Senate chamber today did just that. The body approved a fair, common sense process to guide the beginning of a presidential impeachment trial. Today, 2 decades later, this Senate will retake that entrance exam. The basic structure we're proposing is just as eminently fair and even-handed as it was back then. The question is whether senators are themselves ready to be as fair and as even-handed. The Senate made a statement 21 years ago. We said that presidents of either party deserve basic justice and a fair process. A challenging political moment like today does not make such statements less necessary, but all the more necessary, in fact. So I would say to my colleagues across the aisle, there is no reason why the vote on this resolution ought to be remotely partisan. There's no reason other than base partisanship to say this particular president deserves a radically different rule book than what was good enough for a past president of your own party. So I would urge every single senator to support our fair resolution. I urge everyone to vote to uphold the Senate's unanimous bipartisan precedent of a fair process.
President.
Democratic leader.
Now, before I begin, there has been well-founded concern that the additional security measures required for access to the galleries during the trial could cause reporters to miss some of the events on the Senate floor. I want to assure everyone in the press that I will vociferously oppose any attempt to begin the trial unless the reporters trying to enter the gallery are seated. The press is here to inform the American public about these pivotal events in our nation's history. We must make sure they are able to. Some may not want what happens here to be public. We do. Now, Mr. President, after the conclusion of my remarks, the Senate will proceed to the impeachment trial of President Donald John Trump for committing high crimes and misdemeanors. President Trump is accused of coercing a foreign leader into interfering in our elections to benefit himself and then doing everything in his power to cover it up. If proved, the president's actions are crimes against democracy itself. It's hard to imagine a greater subversion of our democracy than for powers outside our borders to determine the elections from within. For a foreign country to attempt such a thing on its own is bad enough. For an American president to deliberately solicit such a thing, to blackmail a foreign country with military assistance to help him win an election, is unimaginably worse. I can't imagine any other president doing this. Beyond that, for then the president to deny the right of Congress to conduct oversight, deny the right to investigate any of his activities, to say Article 2 of the Constitution gives him the right to, quote, do whatever he wants. We are staring down an erosion of the sacred democratic principles for which our founders fought a bloody war of independence. Such is the gravity of this historic moment. Now, once Senator Inhofe is sworn in at 1 p.m., the ceremonial functions at the beginning of a presidential trial will be complete. The Senate then must determine the rules of the trial. The Republican leader will offer an organizing resolution that outlines his plan for the rules of the trial. It is completely partisan. It was kept secret until the very eve of the trial. And now that it's public, it's very easy to see why. The McConnell rules seem to be designed by President Trump for President Trump. It asks the Senate to rush through as fast as possible and makes getting evidence as hard as possible. He could force presentations to take place at 2 or 3 in the morning so the American people won't see them. In short, the McConnell resolution will result in a rushed trial with little evidence in the dark of night. Literally, the dark of night. If the president is so confident in his case, if Leader McConnell is so confident the president did nothing wrong, why don't they want the case to be presented in broad daylight? On something as important as impeachment, the McConnell resolution is nothing short of a national disgrace. This will go down, this resolution, as one of the darker moments in the Senate history, perhaps one of even the darkest. Now, Leader McConnell has just said he wants to go by the Clinton rules. Then why did he change them in 4 important ways at minimum to all make the trial less transparent, less clear, and with less evidence? He said he wanted to get started in exactly the same way. It turns out, contrary to what the leader said, I'm amazed he could say it with a straight face, that the rules are the same as the Clinton rules. The rules are not even close to the Clinton rules. Unlike the Clinton rules, the McConnell resolution does not admit the record of the House impeachment proceedings into evidence. So Leader McConnell wants a trial with no existing evidence and no new evidence. A trial without evidence is not a trial. It's a cover-up. Second, unlike the Clinton rules, the McConnell resolution limits presentation by the parties to 24 hours per side over only 2 days. We start at 1, 12 hours a day, we're at 1 a.m., and that's without breaks. It'll be later. Leader McConnell wants to force the managers to make important parts of their case in the dark of night. Number 3, unlike the Clinton rules, the McConnell resolution places an additional hurdle to get witnesses and documents by requiring a vote on whether such motions are even in order. If that vote fails, then no motions to subpoena witnesses and documents will be in order. I don't want anyone on the other side to say, I'm going to vote no first on witnesses, but then later I'll determine it. If they vote for McConnell's resolution, they're making it far more difficult to vote in the future, later on in the trial. And finally, unlike the Clinton rules, the McConnell resolution allows a motion to dismiss at any time in the trial. So in short, contrary to what the leader has said, the McConnell rules are not at all like the Clinton rules. The Republican leader's resolution is based neither in precedent nor in principle. It is driven by partisanship and the politics of the moment. Today, I'll be offering amendments to fix the many flaws in Leader McConnell's deeply unfair resolution and seek the witnesses and documents we've requested, beginning with an amendment to have the Senate subpoena White House documents. Let me be clear, these amendments are not dilatory. They only seek one thing, the truth. That means relevant documents. That means relevant witnesses. That's the only way to get a fair trial, and everyone in this body knows it. Each Senate impeachment trial in our history, all 15 that were brought to completion, feature witnesses. Every single one. The witnesses we request are not Democrats. They're the president's own men. The documents are not Democratic documents. They're documents, period. We don't know if the evidence of the witnesses or the documents will be exculpatory to the president or incriminating. But we have an obligation, a solemn obligation, particularly now during this most deep and solemn part of our Constitution, to seek the truth and then let the chips fall where they may. My Republican colleagues have offered several explanations for opposing witnesses and documents at the start of the trial. None of them has much merit. Republicans have said we should deal with the question of witnesses later in the trial. Of course, it makes no sense to hear both sides present their case first and then afterward decide if the Senate should hear evidence. The evidence is supposed to inform arguments, not come after they're completed. Some Republicans have said the Senate should not go beyond the House record by calling any witnesses. But the Constitution gives the Senate the sole power to try impeachments, not the sole power to review, not the sole power to rehash, but to try. Republicans have called our request for witnesses and documents political. If seeking the truth is political, then the Republican Party is in serious trouble. The White House has said that the articles of impeachment are brazen and wrong. Well, if the president believes his impeachment is so brazen and wrong, why won't he show us why? Why is the president so insistent that no one come forward, that no documents be released? If the president's case is so weak that none of the president's men can defend him under oath, shame on him and those who allow it to happen. What is the president hiding? What are our Republican colleagues hiding? Because if they weren't afraid of the truth, they'd say, go right ahead, get at the truth, get witnesses, get documents. In fact, no point over the last few months have I heard a single solitary argument on the merits of why witnesses and documents should not be part of the trial. No Republican has explained why less evidence is better than more evidence. Nevertheless, Leader McConnell is poised to ask the Senate to begin the first impeachment trial of a president in history without witnesses, that rushes through the arguments as quickly as possible, that in ways both shameless and subtle will conceal the truth from the American people. Leader McConnell claimed that the House ran the most rushed, least thorough, and most unfair impeachment inquiry in modern history. The truth is, Leader McConnell is plotting the most rushed, least thorough, and most unfair impeachment trial in modern history. And it begins today. The Senate has before it a very straightforward question. The president is accused of coercing a foreign power to interfere in our elections to help himself. It's the job of the Senate to determine if these very serious charges are true. The very least we can do is examine the facts, review the documents, hear the witnesses, try the case. Not run from it, not hide it, try it. Because if the president commits high crimes and misdemeanors, and Congress refuses to act, refuses even to conduct a fair trial of his conduct, then presidents, this president and future presidents, can commit impeachable crimes with impunity, and the order and rigor of our democracy will dramatically decline. The fail-safe, the final fail-safe of our democracy will be rendered moot. The most powerful check on the executive, the one designed to protect the people from tyranny, will be erased. In short time, my colleagues, each of us will face a choice about whether to begin this trial in search of the truth or in service of the president's desire to cover it up. Whether the Senate will conduct a fair trial and a full airing of the facts, or a rush to a predetermined political outcome. My colleagues, the eyes of the nation, the eyes of history, the eyes of the Founding Fathers are upon us. History will be our final judge. Will senators rise to the occasion? I yield the floor.
Under the previous order, the leadership time is reserved. Morning business is closed. Under the previous order, the Senate stands in recess, subject to the call of the chair.
The Senate will convene as a court of impeachment. If there is no objection, the journal of proceedings of the trial are approved to date. I'm aware of one senator present who was unable to take the impeachment oath last Thursday. Will he please raise his right hand and be sworn? Do you solemnly swear that in all things appertaining to the trial of the impeachment of Donald John Trump, President of the United States, now pending, you will do impartial justice according to the Constitution and laws, so help you God?
I do.
The Secretary will note the name of the senator who has just taken the oath and will present the oath book to him for signature. The Sergeant at Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The Majority Leader is recognized.
I'd like to state that for the information of all senators, the trial briefs filed yesterday by the parties have been printed and are now at each senator's desk.
The following documents will be submitted to the Senate for printing in the Senate Journal: the precept issued January 16, 2020, the writ of summons issued on January 16, 2020, and the receipt of summons dated January 16, 2020. The following documents, which were received by the Secretary of the Senate, will be submitted to the Senate for printing in the Senate Journal pursuant to the order of January 16, 2020. The answer of Donald John Trump, President of the United States, to the articles of impeachment exhibited by the House of Representatives against him on January 16, 2020, received by the Secretary of the Senate on January 18, 2020. The trial brief filed by the House of Representatives received by the Secretary of the Senate on January 18, 2020. The trial brief filed by the President received by the Secretary of the Senate on January 20, 2020. The replication of the House of Representatives received by the Secretary of the Senate on January 20, 2020. And the rebuttal brief filed by the House of Representatives received by the Secretary of the Senate on January 21, 2020. Without objection, the foregoing documents will be printed in the Congressional Record. I note the presence in the House of the Senate, in the Senate chamber, of the managers on the part of the House of Representatives and counsel for the President of the United States.
Mr. Chief Justice,
The Majority Leader is recognized.
I send to the desk a list of floor privileges for closed sessions. It's been agreed to by both sides. I ask that it be inserted in the record and agreed to by unanimous consent.
Without objection,
For the further information of all senators, I'm about to send a resolution to the desk providing for an outline of the next steps in these proceedings. It will be debatable by parties for 2 hours, equally divided. Senator Schumer will then send an amendment to the resolution to the desk. Once that amendment has been offered and reported, we'll have a brief recess. When we reconvene, Senator Schumer's amendment will be debatable by the parties for 2 hours. Upon the use or yielding back of time, I intend to move to table Senator Schumer's amendment. And so, Mr. Chief Justice, I send a resolution to the desk and ask that it be read.
the clerk will read the resolution.
Senate Resolution 483 to provide for related procedures concerning the articles of impeachment against Donald John Trump, President of the United States. Resolved that the House of Representatives shall file its record with the Secretary of the Senate, which will consist of those publicly available materials that have been submitted to or produced by the House Judiciary Committee, including transcripts of public hearings or markups in any materials printed by the House of Representatives or the House Judiciary Committee pursuant to House Resolution 660. Materials in this record will be admitted into evidence subject to any hearsay, evidentiary, or other objections that the President may make after opening presentations are concluded. All materials filed pursuant to this paragraph shall be printed and made available to all parties. The President and the House of Representatives shall have until 9 a.m. on Wednesday, January 22nd, 2020, to file any motions permitted under the rules of impeachment, with the exception of motions to subpoena witnesses or documents or any other evidentiary motions. Responses to any such motions shall be filed no later than 11 a.m. on Wednesday, January 22nd, 2020. All materials filed pursuant to this paragraph shall be filed with the Secretary and be printed and made available to all parties. Arguments on such motions shall begin at 1 p.m. on Wednesday, January 22nd, 2020, and each side may determine the number of persons to make its presentation, following which the Senate shall deliberate, if so ordered, under the impeachment rules, and vote on any such motions. Following the disposition of such motions, or if no motions are made, then the House of Representatives shall make its presentation in support of the articles of impeachment for a period of time not to exceed 24 hours over up to 3 session days. Following the House of Representatives' presentation, the President shall make his presentation for a period not to exceed 24 hours over up to 3 session days. Each side may determine the number of persons to make its presentation. Upon the conclusion of the President's presentation, senators may question the parties for a period of time not to exceed 16 hours. Upon the conclusion of questioning by the Senate, there shall be 4 hours of argument by the parties, equally divided, followed by deliberation by the Senate, if so ordered under the impeachment rules, on the question of whether it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. The Senate, without any intervening action, motion, or amendment, shall then decide by the yeas and nays whether it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. Following the disposition of that question, other motions provided under the impeachment rules shall be in order. If the Senate agrees to allow either the House of Representatives or the President to subpoena witnesses, the witnesses shall first be deposed, and the Senate shall decide after deposition which witnesses shall testify pursuant to the impeachment rules. No testimony shall be admissible in the Senate unless the parties have had an opportunity to depose such witnesses. At the conclusion of deliberations by the Senate shall vote on each article of impeachment.
The resolution is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent of this motion?
Managers are in opposition to this resolution.
Thank you. Mr. Cipollone, are you a proponent or opponent of the motion?
Mr. Chief Justice, we are a proponent of the motion.
Then, Mr. Cipollone, your side may proceed first, and we'll be able to reserve rebuttal time if you wish.
Thank you, Mr. Chief Justice. Majority Leader McConnell, Democratic Leader Schumer, Senators. My name is Pat Cipollone. I am here as counsel to the President of the United States. Our team is proud to be here representing President Trump. We support this resolution. It is a fair way to proceed with this trial. It is modeled on the Clinton resolution, which had 100 senators supporting it the last time this body considered an impeachment. It requires the House managers to stand up and make their opening statement and make their case. They have delayed bringing this impeachment to this House for 33 days to this body. And it's time to start with this trial. It's a fair process. They will have the opportunity to stand up and make their opening statement. They will get 24 hours to do that. Then the President's attorneys will have a chance to respond. After that, all of you will have 16 hours to ask whatever questions you have of either side. Once that's finished and you have all of that information, we will proceed to the question of witnesses and some of the more difficult questions that will come before this body. We are in favor of this. We believe that once you hear those initial presentations, the only conclusion will be that the President has done absolutely nothing wrong, and that these articles of impeachment do not begin to approach the standard required by the Constitution, and in fact, they themselves will establish nothing beyond those articles. You look at those articles alone and you will determine that there is absolutely no case. So we respectfully ask you to adopt this resolution so that we can begin with this process. It is long past time to start this proceeding, and we are here today to do it. And we hope that the House managers will agree with us and begin this proceeding today. We reserve the remainder of our time for rebuttal.
Mr. Chief Justice, Senators, and Counsel for the President, the House managers, on behalf of the House of Representatives, rise in opposition to Leader McConnell's resolution. Let me begin by summarizing why. Last week, we came before you to present the articles of impeachment against the President of the United States for only the third time in our history. Those articles charge President Donald John Trump with abuse of power and obstruction of Congress. The misconduct set out in those articles is the most serious ever charged against a president. The first article, abuse of power, charges the president with soliciting a foreign power to help him cheat in the next election. Moreover, it alleges, and we will prove, that he sought to coerce Ukraine into helping him cheat by withholding official acts, two official acts: a meeting that the new president of Ukraine desperately sought with President Trump at the White House to show the world, and the Russians in particular, that the Ukrainian president had a good relationship with his most important patron, the President of the United States. And even more perniciously, President Trump illegally withheld almost $400 million in taxpayer-funded military assistance to Ukraine, a nation at war with our Russian adversary, to compel Ukraine to help him cheat in the election. Astonishingly, the President's trial brief filed yesterday contends that even if this conduct is proved, that there is nothing that the House or this Senate may do about it. It is the President's apparent belief that under Article 2 he can do anything he wants, no matter how corrupt, outfitted in gaudy legal clothing. And yet, when the founders wrote the impeachment clause, they had precisely this type of misconduct in mind. Conduct that abuses the power of his office for personal benefit, that undermines our national security, that invites foreign interference in our democratic process of an election. It is the trifecta of constitutional misconduct justifying impeachment. In Article 2, the President is charged with other misconduct that would likewise have alarmed the founders: the full, complete, and absolute obstruction of a co-equal branch of government, the Congress, during the course of its impeachment investigation into the President's own misconduct. This is every bit as destructive of our constitutional order as the misconduct charged in the first article. If a president can obstruct his own investigation, if he can effectively nullify a power the Constitution gives solely to Congress, indeed the ultimate power the Constitution gives to prevent presidential misconduct, then the president places himself beyond accountability, above the law, cannot be indicted, cannot be impeached. It makes him a monarch, the very evil against which our Constitution and the balance of powers it carefully laid out was designed to guard against.
Shortly, the trial on these charges will begin, and when it has concluded, you'll be asked to make several determinations. Did the House prove that the President abused his power by seeking to coerce a foreign nation to help him cheat in the next election? And did he obstruct the Congress in its investigation into his own misconduct by ordering his agencies and officers to refuse to cooperate in any way, to refuse to testify, to refuse to answer subpoenas for documents, and through every other means? And if the House has proved its case, and we believe the evidence will not be seriously contested, you will have to answer at least one other critical question. Does the commission of these high crimes and misdemeanors require the conviction and removal of the President? We believe that it does, and that the Constitution requires that it be so, or the power of impeachment must be deemed a relic or a casualty to partisan times, and the American people left unprotected against a president who would abuse his power for the very purpose of corrupting the only other method of accountability, our elections themselves. And so you will vote to find the president guilty or not guilty, to find his conduct impeachable or not impeachable. But I would submit to you, these are not the most important decisions you will make. How can that be? How can any decision you will make be more important than guilt or innocence, than removing the president or not removing the president? I believe the most important decision in this case is the one you will make today. The most important question is the question you must answer today. Will the president and the American people get a fair trial? Will there be a fair trial? I submit that this is an even more important question than how you vote on guilt or innocence, because whether we have a fair trial will determine whether you have a basis to render a fair and impartial verdict. It is foundational, the structure upon which every other decision you will make must rest. If you only get to see part of the evidence, if you only allow one side or the other a chance to present their full case, your verdict will be predetermined by the bias in the proceeding. If the defendant is not allowed to introduce evidence of his innocence, it's not a fair trial. So too for the prosecution. If the House cannot call witnesses or introduce documents and evidence, it's not a fair trial. It's not really a trial at all. Americans all over the country are watching us right now. And imagine they're on grand jury or they're on jury duty. Imagine that the judge walks into that courtroom and says that she's been talking to the defendant. And at the defendant's request, the judge has agreed not to let the prosecution call any witnesses or introduce any documents. The judge and the defendant have agreed that the prosecutor may only read to the jury the dry transcripts of the grand jury proceedings. That's it. Has anyone on jury duty in this country ever heard a judge describe such a proceeding and call it a fair trial? Of course not. That's not a fair trial. It's a mockery of a trial. Under the Constitution, this proceeding, the one we are in right now, is the trial. This is not the appeal from a trial. You are not appellate court judges. Okay, one of you is. And unless this trial is going to be different from every other impeachment trial or any other kind of trial for that matter, you must allow the prosecution and defense, the House manager and the president's lawyers, to call relevant witnesses. You must subpoena documents that the president has blocked, but which bear on his guilt or innocence. You must impartially do justice as your oath requires. So what does a fair trial look like in the context of impeachment? The short answer is it looks like every other trial. First, the resolution should allow the House managers to obtain documents that have been withheld. First, not last, because the documents will inform the decision about which witnesses are most important to call. And when the witnesses are called, the documentary evidence will be available and must be available to question them with. Any other order makes no sense. Next, the resolution should allow the House managers to call their witnesses, and then the President should be allowed to do the same and any rebuttal witnesses. And when the evidentiary portion of the trial ends, the parties argue the case. You deliberate and render a verdict. If there's a dispute as to whether a particular witness is relevant or material to the charges brought, under the Senate rules, the Chief Justice would rule on the issue of materiality. Why should this trial be different than any other trial? The short answer is it shouldn't. But Leader McConnell's resolution would turn the trial process on its head. His resolution requires the House to prove its case without witnesses, without documents, and only after it's done will such questions be entertained, with no guarantee that any witnesses or any documents will be allowed even then. That process makes no sense. So what is the harm of waiting until the end of the trial, of kicking the can down the road on the question of documents and witnesses? Besides the fact it's completely backwards, trial first, then evidence, besides the fact that the documents would inform the decision on which witnesses and help in their questioning, the harm is this. You will not have any of the evidence the President continues to conceal throughout most or all of the trial. And although the evidence against the President is already overwhelming, you may never know the full scope of the President's misconduct or those around him. And neither will the American people. The charges here involve the sacrifice of our national security at home and abroad, and a threat to the integrity of the next election. If there are additional remedial steps that need to be taken after the President's conviction, the American people must know about it. But if, as a public already jaded by experience has come to suspect, this resolution is merely the first step of an effort orchestrated by the White House to rush the trial, hide the evidence, and render a fast verdict, or worse, a fast dismissal, to make the President go away as quickly as possible to cover up his misdeeds, then the American people will be deprived of a fair trial and may never learn just how deep the corruption of this administration goes, or what other risks to our security and elections remain hidden. The harm will also endure for this body. If the Senate allows the President to get away with such extensive obstruction, it will affect the Senate's power of subpoena and oversight just as much as the House. The Senate's ability to conduct oversight will be beholden to the desires of this President and future presidents, whether he or she decides they want to cooperate with a Senate investigation or another impeachment inquiry and trial. Our system of checks and balances will be broken. Presidents will become accountable to no one. Now, it has been reported that Leader McConnell has already got the votes to pass this resolution, the text of which we did not see until last night and which has been changed even moments ago. And they say that Leader McConnell is a very good vote counter. Nonetheless, I hope that he's wrong. And not just because I think this process, the process contemplated by this resolution, is backwards and designed with the result in mind, and that the result is not a fair trial. I hope that he's wrong because whatever senators may have said or pledged or committed has been superseded by an event of constitutional dimension. You have all now sworn an oath. Not to each other, not to your legislative leadership, not to the managers or even to the Chief Justice. You have sworn an oath to do impartial justice. That oath binds you. That oath supersedes all else. Many of you in the Senate and many of us in the House have made statements about the President's conduct, or this trial, or this motion, or expectations. None of that matters now. That is all in the past. Nothing matters now but the oath to do impartial justice. And that oath requires a fair trial, fair to the President and fair to the American people. But is that really possible? Or as the founders feared, has factionalism, or an excessive partisanship made that now impossible. One way to find out what a fair trial should look like, devoid of partisan consideration, is to ask yourselves, how would you structure the trial if you didn't know what your party was? And you didn't know what the party of the president was? Would it make sense to you to have the trial first and then decide on witnesses and evidence later? Would that be fair to both sides? I have to think that your answer would be no. Let me be blunt. Let me be very blunt. Right now, a great many, perhaps even most Americans, do not believe there will be a fair trial. They don't believe that the Senate will be impartial. They believe that the result is pre-cooked. The president will be acquitted. Not because he is innocent, he is not, but because the senators will vote by party and he has the votes. The votes to prevent the evidence from coming out, the votes to make sure the public never sees it. The American people want a fair trial. They want to believe their system of government is still capable of rising to the occasion. They want to believe that we can rise above party and do what's best for the country, but a great many Americans don't believe that will happen. Let's prove them wrong. Let's prove them wrong. How? By convicting the president? No, not by conviction alone. By convicting him if the House proves its case, and only if the House proves its case. But by letting the House prove its case, by letting the House call witnesses, by letting the House obtain documents, by letting the House decide how to present its own case, and not deciding it for us. In sum, by agreeing to a fair trial. Now let's turn to the precise terms of the resolution, the history of impeachment trials, and what fairness and impartiality require. Although we have many concerns about the resolution, I will begin with its single biggest flaw. The resolution does not ensure that subpoenas will, in fact, be issued for additional evidence that the Senate and the American people should have, and that the President continues to block to fairly decide the President's guilt or innocence. Moreover, it guarantees that subpoenas will not be issued now, when they would be most valuable to the Senate, the parties, and the American people. According to the resolution the leader has introduced, first, the Senate receives briefs and filings from the parties. Next, it hears lengthy presentations from the House and the President. Now, my colleagues, the President's lawyers, have described this as opening statements. But let's not kid ourselves. That is the trial that they contemplate. The opening statements are the trial. They'll either be most of the trial or they'll be all the trial. If the Senate votes to deprive itself of witnesses and documents, the opening statements will be the end of the trial. So to say, let's just have the opening statements and then we'll see, means let's have the trial. And maybe we can just sweep this all under the rug. So you'll hear these lengthy presentations from the House. There will be a question and answer period for the senators, and then and only then, after essentially the trial is over, after the briefs have been filed, after the arguments have been made, after the senators exhaust all their questions, only then will the Senate consider whether to subpoena crucial documents and witness testimony that the President has desperately tried to conceal from this Congress and the American people. Documents and witness testimony that, unlike the Clinton trial, have not yet been seen or heard. It is true that the record compiled by the House is overwhelming. It is true the record already compels the conviction of the President. In the face of unprecedented resistance by the President, the House assembled a powerful case, evidence of the President's high crimes and misdemeanors that includes direct evidence and testimony of officials who were unwilling and unwitting in this scheme and saw it for what it was. Yet there is still more evidence, relative and probative evidence, that the President continues to block, that would flesh out the full extent of the President's misconduct and those around him. We have seen that over the past few weeks, new evidence has continued to come to light, as the Nonpartisan Government Accountability Office has determined that the hold on military to Ukraine was illegal and broke the law, as John Bolton has offered to testify in the trial, as one of the President's agents, Lev Parnas, has produced documentary evidence that clarifies Mr. Giuliani's activities on behalf of the President and corroborates Ambassador Sondland's testimony that everyone was in the loop, as documents released under the Freedom of Information Act have documented the alarm at the Department of Defense while the President illegally withheld military support for Ukraine, an ally at war with Russia, without explanation. As a senior Office of Management and Budget official, Michael Duffy instructed Defense Department officials on July 25th, 90 minutes after President Trump spoke by phone with President Zelensky, the Defense Department should pause all obligation of Ukraine military assistance under its purview. 90 minutes after that call. Duffy added, quote, "Given the sensitive nature of the request, I appreciate your keeping that information closely held to those who need to know to execute the direction." Although the evidence is already more than sufficient to convict, there is simply no rational basis for the Senate to deprive itself of all relevant information in making such a hugely consequential judgment. Moreover, as the President's answer to his summons and his trial brief make clear, the President now attempts to contest the facts, albeit in false and misleading ways. But the President should not have it both ways. He should not be permitted to claim that the facts uncovered by the House are wrong, while also concealing mountains of evidence that bear precisely on those facts. If this body seeks impartial justice, it should ensure that subpoenas are issued and that they are issued now, before the Senate begins extended proceedings based on a record that every person in this room and every American watching at home knows does not include documents and witness testimony. It should, because the President would not allow it to be so. Complying with these subpoenas would not impose a burden. The subpoenas cover narrowly tailored and targeted documents and witnesses that the President has concealed. The Senate deserves to see the documents from the White House, the State Department, the Office of Management and Budget, the Department of Defense. These agencies already should have collected and at least preserved these documents in response to House subpoenas. Indeed, in some cases, agencies have already produced documents in FOIA lawsuits, albeit in heavily redacted form. And witnesses with direct knowledge or involvement should be heard. That includes the President's acting Chief of Staff, Mick Mulvaney, his former National Security Advisor, John Bolton, who has publicly offered to testify, two senior officials integral to implementing the President's freeze on Ukraine's military aid also have very relevant testimony. Why not hear it? Robert Blair, who serves as Mulvaney's senior advisor, Michael Duffy, a senior official at OMB, and other witnesses with direct knowledge that we reserve the right to call later, but these witnesses with whom we wish to begin the trial. Last month, President Trump made clear that he supported having senior officials testify before the Senate during his trial, declaring that he would love to have Secretary Pompeo, Mr. Mulvaney, now former Secretary Perry, and, quote, many other people testify in the Senate trial.
So, when it's fair, if it was fair in the Senate, I would love to have Mike Pompeo, I'd love to have Mick, I'd love to have Rick Perry, and many other people testify.
The Senate has an opportunity to take the President up on his offer to make his senior aides available, including Mr. Mulvaney and Secretaries Perry and Pompeo. But now the President is changing his tune. The bluster of wanting these witnesses to testify is over, notwithstanding the fact that he has never asserted a claim of privilege during the course of the House impeachment proceedings. He threatens to invoke one now in a last-ditch effort to keep the rest of the truth from coming out. The President sends his lawyers here to breathlessly claim that these witnesses or others cannot possibly testify because it involves national security. Never mind that it was the president's actions in withholding military aid from an ally at war that threatened our national security in the first place. Never mind that the most impeachable, serious offenses will always involve national security because they will involve other nations, and that misconduct based on foreign entanglement was what the framers feared most. The president's absurdist argument amounts to this: we must endanger national security to protect national security. We must make a president's conduct threatening our security beyond the reach of impeachment power if we are to save the presidency. This is dangerous nonsense. As justices of the Supreme Court have underscored, the Constitution is not a suicide pact. But let us turn from the abstract to the very concrete, and let me show you just one example of what the president is hiding in the name of national security. There is a document which the president has refused to turn over, in which his top diplomat in Ukraine says to two other appointees of the president, "As I said on the phone, I think it's crazy to withhold security assistance for help with a political campaign." The administration refuses to turn over that document and so many more. We only know about its existence. We have only seen its contents because it was turned over by a cooperating witness. This is what the president would hide from you and from the American people. In the name of national security, he would hide graphic evidence of his dangerous misconduct. The only question is, and it is the question raised by this resolution, will you let him? Last year, President Trump said that Article 2 of the Constitution will allow him to do anything he wanted. And evidently believing that Article 2 empowered him to denigrate and defy a co-equal branch of government, he also declared that he will fight all subpoenas. Let's hear the president's own words.
Then I have an Article 2 where I have the right to do whatever I want as president. But we're fighting all the subpoenas.
True to his pledge to obstruct Congress, when President Trump faced an impeachment inquiry in the House of Representatives, he ordered the executive branch to defy every single request on every single subpoena. He issued this order through his White House counsel, Pat Cipollone, on October 8, the same counsel that stood before you a moment ago to defend the president's misconduct. He then affirmed it again at a rally on October 10. Following President Trump's categorical order, we never received key documents and communications. It is important to note, in refusing to respond to Congress, the president did not make any formal claim of privilege ever. Instead, Mr. Cipollone's letter stated, in effect, that the president would withhold all evidence in the executive branch unless the House surrendered to demands that would effectively place President Trump in charge of the inquiry into his own misconduct. Needless to say, that was a non-starter and designed to be so. The president was determined to obstruct Congress no matter what we did. And his conduct since, his attacks on the impeachment inquiry, his attacks on witnesses, have affirmed that the president never had any intention to cooperate under any circumstance. And why? Because the evidence and testimony he conceals would only further prove his guilt. The innocent do not act this way. Simply stated, this trial should not reward the president's obstruction by allowing him to control what evidence is seen and when it is seen and what evidence will remain hidden. The documents the president seeks to conceal include White House records, including records about the president's unlawful hold on military aid, State Department records, including text messages and WhatsApp messages exchanged by the State Department and Ukrainian officials, and notes to file written by career professionals as they saw the president's scheme unfold in real time. OMB records demonstrating efforts to fabricate an after-the-fact rationale for the president's orders and showing internal objections that the president's orders violated the law. Defense Department records reflecting bafflement and alarm that the president suspended military aid to a key security partner without explanation. Many of the president's aides have also followed his orders and refused to testify. These include central figures in the impeachment inquiry, including White House Chief of Staff Mick Mulvaney, former National Security Advisor John Bolton, and many others with relevant testimony, like Robert Blair and Michael Duffy. Mr. Blair, who serves as a senior advisor to Acting Chief of Staff Mulvaney, worked directly with Mr. Duffy, a political appointee in the Office of Management and Budget, to carry out the president's order to freeze vital military and security assistance to Ukraine. The Trump administration has refused to disclose their communications, even though we know from written testimony, public reporting, and even Freedom of Information Act lawsuits that they were instrumental in implementing the hold and extending it at the president's express direction, even as career officials warned accurately that doing so would violate the law. The president has also made the insupportable claim that the House should have enforced its subpoenas in court and allowed the president to delay his impeachment for years. If we had done so, we would have abdicated our constitutional duty to act on the overwhelming facts before us and the evidence the president was seeking to cheat in the next election. We could not engage in a deliberately protracted court process while the president continued to threaten the sanctity of our elections. Resorting to the courts is also inconsistent with a constitution that gives the House the sole power of impeachment. If the House were compelled to exhaust all legal remedies before impeaching the president, it would interpose the courts or the decision of a single judge between the House and the power to impeach. Moreover, it would invite the president to prevent his own impeachment by endlessly litigating the matter in court, appealing every judgment, engaging in every frivolous motion or device. Indeed, in the case of Don McGahn, the president's lawyer who was ordered to fire the special counsel and lie about it, he was subpoenaed by the House in April last year, and there is still no final judgment. A president may not defeat impeachment or accountability by engaging in endless litigation. Instead, it's been the long practice of the House to compile core evidence necessary to reach a reasoned decision about whether to impeach, and then to bring the case here to the Senate for a full trial. That is exactly what we did here, with an understanding that the Senate has its own power to compel documents and testimony. It would be one thing if the House had shown no interest in documents or witnesses during its investigation, although even there, the House has the sole right to determine its proceedings, as long as it makes the full case to the House, as it did. But it is quite another when the president is the cause of his own complaint, when the president withholds witnesses and documents and then attempts to rely on his own noncompliance to justify further concealment. President Trump made it crystal clear we would never see a single document or a single witness when he declared, as we just watched, that he would fight all subpoenas. As a matter of history and precedent, it would be wrong to assert that the Senate is unable to obtain and review new evidence during a Senate trial, regardless of why evidence was not produced in the House. You can and should insist on receiving all of the evidence so you can render impartial justice and can earn the confidence of the public in the Senate's willingness to hold a fair trial. Under the Constitution, the Senate does not just vote on impeachments. It does not just debate them. Instead, it is commanded by the Constitution to try all cases of impeachment. If the founders intended for the House to try the matter and the Senate to consider an appeal based on the cold record from the other chamber, they would have said so. But they did not. Instead, they gave us the power to charge and you the power to try all impeachments. The framers chose their language and the structure for a reason. As Alexander Hamilton said, the Senate is given awful discretion in matters of impeachment. The Constitution thus speaks to senators in their judicial character as a court for the trial of impeachments. It requires them to aim at real demonstrations of innocence or guilt, and it requires them to do so by holding a trial. The Senate has repeatedly subpoenaed and received new documents, often many of them while adjudicating cases of impeachment. Moreover, the Senate has heard witness testimony in every one of the 15 Senate trials, full Senate trials in the history of this republic, including those for Presidents Andrew Johnson and Bill Clinton. Indeed, in President Andrew Johnson's Senate impeachment trial, the House managers were permitted to begin presenting documentary evidence to the Senate on the very first day of the trial. The House managers' initial presentation of documents in President Johnson's case carried on for the first 2 days of trial, immediately after which witnesses were called to appear in the Senate. This has been the standard practice in prior impeachment trials. Indeed, in most trials, this body has heard from many witnesses, ranging from 3 in President Clinton's case to 40 in President Johnson's, and well over 60 in other impeachments. As these numbers make clear, the Senate has always heard from key witnesses when trying an impeachment. The notion that only evidence that was taken before the House should be considered is squarely and unequivocally contrary to Senate precedent. Nothing in law or history supports it. To start, consider Leader McConnell's own description of his work in a prior Senate impeachment proceeding. After serving on the Senate Trial Committee in the case of Judge Claiborne, Leader McConnell described how the Senate committee, quote, labored intensively for more than 2 months, amassing the necessary evidence and testimony. In the same essay, Leader McConnell recognized the full body's responsibility for amassing and digesting evidence. There was certainly a lot of evidence for the Senate to amass and digest in that proceeding, which involved charges against a district court judge. The Senate heard testimony from 19 witnesses, and it allowed for over 2,000 pages of documents to be entered into the record over the course of that trial. At no point did the Senate limit evidence to what was before the House. It did the opposite, consistent with unbroken Senate practice in every single impeachment trial, every single one. For example, of the 40 witnesses who testified during President Johnson's Senate trial, only 3 provided testimony to the House during its impeachment inquiry. Only 3. The remaining 37 witnesses in that presidential impeachment trial testified before the Senate. Similarly, the Senate's full first impeachment trial, which involved charges against Judge Pickering, involved testimony from 11 witnesses, all of whom were new to the impeachment proceedings and had not testified before the House. There are many other examples of this point, including the Senate's most recent impeachment trial of Judge Porteous in 2010. It is one that many of you and some of us know well. It, too, is consistent with this long-standing practice. There, the Senate heard testimony from 26 witnesses, 17 of whom had not testified before the House during its impeachment inquiry. Thus, there is a definitive tradition of the Senate hearing from new witnesses when trying articles of impeachment. There has never been a rule limiting witnesses to those who appeared in the House or limiting evidence before the Senate to that which the House itself considered. And that is because, as Senator Hiram Johnson explained in 1934, the integrity of Senate impeachment trials depend heavily upon the witnesses who are called, their appearance on the stand, their mode of giving testimony. There is thus an unbroken history of witness testimony in Senate impeachment trials. Presidential and judicial, I would argue in the case of a president, it is even more important to hear the witnesses and see the documents. Any conceivable doubt on this score, and there should be none left, is dispelled by the Senate's own rules for trial of impeachment. Obtaining documents and hearing live witness testimony is so fundamental that the rules of procedure and practice in the Senate when sitting on impeachment trials, which date back to the 19th century, devote more attention to the gathering, handling, and admission of new evidence than any other single subject. These rules expressly contemplate that the Senate will hear evidence and conduct a thorough trial when sitting as a court of impeachment. At every turn, they reject the notion that the Senate would take the House's evidentiary record, blind itself to everything else, and vote to convict or acquit. For example, Rule 6 says the Senate shall have the power to compel the attendance of witnesses and enforce obedience to its orders. Rule 7 authorizes the presiding officer to rule on all questions of evidence, including but not limited to questions of relevancy, materiality, and redundancy. This Rule 2 presumes that the Senate trial will have testimony, giving rise to such questions. Rule 11 authorizes the full Senate to designate a committee of senators to receive evidence and take testimony at such times and places as the committee may determine. As Rule 11 makes clear, the committee's report must be transmitted to the full Senate for final adjudication. But nothing herein, the rule states, shall prevent the Senate from sending for any witness and hearing his testimony in open Senate or by order of the Senate involving the entire trial in the open Senate. Here, too, the Senate's operative impeachment rules expressly contemplate and provide for subpoenaing witnesses and hearing their testimony as part of the Senate trial. And the list goes on. These rules plainly contemplate a robust role for the Senate in gathering and considering evidence. They reflect centuries of practice of accepting and requiring new evidence in Senate trials. This Senate should honor that practice today by rejecting this resolution. What about the Clinton trial? What about the Clinton trial that will be argued? Even if we are departing from every other impeachment trial in history, including the impeachment of President Andrew Johnson, what about the Clinton trial? Aren't we following the same processes in the Clinton trial? The answer is no. First, the process for the Clinton trial was worked out by mutual consent among the parties. That is not true here, where the process is sought to be imposed by one party on the other. Second, all of the documents in the Clinton trial were turned over prior to the trial. All 90,000 pages of them, so they could be used in the House's case. None of the documents have been turned over by the President in this case. And under Leader McConnell's proposal, none may ever be. They certainly won't be available to you or to us during most or all of the trial. If we are really going to follow the Clinton precedent, the Senate must insist on the documents now, before the trial begins. Third, the issue in the Clinton trial was not one of calling witnesses, but of recalling witnesses. All of the key witnesses in the Clinton trial had testified before the grand jury or been interviewed by the FBI, one of them dozens of times, and their testimony was already known. President Clinton himself testified on camera and under oath before the Senate trial. He allowed multiple chiefs of staff and other key officials to testify, again, before the Senate trial took place. Here, none of the witnesses we seek to call, none of them have testified or been interviewed by the House. And as I said, the President cannot complain that we did not call these witnesses before the House when their unavailability was caused by the President himself. And last, as you will remember, those of you that were here, the testimony in the Clinton trial involved decorum issues that are not present here. You may rest assured, whatever else the case may be, such issues will not be present here. In sum, the Clinton precedent, if you're serious about it, if we're really serious about modeling this proceeding after the Clinton trial, the Clinton precedent is one where all the documents had been provided up front, where all the witnesses had testified up front prior to the trial. That is not being replicated by the McConnell resolution, not in any way, not in any shape, not in any form, far from it. The traditional model followed in President Johnson's case and all of the others is really the one that's most appropriate to the circumstances. The Senate should address all the documentary issues and most of the witnesses now, not later. The need to subpoena documents and testimony now has only increased due to the President's obstruction for several reasons. First, his obstruction has made him uniquely and personally responsible for the absences of the witnesses before the House. Having ordered them not to appear, he may not be heard to complain now that they followed his orders. and refuse to testify. To do otherwise only rewards the president's obstruction and encourages future presidents to defy lawful process in impeachment investigations. Second, if the president wishes to contest the facts and his answer and trial brief indicates that he will try, he must not continue to deny the Senate access to the relevant witnesses and documents that shed light on the very factual matters he wishes to challenge. The Senate trial is not analogous to an appeal where the parties must argue the facts on the basis of the record below. There is no record below. There is no below. This is the trial. Third, the president must not be allowed to mislead the Senate by selectively introducing documents while withholding the vast body of documents that may contradict them. This is very important. The president must not be allowed to mislead you by introducing documents selectively and withholding all of the rest. All of the relevant documents should be produced so there is full disclosure of the truth. Otherwise, there is a clear risk that the president will continue to hide all evidence harmful to his position while selectively producing documents without any context or opportunity to examine their creators. And finally, you may infer the president's guilt from his continuing efforts to obstruct production of documents and witnesses. The president has said he wants witnesses like Mulvaney and Pompeo and others to testify, and that his interactions with Ukraine have been perfect. Counsel has affirmed today that will be the president's defense. His conduct was perfect. It's perfect. Perfectly fine to coerce an ally by withholding military aid to get help cheating in the next election. That will be part of the president's defense, although albeit not worded in that way. But now he has changed course and does not want these witnesses to testify. The logical inference in any court of law would be that the party's continued obstruction of lawful subpoenas may be construed as evidence of guilt. Let me conclude. The facts will come out in the end. The documents which the president is hiding will be released through the Freedom of Information Act or through other means over time. Witnesses will tell their stories in books and film. The truth will come out. The question is, will it come out in time? And what answer shall we give if we did not pursue the truth now and let it remain hidden until it was too late to consider on the profound issue of the president's guilt or innocence? There are many overlapping reasons for voting against this resolution, but they all converge on a single idea: fairness. The trial should be fair to the House, which has been wrongly deprived of evidence by a president who wishes to conceal it. It should be fair to the president, who will not benefit from an acquittal or dismissal if the trial is not viewed as fair, if it is not viewed as impartial. And fair to you senators, who are tasked with the grave responsibility of determining whether to convict or acquit, and should do so with the benefit of all of the facts. And fair to the American people, who deserve the full truth and who deserve representatives who will seek it on their behalf. And with that, Mr. Chief Justice, I yield back.
Mr. Cipollone, Mr. Sekulow, you have 57 minutes available.
Thank you, Mr. Chief Justice, members of the Senate, Leader McConnell, Democratic Leader Schumer. It's also my privilege to represent the President of the United States before this chamber. Senator Schumer said earlier today that the eyes of the founders are on these proceedings. Indeed, that's true. But it is the heart of the Constitution that governs these proceedings. And what we just heard from Manager Schiff, courts have no role, privileges don't apply. What happened in the past, we should just ignore. In fact, Manager Schiff just said try to summarize my colleague's defense of the president. He said, not in those words, of course, which is not the first time Mr. Schiff has put words into transcripts that did not exist. Mr. Schiff also talked about a trifecta. I'll give you a trifecta. During the proceedings that took place before the Judiciary Committee, the president was denied the right to cross-examine witnesses. The president was denied the right to access evidence. And the president was denied the right to have counsel present at hearings. That's a trifecta. A trifecta that violates the Constitution of the United States. Mr. Schiff did say the courts really don't have a role in this. Executive privilege, why would that matter? It matters because it's based on the Constitution of the United States. One manager said that it is you that are on trial, the Senate. He also said that, and others did, that you're not capable of abiding by your oath. And then we had the invocation of the ghost of the Mueller report. I know something about that report. It came up empty on the issue of collusion with Russia. There was no obstruction. In fact, the Mueller report, to the contrary of what these managers say today, came to the exact opposite conclusions of what they say. Let me quote from the House impeachment report at page 16. Although President Trump has in times invoked the notion of due process, an impeachment trial, an impeachment inquiry is not a criminal trial and should not be confused with it. Believe me, what has taken place in these proceedings is not to be confused with due process. Because due process demands, and the Constitution requires, that fundamental fairness and due process, we're hearing a lot about due process is designed to protect the person accused. When the Russia investigation failed, it devolved into the Ukraine. A quid pro quo. When that didn't prove out, it was then bribery or maybe extortion, or somebody said, one of the members or the members of the House said treason. But instead we get two articles of impeachment. Two articles of impeachment that have a vague allegation about a non-crime allegation of abuse of power and obstruction of Congress. Managers, right here, before you today, who have said that executive privilege and constitutional privileges have no place in these proceedings. On June 28, 2012, Attorney General Eric Holder became the first United States Attorney General to be held in both civil and criminal contempt. Why? Because President Obama asserted executive privilege. With respect to the Holder contempt proceedings, Mr. Manager Schiff wrote, the White House assertion of privilege is backed by decades of precedent that has recognized the need for the President and his senior advisors to receive candid advice and information from their top aides. Indeed, that's correct. Not because Manager Schiff said it, but because the Constitution requires it. Mr. Manager Nadler said that the effort to hold Eric Holder, Attorney General Holder, in contempt for refusing to comply with various subpoenas was, quote, politically motivated, and Speaker Pelosi called the Holder matter, and I quote, a little more than a witch hunt. What are we dealing with here? Why are we here? Are we here because of a phone call? Or are we here before this great body because since the President was sworn into office, there was a desire to see him removed? I remember in the Mueller report, there were discussions about, remember, insurance policies. The insurance policy didn't work out so well. So then we moved 2 other investigations. I guess you would call it reinsurance or an umbrella policy. And that didn't work out so well. And here we are today. Manager Schiff quoted the Supreme Court, and I'd like to make reference to the Supreme Court as well. It was then Justice Rehnquist, later to be Chief Justice Rehnquist, who wrote for the majority in United States versus Russell in 1973. These are the words. We may someday be presented with a situation in which the conduct of law enforcement agents is so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction. That day is today. That day was a year ago. That day was in July when Special Counsel Mueller testified. I am not today going to take the time to review, and I will do it later, the pattern and practices of irregularities that have gone on in these investigations from the outset. But to say that the courts have no role, the rush to impeachment, to not wait for a decision from a court on an issue as important as executive privilege, as if executive privilege hasn't been utilized by presidents since our founding. This is not some new concept. We don't waive executive privilege, and there's a reason we keep executive privilege, and we assert it when necessary. And that is to protect the Constitution and the separation of powers. The president's opponents, in their rush to impeach, have refused to wait for complete judicial review. That was their choice. Speaker Pelosi clearly expressed her impatience and contempt for judicial proceedings when she said, "We cannot be at the mercy of the courts." Think about that for a moment. We cannot be at the mercy of the courts. So take Article 3 of the United States Constitution, remove it. We're acting as if the courts are an improper venue to determine constitutional issues of this magnitude? That is why we have courts. That is why we have a federal judiciary. It was interesting when Professor Turley testified before the House Judiciary Committee in front of Mr. Nadler's committee. He said, we have 3 branches of government, not 2. If you impeach a president, if you make a high crime and misdemeanor out of going to courts and abuse of power, it's your abuse of power. You know, it's more than that. A lot more than that. There's a lot more than an abuse of power if you say the courts don't apply. Constitutional principles don't apply. Let's start with a clean slate as if nothing happened. A lot has happened. As we proceed in the days ahead, we will lay out our case. We're going to put forward to the American people, but more important, for the Constitution's sake, what's taken place here. But this idea that we should ignore what has taken place over the last 3 years is outrageous. We believe that what Senator McConnell has put forward provides due process, allows the proceedings to move forward in an orderly fashion. 33 days. 33 days they held on to those impeachment articles. 33 days. It was such a rush of national security to impeach this president before Christmas that they then held him for 33 days. To do what? To act as if they negotiate, the House of Representatives should negotiate the rules of the United States Senate. They didn't hide this. This was the express purpose. This was the reason they did it. We're prepared to proceed. Majority Leader, Democratic Majority Leader, we're prepared to proceed. In our view, these proceedings should begin. I yield the rest of my time to my colleague, the White House counsel. Thank you, Mr. Chief Justice.
Cipollone.
Thank you, Mr. Chief Justice. I just want to make a couple of additional points. It's very difficult to sit there and listen to Mr. Schiff tell the tale that he just told. Let's remember how we all got here. They made false allegations about a telephone call. The President of the United States declassified that telephone call and released it to the public. How's that for transparency? When Mr. Schiff found out that there was nothing to his allegations, he focused on the second telephone call. He made false, and his colleagues made false allegations about that second telephone call that occurred before the one he had demanded. So the President of the United States declassified and released that telephone call. Still nothing. Again, complete transparency in a way that, frankly, I'm unfamiliar with any precedent of any President of the United States releasing a classified telephone call with a foreign leader. When Mr. Schiff saw that his allegations were false, and he knew it anyway, what did he do? He went to the House, and he manufactured a fraudulent version of that call. He manufactured a false version of that call. He read it to the American people, and he didn't tell them it was a complete fake. Do you want to know about due process? I'll tell you about due process. Never before in the history of our country has a president been confronted with this kind of impeachment proceeding in the House. It wasn't conducted by the Judiciary Committee. Now, Mr. Nadler, when he applied for that job, told his colleagues when they took over the House that he was really good at impeachment. But what happened was the proceedings took place in a basement of the House of Representatives. The president was forbidden from attending. The president was not allowed to have a lawyer present. In every other impeachment proceeding, the president has been given a minimal due process. Nothing here. Not even Mr. Schiff's Republican colleagues were allowed into the SCIF. Information was selectively leaked out. Witnesses were threatened. Good public servants were told that they would be held in contempt. They were told that they were obstructing. What does Mr. Schiff mean by obstructing? He means that unless you do exactly what he says, regardless of your constitutional rights, then you're obstructing. The president was not allowed to call witnesses. By the way, there's still evidence in the SCIF that we haven't been allowed to see. I wonder why. No witnesses. Now let's think about something else for a second. Let's think about something else. They held these articles for 33 days. We hear all this talk about an overwhelming case. An overwhelming case that they're not even prepared today to stand up and make an opening argument about. That's because they have no case. Frankly, they have no charge. When you look at these articles of impeachment, they're not only ridiculous, they are dangerous to our republic. And why? First of all, the notion that invoking your constitutional rights to protect the executive branch, that's been done by just about every president since George Washington, that is obstruction. That is our patriotic duty, Mr. Schiff, particularly when confronted with a wholesale trampling of constitutional rights that I'm unfamiliar with in this country. Frankly, it's the kind of thing that our State Department would criticize if we see it in foreign countries. We've never seen anything like it. And Mr. Schiff said, have I got a deal for you? Abandon all your constitutional rights. Forget about your lawyers and come in and do exactly what I say. No, thank you. No, thank you. And then he says he has the temerity to come into the Senate and say, we have no use for courts. It's outrageous. Now, let me tell you another story. There's a man named Charlie Kupperman. He is the Deputy National Security Advisor. He is the number 2 to John Bolton. Because you have to remember, Mr. Schiff wants you to forget, but you have to remember how we got here. They threatened him. They sent him a subpoena. Mr. Kupperman did what any American should be allowed to do, used to be allowed to do. He was forced to get a lawyer. He was forced to pay for that lawyer. And he went to court. Mr. Schiff doesn't like courts. He went to court. And he said, Judge, tell me what to do. I have obligations that frankly rise to what the Supreme Court has called the apex of executive privilege in the area of national security. And then I have a subpoena from Mr. Schiff. What do I do? You know what Mr. Schiff did? Mr. Kupperman went to the judge, and the House said, never mind, we withdraw the subpoena. We promise not to issue it again. And then they come here and they ask you to do the work that they refuse to do for themselves. They ask you to trample on executive privilege. Now, would they ever suggest that the executive could determine on its own what the speech or debate clause means? Of course not. Would they ever suggest that the House could invade the discussions that the Supreme Court has behind closed doors? I hope not. But they come here and they ask you to do what they refuse to do for themselves. They had a court date. And they withdrew the subpoena, they evaded a decision, and they're asking you to become complicit in that evasion of the courts. It's ridiculous. And we should call it out for what it is. Obstruction for going to court? It's an act of patriotism to defend the constitutional rights of the president, because if they can do it to the president, they could do it to any of you, and they could do it to any American citizen, and that's wrong. And Lawrence Tribe, who's been advising them, I guess he didn't tell you that in the Clinton impeachment he said, it's dangerous to suggest that invoking constitutional rights is impeachable. It's dangerous. And you know what? It is dangerous, Mr. Schiff. So what are we doing here? We have the House that completely concocted a process that we've never seen before. They locked the president out. Oh, and by the way, will Mr. Schiff give documents? We asked him for documents. We asked him for documents when, contrary to his prior statements, it turned out that his staff was working with the whistleblower. We said, let us see the documents, release them to the public. We're still waiting. So the idea that they would come here and lecture the Senate. By the way, I was surprised to hear that, did you realize you're on trial? Mr. Nadler's putting you on trial. Everybody's on trial except for them. It's ridiculous. It's ridiculous. They said in their brief, we have overwhelming evidence, and they're afraid to make their case. Think about it. Think about it. It's common sense. Overwhelming evidence to impeach the President of the United States. And then they come here on the first day and they say, you know what, we need some more evidence. Now let me tell you something. If I showed up in any court in this country and I said judge my case is overwhelming, but I'm not ready to go yet. I need more evidence before I can make my case. I would get thrown out in 2 seconds. And that's exactly what should happen here. That's exactly what should happen here. It's too much to listen to almost. The hypocrisy of the whole thing. And what are the stakes? What are the stakes? There's an election in almost 9 months. Months from now, there's going to be an election. Senators in this body the last time had very wise words. They echoed the words of our founders. A partisan impeachment is like stealing an election. And that's exactly what we have. We have, talk about the framers' worst nightmare. It's a partisan impeachment that they've delivered to your doorstep in an election year. Some of you are upset because you should be in Iowa right now. But instead we're here, and they're not ready to go. And it's outrageous. It's outrageous. And the American people won't stand for it, I'll tell you that right now. They're not here to steal one election, they're here to steal 2 elections. It's buried in the small print of their ridiculous articles of impeachment. They want to remove President Trump from the ballot. They won't tell you that. They don't have the guts to say it directly, but that's exactly what they're here to do. They're asking the Senate to attack one of the most sacred rights we have as Americans, the right to choose our president in an election year. It's never been done before. It shouldn't be done before. Now, the reason it's never been done is because no one ever thought that it would be a good idea for our country, for our children, for our grandchildren, to try to remove a president from a ballot, to deny the American people the right to vote based on a fraudulent investigation conducted in secret with no rights. Well, I could go on and on, but my point is very simple. It's long past time that we start this so we can end this ridiculous charade and go have an election. Thank you very much, Mr. Chief Justice.
Does the President's Counsel yield back the remainder of their time? Thank you. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain documents and records from the White House, and I ask that it be read.
The clerk will read the document.
The senator from New York, Mr. Schumer, proposes an amendment number 1284. At the appropriate place in the resolving clause, insert the following. Section, notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules and Procedure and Practice in the Senate when sitting on impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the Acting Chief of Staff of the White House, commanding him to produce, for the time period from January 1st, 2019 to the present, all documents, communications, and other records within the possession, custody, or control of the White House, including the National Security Council, referring or relating to A, all meetings and calls between President Trump and the President of Ukraine, including documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21st and July 25th, 2019 telephone calls, as well as the President's September 25th, 2019 meeting with the President of Ukraine in New York. B, all investigations, inquiries, or other probes relating to Ukraine, including any that relate in any way to 1, former Vice President Joseph Biden, 2, Hunter Biden and any of his associates, 3, Burisma Holdings Limited, also known as Burisma, 4, interference or involvement by Ukraine in the 2016 United States election, 5, the Democratic National Committee, or 6, CrowdStrike. C, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF. D, all documents, communications, notes, and other records created or received by Acting Chief of Staff Mick Mulvaney, then National Security Advisor John R. Bolton, Senior Advisor to the Chief of Staff Robert B. Blair, and other White House officials relating to efforts to 1, solicit, request, demand, induce, persuade, or coerce Ukraine to conduct or announce investigations, 2, offer, schedule, cancel, or withhold a White House meeting for Ukraine's president, or 3, hold and then release military and other security assistance to Ukraine. E, meetings at or involving the White House that related to Ukraine, including but not limited to 1, President Zelensky's inauguration on May 20th, 2019 in Kiev, Ukraine, including but not limited to President Trump's decision not to attend to ask Vice President Pence to lead the delegation, directing Vice President Pence not to attend, and subsequent decision about the composition of the delegation of the United States. 2, a meeting at the White House on or around May 23rd, 2019, involving, among others, President Trump, then Special Representative for Ukraine negotiations, Ambassador Kurt Volker, then Energy Secretary Rick Perry, and United States Ambassador to the European Union, Gordon Sondland, as well as any private meetings or conversations with those individuals before or after the larger meeting. 3, meetings at the White House on or about July 10th, 2019, involving Ukrainian officials Andrei Yermak and Oleksandr Daniluk, and United States government officials, including but not limited to then National Security Advisor John Bolton, Secretary Perry, Ambassador Volker, Ambassador Sondland, to include at least a meeting in Ambassador Bolton's office and subsequent meeting in the wardroom. 4, a meeting at the White House on or around August 30th, 2019, involving President Trump, Secretary of State Mike Pompeo, and Secretary of Defense Mark Esper. 5, a planned meeting later canceled in Warsaw, Poland, on or around September 1st, 2019, between President Trump and President Zelensky, and subsequently attended by Vice President Pence. And 6, a meeting at the White House on or around September 11th, 2019, involving President Trump, Vice President Pence, and Mr. Mulvaney concerning the lifting of the hold on security assistance for Ukraine. F, meetings, telephone calls, or conversations related to any occasions in which the National Security Council officials reported concerns to National Security Council lawyers, including but not limited to National Security Council legal advisor John Eisenberg regarding matters related to Ukraine, including but not limited to 1, the decision to delay military assistance to Ukraine, 2, the July 10, 2019 meetings at the White House with Ukrainian officials, 3, the President's July 25, 2019 call with the President of Ukraine, 4, a September 1, 2019 meeting between Ambassador Sondland and a Ukrainian official, and 5, the President's September 7, 2019 call with Ambassador Sondland. G, any internal review or assessment within the White House regarding Ukraine matters following the September 9, 2019 request for documents from the House Permanent Select Committee on Intelligence, the House Committee on Oversight and Reform, and the House Committee on Foreign Affairs, including but not limited to documents collected that pertain to the hold on military and other security assistance to Ukraine, the scheduling of a White House meeting for the President of Ukraine, and any requests for investigations by Ukraine. H, the complaint submitted by a whistleblower within the intelligence community on or around August 12, 2019, to the Inspector General of the intelligence community. I, all meetings or calls, including requests for or recordings of meetings or telephone calls, scheduling items, calendar entries, White House visitor records, and email or text messages using personal or work-related devices between or among 1, current or former White House officials or employees, including but not limited to President Trump, and 2, Rudolph W. Giuliani, Ambassador Sondland, Victoria Tunsang, or Joseph DeGenova, and J, former United States Ambassador to Ukraine, Marie Masha Yovanovitch, including but not limited to the decision to end her tour or recall her from the United States Embassy in Kiev, and 2, the Sergeant at Arms is authorized to utilize the services of the Deputy Sergeant at Arms or any other employee of the United States Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice,
The Majority Leader is recognized.
I now ask for a brief 15-minute recess before the parties are recognized to debate the Schumer amendment. Therefore, I ask consent the Senate stand in recess, subject to the call of the chair.
Without objection, so ordered.
Will somebody please, there you go. I'd like to remind everybody to take your seats, and when the Chief Justice comes in, we really should all stand.
Senate will come to order. There are now 2 hours of argument on Senator Schumer's amendment. Mr. Schiff, do you wish to be heard on the amendment in proponent or as an opponent? Very well. Mr. Cipollone? Okay. Mr. Schiff, you have an hour.
Thank you, Mr. Chief Justice. In a moment, I will introduce House Manager Lofgren of California to respond on the amendment. But I did want to take this opportunity before certain representations became congealed to respond to my colleague's argument on the resolution at large. First, it's worth noting they said nothing about the resolution. They said nothing about the resolution. They made no effort to defend it. They made no effort to even claim that this was like the Senate trial in the Clinton proceeding. They made no argument that, well, this is different here because of this or that, or they made no argument about that whatsoever. They made no argument that it makes sense to try the case and then consider documents. They made no argument about why it makes sense to have a trial without witnesses. And why? Because it's indefensible. It's indefensible. No trial in America has ever been conducted like that. And so you heard nothing about it. And that should be the most telling thing about counsel's argument. They had no defense of the McConnell resolution because there is none. They couldn't defend it on the basis of Senate precedent. They couldn't defend it on the basis of Senate history, tradition. They couldn't defend it on the basis of the Constitution. They couldn't defend it at all. And so what did they say? Well, first they made the representation that the House is claiming there is no such thing as executive privilege. That's nonsense. No one here has ever suggested there's no such thing as executive privilege. But the interesting thing here is they've never claimed executive privilege. Not once during the House investigation did they ever say that a single document was privileged or a single witness had something privileged to say. And why didn't they invoke privilege? Why only now? And even now they haven't quite invoked it. Why only now? Why not in the House? Because in order to claim privilege, as they know because they're good lawyers, you have to specify which document, which line, which conversation, And they didn't want to do that because to do that, the president would have to reveal the evidence of his guilt. That's why they made no invocation of privilege. Now, they make the further argument that the House should only be able to impeach after they exhaust all legal remedies, as if the Constitution says the House shall have the sole power of impeachment, asterisk, but only after it goes to court, in the district court, then the Court of Appeals, and then en banc, and then the Supreme Court, and it's remanded, and they go back up the chain, and it takes years. Why didn't the founders require the exhaustion of legal remedies? Because they didn't want to put the impeachment process in the courts. And you know what's interesting is that while these lawyers for the president are here before you today saying the House should have gone to court, they are in court saying the House may not go to court to enforce its subpoenas. I kid you not. Other lawyers, maybe not the ones at this table, but other lawyers for the president, are in court saying the exact opposite of what they're telling you today. They're saying you cannot enforce congressional subpoenas. That's non-judiciable. You can't do it. Counsel brings up the case involving Charles Kupperman, who was a deputy to John Bolton on the National Security Council, and says he did what he should do. He went to court to fight us. Well, the Justice Department took the position he can't do that. So these lawyers are saying he should, and those lawyers are saying he shouldn't. They can't have it both ways. Now, interestingly, while Mr. Kupperman, Dr. Kupperman went to court, and they applaud him for doing that, his boss, John Bolton, now says there's no necessity for him to go to court. He doesn't have to do it. He's willing to come and talk to you. He's willing to come and testify and tell you what he knows. The question is, do you want to hear it? Do you want to hear it? Do you want to hear from someone who was in the meetings, someone who described what the president did, this deal between Mulvaney and Sondland as a drug deal? Do you want to know why it was a drug deal? Do you want to ask him why it was a drug deal? Do you want to ask him why he repeatedly told people, go talk to the lawyers? You should want to know. They don't want you to know. They don't want you to know. The president doesn't want you to know. Can you really live up to the oath you've taken to be impartial and not know? I don't think you can. Now, they also made the argument that you'll hear more later on from apparently Professor Dershowitz that, well, abuse of power is not an impeachable offense. It's interesting that they had to go outside the realm of constitutional lawyers and scholars to a criminal defense lawyer to make that argument because no reputable constitutional law expert would do that. Indeed, the one they called in the House, the Republicans called in the House, Jonathan Turley, has said exactly the opposite. There's a reason that Jonathan Turley is not sitting at the table, much to his dismay, and that is because he doesn't support their argument. So they'll cite him for one thing, but they'll ignore him for the other. Now they say, oh, the president is very transparent. He may have refused every subpoena, every document request, but he released 2 documents. The document on the July 25th call and the document on the April 21st call. Well, let's face it. He was forced to release the record of the July 25th call when he got caught. When a whistleblower filed a complaint, when we opened an investigation, he was forced because he got caught. You don't get credit for transparency when you get caught. And what's more, what's revealed in that, of course, is damning. Now they point to the only other record he has apparently released, the April 21st call, and that's interesting too. Now that's just a congratulatory call, but what's interesting about it is the president was urged on that call to bring up the issue of corruption. And indeed, in the readout of that call, the White House misleadingly said he did. But now that we've seen the record, we see that he didn't. And notwithstanding counsel's claim in their trial brief that the president raised the issue of corruption in his phone call, the July 25th call, of course, that word doesn't appear in either conversation. And why? Because the only corruption he cared about was the corruption that he could help bring about. Now, Mr. Cipollone made the representation that Republicans were not even allowed in the depositions conducted in the House. Now, I'm not going to suggest to you that Mr. Cipollone would deliberately make a false statement. I will leave it to Mr. Cipollone to make those allegations against others. But I will tell you this, he's mistaken. He's mistaken. Every Republican on the 3 investigative committees was allowed to participate in the depositions, and more than that, they got the same time we did. You show me another proceeding, another presidential impeachment or other that had that kind of access for the opposite party. Now, there were depositions in the Clinton impeachment. There were depositions in the Nixon impeachment. So what they would say is some secret process. Well, they were the same private depositions in these other impeachments as well. Finally, a couple last points. They make the argument the president was not allowed in the Judiciary Committee, chaired by my colleague, Chairman Nadler, to be present, to present evidence, to have his counsel present. That is also just plain wrong. Just plain wrong. Not going to suggest you they're being deliberately misleading here, but it is just plain wrong. You've also heard my friends at the other table make attacks on me and Chairman Adler. You'll hear more of that. I'm not going to do them the dignity of responding to them, but I will say this. They make a very important point, although it's not the point I think they're trying to make. When you hear them attack the House managers, what you're really hearing is, we don't want to talk about the president's guilt. We don't want to talk about the McConnell resolution and how patently unfair it is. We don't want to talk about how to pardon the expression, ass backwards it is to have a trial and then ask for witnesses. And so we'll attack the House managers because maybe we can distract you for a moment from what's before you. Maybe if we attack the House managers, you'll be thinking about them instead of thinking about the guilt of the president. So you'll hear more of that, and every time you do, every time you hear them attacking the House managers, I want you to ask yourselves, away from what issue are they trying to distract me? What was the issue that came up just before this? What are they trying to deflect my attention from? Why don't they have a better argument to make on the merits? Finally, Mr. Sekulow asks, why are we here? Why are we here? Well, I'll tell you why we're here. Because the president used the power of his office to coerce an ally at war with an adversary, at war with Russia, used the power of his office to withhold hundreds of millions of dollars of military aid that you appropriated and we appropriated to defend an ally and defend ourselves because it's our national security as well. And why? To fight corruption? That's nonsense, and you know it. He withheld that money, and he withheld even meeting with him in the Oval Office, the president of Ukraine, because he wanted to coerce Ukraine into these sham investigations of his opponent that he was terrified would beat him in the next election. That's what this is about. You want to say that's okay? Their brief says that's okay. The president has a right to do it. On Article 2, we heard the president, he can do whatever he wants. You want to say that's okay? Then you got to say that every future president can come into office and they can do the same thing. Are we prepared to say that? Well, that's why we're here. I now yield to Representative Lofgren.
Mr. Chief Justice, Senators, Counsel for the President, the House managers strongly support Senator Schumer's amendment, which would ensure a fair, legitimate trial based on a full evidentiary record. The Senate can remedy President Trump's unprecedented cover-up by taking a straightforward step. It can ask for the key evidence that the president has improperly blocked. Senator Schumer's amendment does just that. The amendment authorizes a subpoena for White House documents that are directly relevant to this case. These documents focus on the president's scheme to strong-arm Ukraine, to announce an investigation into his political opponent, to interfere with the 2020 election. The documents will reveal the extent of the White House's coordination with the president's agents, such as Ambassador Sondland and Rudy Giuliani, who pushed the president's so-called drug deal on Ukrainian officials. The documents will also show us how key players inside the White House, such as the president's acting chief of staff, Mick Mulvaney, and his deputy, Robert Blair, helped set up the deal by executing the freeze on all military aid and withholding a promised visit to the White House. The documents include records of the people who may have objected to this scheme, such as Ambassador Bolton. This is an important impeachment case against the president. The most important documents are going to be at the White House. The documents Senator Schumer's amendment targets would provide more clarity and context about President Trump's scheme. The amendment prevents the president from hiding evidence, as he has previously tried to do. Now, the House subpoenaed these documents as part of the impeachment inquiry, but the president completely rejected this and every document subpoena from the House. As powerful as our evidence is, and make no mistake, it overwhelmingly proves his guilt, we did not receive a single document from the executive branch agency, including the White House itself. Recent revelations from press reports, Freedom of Information Act requests, and additional witnesses, such as Lev Parnas, underscore how relevant these documents and therefore why the president has been so desperate to hide them and his misconduct from Congress and from the American people. A trial without all the relevant evidence is not a fair trial. It would be wrong for you senators acting as judges to be deprived of relevant evidence of the president's offenses when you are judging these most serious charges. It would also be unfair to the American people, who overwhelmingly believe the president should produce all relevant documents and evidence. Now, documentary evidence is used in all trials for a simple reason. As the story goes, the documents don't lie. Documents give objective, real-time insight into the events under investigation. The need for such evidence is especially important in Senate impeachment trials. More than 200 years of Senate practice make clear that documents are generally the first order of business. They've been presented to the Senate before witnesses take the stand in great volume to ensure the Senate has the evidence it needs to evaluate the case. Now, documentary evidence in Senate trials has never been limited to the documents sent by the House. The Senate, throughout its existence, has exercised its authority pursuant to its clear rules of procedure to subpoena documents at the outset of a trial. We don't know with certainty what the documents will say. We simply want the truth, whatever that truth may be. So do the American people. They want to know the truth, and so should everybody in this chamber, regardless of our party affiliation. There are key reasons why this amendment is necessary. We'll begin by walking through the history and precedent of Senate impeachment trials. I'll let you know about the House's efforts to get the documents, which were met by the president and his administration's categorical commitment to hide all the evidence at all costs. And we'll address the specific need for these subpoenaed White House documents. I'll tell you why these documents are needed now, not at the end of the trial, in order to ensure a full, fair trial based on a complete evidentiary record. Now, some have suggested incorrectly that the Senate is limited only to evidence gathered before the House approved its articles of impeachment. Others have suggested, also incorrectly, that it would somehow be strange for the Senate to issue subpoenas. These claims are without any historical, precedential, or legal support. Over the past 2 centuries, the Senate has always understood that its sole power under the Constitution to try all impeachments requires the Senate to sit as a court of impeachment and hold a trial. In fact, the founders assigned sole authority only twice in the Constitution. First, giving the House sole authority to impeach, and second, giving the Senate sole authority to try that impeachment. If the founders had intended for the Senate to serve as some kind of appellate body, they would have said that. But no, instead they wrote this: Article 1, Section 3, the Senate shall have the sole power to try all impeachments. The Senate has always received the relevant documents in impeachment trials, and indeed, the Senate's own rules of procedure and practice make clear that new evidence will be considered. Precedent shows this. All 15 full Senate impeachment trials considered new evidence. Let's look at a few examples that show the Senate takes new evidence in impeachment trials. The first ever presidential impeachment trial in 1868 against President Andrew Johnson allowed the House managers to spend the first 2 days of the trial introducing new documentary evidence. It was the same in Judge John Pickering's trial in 1804. New documents were presented to the Senate nearly a week before House managers made their opening statement and later throughout the trial. And, as been mentioned earlier by Mr. Schiff, in modern times in 2010, George Porteous's impeachment trial included 7 months of pretrial discovery and 6,000 pages of documentary evidence admitted at trial. After that evidence was admitted, the Senate held its trial. President Clinton's case did not involve subpoenas for documents. Now, why was that? Because President Clinton had already produced a huge trove of documents. The independent counsel turned over to Congress some 90,000 pages of relevant documents gathered during the course of his years-long investigation. And I remember, as a member of the Judiciary Committee, going over to the Ford building, looking at the boxes of the document. But even with all those documents, the Clinton trial included the opportunity to present new evidence and the admission of additional documents and 3 witnesses. The Clinton impeachment precedent also shows how President Trump's refusal to produce any relevant documents in response to congressional subpoenas is different than past presidents, different from President Clinton, different from President Johnson, and less even than President Nixon. In short, not a single president has categorically refused to cooperate with an impeachment investigation. Not a single president has issued a blanket direction to his administration to produce no documents and no witnesses. These are the precedents the Senate must rely on. The Senate should issue a subpoena for documents at the very outset of the proceedings so that this body, the House managers, the President, can all account for those documents in their presentations and deliberations. It doesn't make sense to request and receive documents after the parties present their cases. The time is now to do that. So why is the amendment needed to prevent President Trump from continuing his categorical commitment to hide the evidence? In this case, the House sought White House documents. Why don't we have them? It's not because we didn't try. It's because the White House refused to give them to us. The President's defense team seems to believe that the White House is permitted to completely refuse to provide any documents without regard to whether or not it is privileged. They apparently believe that Congress's authority is subject to the approval of the President. But that's not what the Constitution says. Our Constitution sets forth a democracy with a system of checks and balances to ensure that no one, and certainly not the President, is above the law. Now, even President Nixon produced more than 30 transcripts of White House recordings and notes from meetings with the President. Here, even before the House launched the investigation that led to this trial, President Trump rejected Congress's constitutional responsibility to use its lawful authority to investigate his actions. He asserted that his administration was fighting all the subpoenas, proclaiming, "I have an Article 2, where I have the right to do whatever I want as president." Here is what he said.
Then I have an Article 2, where I have the right to do whatever I want as president.
Even after the House formally announced its investigation of the President's conduct in Ukraine, the President still continued his obstruction. Beginning on September 9th, 2019, the House investigative committees made 2 attempts to voluntarily obtain documents from the White House. The White House refused to engage with, frankly, or even respond to the House committees. On October 4th, the House Committee on Oversight and Reform set a subpoena to White House Acting Chief of Staff Mick Mulvaney, this time compelling the production of documents from the White House by October 18th. On October 8th, before the White House documents were due, the White House counsel sent a letter to Speaker Pelosi stating the president's position that the President Trump and his administration cannot participate in this partisan inquiry under these circumstances. The president simply declared that he will not participate in an investigation he didn't like. 10 days later, on October 18th, the White House counsel sent a letter to the House confirming that it would continue to stonewall. The White House counsel again stated the president refused to participate. Well, the Constitution, Article 1, Section 2, says that the House shall have the sole power of impeachment, just as in Article 1, Section 3, the Senate has the sole power to try. Participation in a duly authorized congressional investigation isn't optional. It's not up to the president to decide whether to participate or not. The Constitution gives the House the sole power of impeachment. It gives the Senate the sole power to try all impeachments. The president may not like being impeached, but if the president, not the Congress, decides when impeachment proceedings are appropriate, then the impeachment power is no power at all. And if you let him block from Congress and from the American people the evidence to cover up his offenses, then the impeachment power truly will be meaningless. With all the back and forth about these documents, we've heard the phrase executive privilege. The president and his lawyers keep saying it. They talk about vast legal rights to justify hiding the truth, withholding information, but that's a distraction. That's not what the Constitution provides, and the truth is, as has been mentioned by Mr. Schiff, in the course of the entire impeachment inquiry, President Trump has not once asserted executive privilege, not a single time. It was not the reason provided by Mr. Cipollone for refusing to comply with the House's subpoena. Indeed, President Trump didn't offer legal justification for withholding the evidence. Here's the truth. Presidents, members of Congress, judges, and the Supreme Court have recognized throughout our nation's history that Congress's investigative power are at their absolute peak during impeachment proceedings. Your powers. Executive privilege cannot be a barrier to give absolute secrecy to cover up wrongdoing. If it did, the House and the Senate would see their power disappear. When President Nixon tried that argument by refusing to produce tape recordings to prosecutors and to Congress, he was soundly rebuked by the other 2 branches of government. The Supreme Court unanimously ruled against him. The House Judiciary Committee voted that he be impeached for obstruction of Congress. It would be remarkable for the United States Senate to declare, for the first time in our nation's history, that the president has an absolute right to decide whether his own impeachment trial is legitimate. And it would be extraordinary for the Senate to refuse to seek important documentary evidence, especially when the president has yet to assert any privilege to justify withholding documents. Now, there's another reason this amendment is important. The documents sought are directly relevant to the president's misconduct. The White House is concealing documents involving officials who have direct knowledge of key events at the heart of this trial. This isn't just a guess. We know these documents exist from the witnesses who testified in the House and from other public release of documents. And let's walk through those specific documents that the White House should send to the Senate. They include, among other documents, relating to President Trump's direct communications with President Zelensky, President Trump's request for political investigations, including communications with Rudy Giuliani, Ambassador Sondland, and others, President Trump's unlawful hold of the $391 million of military aid, concerns that White House officials reported to NSC legal counsel in real time, the President's decision to recall Ambassador Marie Yovanovitch from Ukraine. The first set of documents the Senate should get about President Trump's communication with the President of Ukraine would include the phone calls on April 21st and July 25th, as well as the September 25th, 2019 meeting with President Zelensky in New York. We know, for example, that NSC officials prepared talking points for the President in preparation for both calls with the Ukrainian President. The talking points were about American policy as reflected by the votes of Congress as well as the Trump administration itself. They didn't include any mention of the Bidens or the 2016 election, interference or investigations that President Trump requested on the July 25th call. Here's a clip of Lieutenant Colonel Vindman explaining how the President ignored the points about American policy, reflecting the views of both the Congress and the Trump administration.
Colonel Vindman, if I could turn your attention to the April 21st call, that is the first call between President Trump and President Zelensky. Did you prepare talking points for the President to use during that call?
Yes, I did.
And did those talking points include rooting out corruption in Ukraine?
Yes.
That was something the President was supposed to raise in the conversation with President Zelensky?
Those were the recommended talking points that were cleared through the NSC staff for the President, yes.
The materials provided for the July 25th call that Lieutenant Colonel Vindman mentioned are highly relevant. They could help confirm that the President's actual statements to President Zelensky were unrelated to the foreign policy objectives of his own administration and show that they served his own personal interests at the expense of America's national security interests. These documents also include handwritten notes and other documents that White House officials generated during the calls and meetings. We know, for example, that Lieutenant Colonel Vindman, Mr. Morrison, Jennifer Williams, all testified to taking contemporaneous handwritten notes during the July 25th call. Ms. Williams and Lieutenant Colonel Vindman both testified that President Zelensky made an explicit reference to Burisma that was not included in the memorandum that the White House released to the public. Here's a clip of their testimony.
Both of you recall President Zelensky in that conversation raising the issue or mentioning Burisma, do you not?
That's correct.
Correct.
And yet, the word Burisma appears nowhere in the call record that's been released to the public. Is that right?
That's right.
Correct.
Why do you need documents generated after the calls and meetings? They would shed light on how these events were perceived in the White House and what actions were taken moving forward. For example, National Security Advisor John Bolton wasn't on the 25th call, but he was apparently informed about the contents of the call afterward. His reaction, once he was informed, would be helpful to understanding the extent to which President Trump's action deviated from American policy and American security interests. There's another set of documents that the Senate should get, and they relate to the political investigations that President Trump and his agents repeatedly asked Ukrainian officials to announce. These documents about efforts to pressure Ukraine to announce investigations and the decision to place a hold on military aid to Ukraine, they would be very important for you to evaluate the President's conduct. For example, Ambassador Bolton is a first-hand witness to President Trump's abuse of power. He reported directly to the President. He supervised the entire staff of the National Security Council. Public reports indicate that John Bolton is a voracious note-taker in every meeting. From witness testimony, we know that Ambassador Bolton hosted the July 10th, 2019 meeting where Ambassador Sondland told Ukrainian officials that the promised White House meeting would be scheduled if they announced the investigations. We know Bolton was briefed about this meeting immediately following it when Ambassador Sondland said he had a deal with Mick Mulvaney to schedule the promised White House meeting if Ukraine announced investigations into the Bidens in the 2016 election. We also know Ambassador Bolton was involved in briefing the president on a presidential decision memorandum in August, reflecting the consensus interagency opinion that Ukrainian security assistance was vital to America's national security, something the Congress had approved, appropriated, something the president had signed. Press reports indicate that he too was involved in a late August Oval Office meeting where he, Secretary Pompeo, and Secretary Esper all tried to convince the president to release the aid. Now, Ambassador Bolton has come forward and publicly confirmed that he was a witness to important events, but also that he has new evidence that no one has seen yet. If we know there is evidence that's not yet come out, all of us should want to hear it. We should want to hear it now. Before Ambassador Bolton testifies, we should get documents and records relating to his testimony, including his notes, which would provide contemporaneous evidence about what was discussed in meetings related to Ukraine, which would help to evaluate his testimony. The evidence is not just restricted to Ambassador Bolton. During his public testimony, Ambassador Gordon Sondland stated, "I have not had access to all my phone records." He also said that he and his lawyers had asked repeatedly for these materials. He said the materials would help refresh his memory. We should look at that material. Ambassador Sondland also testified that he exchanged a number of emails with top officials like Mick Mulvaney about his efforts to pressure Ukraine to announce the investigations President Trump demanded. Here's his testimony.
Third, let me say, precisely because we did not think that we were engaging in improper behavior, we made every effort to ensure that the relevant decision makers at the National Security Council and the State Department knew the important details of our efforts. The suggestion that we were engaged in some irregular or rogue diplomacy is absolutely false. I have now identified certain State Department emails and messages that provide contemporaneous support for my view. These emails show that the leadership of the State Department, the National Security Council, and the White House were all informed about the Ukraine efforts from May 23rd, 2019 until the security aid was released on September 11th, 2019.
These emails, among others, are in the possession of... Oh. These emails referenced in this testimony are in the possession of the White House, the State Department, and even the Department of Energy, since officials from all three entities communicated together. You know, during his testimony, Ambassador Sondland described it this way: everyone was in the loop. It was no secret. These emails are therefore important to understanding the full scope of the scheme. The request for relevant evidence is not confined to Trump administration officials. The Senate should also get White House records relating to the president's private agents who acted on his behalf in Ukraine, including Rudy Giuliani, Victoria Tensing, and Joe DeGeneva. Witness testimony and documents have made clear that Mr. Giuliani, a frequent visitor to the White House who also received and made frequent calls to the White House, was acting on behalf of the president to press Ukrainian officials to announce investigations that would personally and politically benefit the president. For example, the May 10th, 2019 letter from Mr. Giuliani to President-elect Zelensky that's shown on this slide states he was acting, quote, as personal counsel to President Trump with his knowledge and consent. He requested a meeting with the president-elect and he to be joined by Ms. Tensing, who is, quote, very familiar with this matter. The evidence indicates he was collaborating with Ms. Tensing and Mr. DeGeneva in this effort. The Senate should get the White House records of meetings, of calls involving Mr. Giuliani, Ms. Tensing, or Mr. DeGeneva. These records are important to help you understand the extent to which the White House was involved in Mr. Giuliani's efforts to coerce Ukraine to announce the investigations the president wanted. The records would also show how the president's personal political agenda became more important than policies to help America's national security interests. The President's Counsel may, consistent with his prior attempts to hide evidence, assert that attorney-client privilege would cover these documents. But the President's personal attorney-client privilege cannot shield evidence of misconduct in office, or that of his aides, or of his lawyers' participation in corrupt schemes. We aren't asking for documents reflecting legitimate legal advice. You need documents about their actions to pressure Ukraine to announce an investigation into President Trump's political opponent. There's a set of White House documents that relate directly to the president's unlawful decision to withhold $391 million appropriated bipartisan to help Ukraine. Witnesses have testified that President Trump directly ordered a hold on this security assistance, despite the unanimous opinion of his agencies that the aid should be released. Importantly, according to the Government Accountability Office, his action violated the law. On January 16, 2020, the GAO, an independent watchdog, issued a legal opinion finding that President Trump violated the law when he held up security assistance to Ukraine. The GAO said, and I quote, "Faithful execution of the law does not permit the president to substitute his own policy priorities for those that Congress enacted into law. OMB withheld funds for a policy reason which is not permitted under the Impeachment Control Act. The withholding was not a programmatic delay. Therefore, we conclude that OMB violated the ICA. The fact that the president's action to freeze the aid, which he used to pressure Ukraine to announce the political investigations he wanted, was against not only the official consensus of his own administration, but also against the law, and it was to help himself. That helps demonstrate these actions were taken for President Trump's personal and political benefit. Witness testimony and public reporting make clear the White House has a significant body of documents that relate to these key aspects of the president's scheme. Some of these documents outline the planning of the president's freeze. For example, the New York Times reported in June that Mr. Mulvaney emailed his senior advisor, Mr. Blair, "Did we ever find out about the money for Ukraine and whether we can hold it back?" This shows that Mr. Mulvaney was in email contact with his aides about the very issues under investigation as part of this impeachment. It tells us that the White House is in possession of communications that go to the heart of the charges before you. The Senate should also get materials prepared for summary notes from a late August meeting with President Trump, Secretary of Defense Mark Esper, and Secretary of State Mike Pompeo when they tried to convince the president that freeing, and this is a quote, "freeing up the money for Ukraine was the right thing to do." According to the New York Times, Ambassador Bolton told the president, "This is in America's interest." The Senate should review that highly relevant document, which reflects real-time assertions by President Trump's own senior aides that Ukrainian aid was in the national security interest of the United States and that there was no legitimate reason to hold up the aid. There are documents that include after-the-fact justifications to try and overcome legal problems and the unanimous objections to freezing assistance to Ukraine. And we know these documents exist. For example, on January 3rd, 2020, OMB stated in a letter to the New York Times that it had discovered 20 responsive documents consisting of 40 pages, reflecting emails between White House official Robert Blair and OMB official Michael Duffy that relate directly to the freezing of the Ukraine security assistance. But OMB wouldn't release them in a Freedom of Information lawsuit, and they have refused to produce these documents at the direction of the President in response to the House's lawful subpoena. Now, the Washington Post reported that a confidential White House review of President Trump's decision to hold up hundreds of documents that reveal extensive efforts to generate an after-the-fact justification for the debate over whether the delay was legal. That's known as a cover-up, actually. The White House lawyers had apparently uncovered, quote, early August email exchanges between Acting Chief of Staff Mick Mulvaney and White House budget officials seeking to provide some explanation for withholding the funds the President had already ordered on hold. The documents also reportedly include communications between White House officials and outside agencies. Not only does Congress have a right to see them, the public does too, under Freedom of Information laws. Now, as a matter of constitutional authority, the Senate has the greatest interest in and right to compel those documents. Indeed, as the news article explains, White House lawyers are reportedly, quote, worried about unflattering exchanges and facts that could, at a minimum, embarrass the President. Perhaps they should be worried about that. But the risk of embarrassment cannot outweigh the constitutional interests in this impeachment proceeding. Any evidence of guilt, including further proof of the real reason the President ordered the funds withheld, or after-the-fact attempts to paper over knowingly unlawful conduct, they must be provided to ensure a full and fair trial. No privilege or national security rationale can be used as a shield from disclosing misconduct. There are key White House documents relating to multiple instances when White House officials reported their concerns to White House lawyers about the President's scheme to press Ukraine to do the President a domestic political favor. For example, Lieutenant Colonel Vindman and Dr. Hill both informed NSC lawyers about the July 10th meeting in which Ambassador Sondland revealed he had a deal with Mr. Mulvaney. I'm going to go directly to the clip by Dr. Hill, because Dr. Hill, pardon me, at Bolton's direction, also reported that meeting to John Eisenberg, as she explained in her testimony.
I had a discussion with Ambassador Bolton both after the meeting in his office, a very brief one, and then one immediately afterwards, the subsequent meeting.
So the subsequent meeting, or after both meetings, when you spoke to him and relayed to him what Ambassador Sondland said, what did Ambassador Bolton say to you?
Well, I just want to highlight, first of all, that Ambassador Bolton wanted me to hold back in the room immediately after the meeting. Again, I was sitting on the sofa with a colleague.
Right, but just in that second meeting, what did he say?
Yes, but he was making a very strong point that he wanted to know exactly what was being said. And when I came back and related it to him, he had some very specific instruction for me. And I'm presuming that that's
what was that specific instruction?
The specific instruction was that I had to go to the lawyers, to John Eisenberg, our senior counsel for the National Security Council, to basically say, you tell Eisenberg, Ambassador Bolton told me, that I am not part of this whatever drug deal that Mulvaney and Sondland are cooking up.
What did you understand him to mean by the drug deal that Mulvaney and Sondland were cooking up?
I took it to mean investigations for a meeting.
Did you go speak to the lawyers?
I certainly did.
You relayed everything that you just told us and
I
more?
relayed it precisely, and then the details of how the meeting had unfolded as well, which I gave a full description of this in my October 14 deposition.
There was something wrong going on here, and White House officials were told repeatedly, go tell the lawyers about it. Dr. Hill, Lieutenant Colonel Vindman, Mr. Morrison, who reported to Mr. Eisenberg at least 2 conversations. We need the notes of those documents to find out what was said. And again, attorney-client privilege cannot shield information about misconduct from the impeachment trial of the President of the United States. Now, it's interesting. This amendment is supported by 200 years of precedent. It's needed to prevent the President from continuing to hide the evidence, and that's why the specific documents requested are so important for this case. It's faithful to the Constitution's provision that the Senate shall have the sole power to try all impeachments. The final point I'll make today concerns urgency. The Senate should act on this subpoena now, at the outset of the trial. In 14 of the Senate's 15 full impeachment trials, threshold evidentiary matters, including the timing, nature, and scope of witness testimony and the gathering of all relevant documents, were addressed at the very outset of the trial. There are practical considerations as why the subpoenas need to be issued now. Resolving whether a subpoena should issue now would let us immediately engage with the White House to resolve asserted legitimate privilege issues, if any exist, and ensure you get the documents as soon as possible so they can be presented to the senators in advance of witness testimony. Waiting to resolve these threshold matters until after the parties have presented their case would undercut the process of a genuine, credible trial. Thus, common sense, tradition, and fairness all compel that the amendment should be adopted, and it should be adopted now. Members of the Senate, for all the reasons I walked through today, I urge you to support the amendment to issue a subpoena for White House documents, documents that are directly relevant to evaluating the President's scheme. The House did its job. In the face of the President's obstruction and categorical commitment to hide the evidence, we still gathered direct evidence of his conduct and determined that his conduct required impeachment. The President complains about due process in the House investigation, but he was not only permitted to participate, he was actually required to participate, yet he refused to do so. He refused to provide witnesses and documents that would tell his side of the story. So now it's up to you. With the backing of a subpoena authorized by the Chief Justice of the United States, you can end President Trump's obstruction. If the Senate fails to take this step, if it won't even ask for this evidence, this trial and your verdict will be questioned. Congress and the American people deserve the full truth. There is no plausible reason why anyone wouldn't want to hear all of the available evidence about the President's conduct. It's up to this body to make sure that happens. It's up to you to decide whether the Senate will affirm its sole power and constitutional duty to try impeachments, whether and when it will get the evidence that it needs to render a fair verdict. Don't surrender to the President's stonewalling. It will allow the President to be above the law and deprive the American people of truth in the process. A fair trial is essential in every way. Important for the President, who hopes to be exonerated, not merely acquitted by a trial seen as unfair. Important for the Senate, whose vital role is to continue to protect and defend the Constitution of the United States, which has preserved our American liberty for centuries. And finally, important for the American people who expect a quest for truth, fairness, and justice. History is watching, and the House managers urge that you support the amendment, and I reserve the balance of my time.
Thank you, counsel. Mr. Cipollone?
Mr. Chief Justice, Patrick Philbin will present our opposition.
Very well. Mr. Philbin?
Thank you, Mr. Chief Justice, Majority Leader McConnell, Democratic Leader Schumer, Senators. It's remarkable that after taking the action of the breathtaking gravity of voting to impeach the duly elected President of the United States, and after saying for weeks that they had overwhelming evidence to support their case, the first thing that the House managers have done upon arriving finally in this chamber after waiting for 33 days is to say, well, actually, we need more evidence. We're not ready to present our case. We need to have subpoenas and we need to do more discovery because we don't have the evidence we need to support our case. This is stunning. It's a stunning admission of the inadequate and broken process that the House Democrats ran in this impeachment inquiry that failed to compile a record to support their charges. It's stunning that they don't have the evidence they need to present their case and that they don't really have a case. If a litigant showed up in any court in this country on the day of trial and said to the judge, actually, Your Honor, we're not ready to go. We need more discovery. We need to do some more subpoenas. We need to do some more work. They'd be thrown out of court and the lawyers would probably be sanctioned. This is not the sort of proceeding that this body should condone. Now, we've just heard that this is so important. Let's consider what's really at issue in the resolution here and the amendment. It's a matter of timing. It's a matter of when this body will consider whether there should be witnesses or subpoenas for documents. Why is it that the managers, the House managers, are so afraid to have to present their case, remember, they've had weeks of a process that they entirely controlled. They had 17 witnesses who testified first in secret and then in public. They've compiled a record with thousands of pages of reports, and they're apparently afraid to just make a presentation based on the record that they compiled and then have you decide whether there's any there, whether there's anything worth trying to talk to more witnesses about. Why is it that they can't wait a few days to make their presentation on everything they've been preparing for weeks and then have that issue considered? Because they don't think that there is any there, and they want to ram this through now. And they want to ram this through now when it's something that they themselves failed to do. So I want to unpack a couple of the aspects of what they're asking this body to do. Part of it relates to the broken process in the House and how that process was inadequate and invalid and compiled an inadequate record. And part of it has to do with what accepting their request to have this body do their job for them would do to this institution going forward, and how it would alter forever the relationship between the House and the Senate in impeachment proceedings. So first, as to the process in the House. What they're asking, the House manager asking this body to do now is really to do their job for them, because they didn't take the measures to pursue these documents in the House proceedings. And there have been a number of statements made about they tried to get the documents and no executive privilege was asserted and things like that. Let's look at what actually happened. They issued a subpoena to the White House. And the White House explained, and we were told a few minutes ago that the White House provided no response, it provided no rationale. That's not true. In a letter of October 18th, White House counsel Pat Cipollone explained in 3 pages of legal argument why that subpoena was invalid. And that subpoena was invalid because it was issued without authorization. We've heard a lot today about how the Constitution assigns the sole power of impeachment to the House. That's right. That's what Article 1, Section 2 says. It assigns the sole power of impeachment to the House, not to any member of the House. And no committee of the House can exercise that authority to issue subpoenas until it's been delegated that authority by a vote of the House. There was no vote from the House. Instead, Speaker Pelosi held a press conference. And she purported, by holding a press conference on September 24th, to delegate the authority of the House to Manager Schiff and several other committees and have them issue subpoenas. All of those subpoenas were invalid. And that was explained to the House, to Manager Schiff and the other chairman of those committees at the time in that October 18th letter. Did the House take any steps to remedy that? Did they try to dispute that? Did they go to court? Did they do anything to resolve that problem? No. Because as we know, all that they wanted to do was issue a subpoena and move on. They just wanted to get through the impeachment process as quick as possible and get it done before Christmas. That was their goal. So those subpoenas were unauthorized. Now, what about some of the other things that they brought up? The witnesses. Witnesses who were directed not to testify. And part on this, we've heard Manager Schiff say several times that the White House never asserted executive privilege. Well, let me be clear on that. That's a lawyer's trick, because it is technically true that the White House didn't assert executive privilege, because there's a particular situation in which you do that and a particular way that you do that. But there's another doctrine of immunity of senior advisors to the president that is based on the same principles as executive privilege, and that has been asserted by presidents of both political parties since the 1970s at least. So that's, and this is what one attorney general explained about that. Quote, "The immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests," end quote. That was Attorney General Janet Reno in the Clinton administration, explaining that senior advisors to the president are immune from congressional compulsion. And that doctrine, that immunity, is rooted in the same principles of executive privilege. It's been asserted by all presidents since the 1970s, and that was the basis on which a number of the advisors whose pictures they put up were directed not to testify. Did they try to challenge that in court? Did they go to court on that one? Did they try to go through the constitutionally mandated accommodations process to see if there was a way to come up with some aspect of testimony that could be provided? No, none of that. They just wanted to forge ahead, rush through the process, not have the evidence, and then use that as another charge in their charging sheet for the impeachment, calling it obstruction of Congress. And what that is Professor Turley explained, this idea that when there's a conflict between the executive branch and the House and seeking information, and the president is asserting constitutionally based privileges, that's part of the operation of separation of powers. That is the president's constitutional duty to defend the prerogatives of the office for the future occupants of that office. And it is not something that can be charged as an impeachable offense, as the House Democrats have tried to say here. To do that is an abuse of power. That's what Professor Turley explained. It's Congress's, it's the House Democrats' abuse of power. We just heard Manager Lofgren refer to executive privilege as a distraction. She was asserting that these issues of executive privilege are just a distraction that shouldn't hold things up. But this is what the Supreme Court has said about executive privilege in Nixon versus United States, that the protections for confidentiality and executive privilege are, quote, fundamental to the operations of government and inextricably rooted in the separation of powers under the Constitution, end quote. Inextricably rooted in the separation of powers. That's why it's the president's duty to defend executive branch confidentiality interests, and that is what the president was doing here. Now, the process that they pursued in the House abandoned any effort beyond issuing the first subpoena that was invalid to work out an accommodation with the White House, and instead just tried to rush ahead to have the impeachment done by Christmas. What does that lead to now? They're coming to this body after a process that was half-baked, that didn't compile a record sufficient to support their charges, and asking this body to do their job for them. Now, as Leader McConnell pointed out in some comments earlier today, to allow that, to accept the idea that the House can bring an impeachment here that is not adequately supported, that has not been investigated, that has not got a record to support it, and to turn this body into the investigatory body would permanently alter the relationship between the House and the Senate in impeachment proceedings. It's not the role of the Senate to have to do the House's job for them. It's not the role of the Senate to be doing an investigation and to be doing discovery in a matter like the impeachment of a president of the United States. If the House has not done the investigation and cannot support its case, it's not the time once it arrives here to start doing all that work. That's something that's the House's role. So, this is something that is important for this institution, I believe, not to allow the House to turn it into a situation where this body would have to be doing the House's work for it. If there is not evidence to support the case, if they haven't done their investigation, then they're not going to be able to support their case. Again, what's at issue here, and I think it's important to recall on the issue of this amendment, it's not whether the Senate, whether this body will be considering whether there should be witnesses or not, but when that should be considered. And there is no reason not to take the approach that was done in the Clinton impeachment. 100 senators agreed then that it made sense to hear from both sides before making a determination on that, to hear from both sides to see what sort of case the House could present and the president's defense. And that makes sense. In every trial system, there is a mechanism for determining whether the parties have actually presented a triable issue, whether there is really some there that requires the further proceedings. And this body should take that common sense approach and hear what it is that the House managers have to say. Why are they afraid to present their case? They had weeks in a process that they controlled to compile their record, and they should be able to make that presentation now. And the one point that I will close on, we've heard Manager Schiff say several times that we have to have a fair process here, and I was struck by it that at one point he said if you allow only one side to present evidence, the outcome will be predetermined. The outcome will be predetermined. That's exactly what happened in the House. Let's recall that the process they had in the House was one-sided. They locked the president and his lawyers out. There was no due process for the president. They started with secret hearings in the basement. The president couldn't be present by his counsel. He couldn't present evidence. He couldn't cross-examine witnesses. And then there was a second round in public, where again they locked the president out. And we've heard, they just said that the president had an opportunity to participate. In the third round of hearings that they held before the Judiciary Committee, after one hearing on December 4th, Speaker Pelosi, on the morning of December 5th, went out and announced the conclusion of the Judiciary Committee proceedings. She announced that she was directing Chairman Nadler to draft articles of impeachment. That was before the day that they had set for the president even to tell them what rights he wanted to have and to exercise in their proceedings. It was all already predetermined. The outcome had been predetermined. The Judiciary Committee had already decided it was not going to have any fact hearings. There was no process for the president. He was never allowed to participate. So when Chairman Schiff says here that if you only allow one side to present evidence, that predetermines the outcome, that's what they did in the House, because they had a predetermined outcome there, because it was all one-sided. And for him to lecture this body now on what a fair process would be takes some gall. A fair process would be when you come to the day of trial Be ready to start the trial and present your case, not ask for more discovery. The President is ready to proceed, and the House manager should be ready to proceed, and this amendment should be rejected. Thank you.
Counsel, the House managers have 8 minutes remaining.
The House is certainly not asking the Senate to do the House's job. We're asking the Senate to do its job, to hold a trial. Have you ever heard of a trial that doesn't have evidence, that doesn't have witnesses? That's what this amendment is all about. Just a moment about the subpoenas. President Trump, refused to provide any information to the House, ordered all of his people to stonewall us. Now, it's been suggested that we should spend 2 or 3 years litigating that question. I was a young law student, actually, working on the Nixon impeachment many years ago. And I remember the day that the Supreme Court issued its unanimous decision that the president had to release the tapes. I think U.S. v. Nixon still governs the president. The House and the Senate should not be required to litigate U.S. v. Nixon back to the Supreme Court and down again for it to be good law. It is good law. The president has not complied with those requirements to the detriment of the truth. This isn't about helping the House. This isn't about helping the Senate. This is about getting to the truth and making sure that impartial justice is done and that the American people are satisfied that a fair trial has been held. I would yield now to my colleague, Mr. Schiff.
Mr. Philbin says that the House is not ready to present its case. Of course, that's not something you heard from any of the managers. We are ready. The House calls John Bolton. The House calls John Bolton. The House calls Mick Mulvaney. Let's get this trial started, shall we? We are ready to present our case. We are ready to call our witnesses. The question is, will you let us? That is the question before us. Now, Mr. Philbin says, well, if I showed up in court and said I wasn't ready, the judge would throw me out of the court. Of course, we're not saying we're not ready. But you know what would happen if Mr. Philbin went into a court and the judge said, I've made a deal with the defendant. I'm not going to let the prosecutor call any witnesses. I'm not going to let the prosecutor present any documents. You know who'd get thrown out of the court? The judge. The judge would be taken out in handcuffs. So let's step out of this body for a moment and imagine what a real trial would look like. It would begin with the government receiving documents, being able to introduce documents, being able to call witnesses. This trial should be no different. Now, Mr. Philbin makes reference to the Cipollone letter on October 18th, which followed a Cipollone 8-page letter on October 8th saying, we're not going to do anything you ask. Part law, part diatribe, mostly diatribe. You should read it. It's a letter basically that says what the president said on that TV screen, which is, we're going to fight all subpoenas. The doctrine of absolute immunity that counsel refers to has, yes, it has been invoked or at least attempted by presidents of both parties and rejected uniformly by the courts, including in the most recent decision involving Don McGahn, the president's former White House counsel, where the court said that would make him a king. He's no king. And this trial has determined that he shall not become a king, accountable to no one, answerable to no one. And what's more, this idea of absolute immunity, this fever dream of presidents of both parties, it has no application to documents. Again, this amendment is on documents. There's no absolute immunity from providing documents. And as Representative Lofgren illustrated, when this case has gone to the Supreme Court, in the Nixon case, the court held that the interest in confidentiality in an impeachment proceeding must give way to the interests of the truth and the Senate and the American people. You cannot invoke privilege to protect wrongdoing. You cannot invoke privilege to protect evidence of a constitutional crime like we have here. And finally, with respect to those secret hearings that counsel keeps referring to, those secret depositions in the House were so secret that only 100 members of Congress were able to be there and participate. Only 100. That's how secret that chamber was. Imagine that in the grand jury proceedings in the Clinton investigation or in the Jaworski, the Nixon investigation, imagine inviting 50 or 100 members of Congress to sit in on those. Imagine, as the president would like here, apparently the president insisting on having his lawyer in the grand jury because there was a case being investigated against him. Now, we had no grand jury here. Why is that? Why did we have no grand jury here? Why was there no special prosecutor here? Because the Justice Department said they're not going to look into this. Bill Barr's Justice Department said there's nothing to see here. If it were up to that Justice Department, you wouldn't know anything about this. That's why there was no grand jury. That's why we in the House had to do the investigative work ourselves. And yes, just like in the Nixon case, just like in the Clinton case, we used depositions. And you know what deposition rules we used? Those terribly unfair deposition rules we used? They were written by the Republicans. We used the same rules that the GOP House members used. That's how terribly unfair they were. My gosh, they used our rules. How dare they? How dare they? And now why did we do depositions? Because we didn't want one witness to hear what another witness was saying so they could either tailor their stories or know that they just had to admit so much and no more. It's how every credible investigation works. And this, the counsel can repeat all they like that the president didn't have a chance to participate, didn't have a chance to have counsel present in the Judiciary Committee or to offer evidence. They can say as much as they like. It doesn't make it any more true when they make the same false representation time and time again. It just makes it that much more deliberate and onerous. The president could have presented evidence in the Judiciary Committee. He chose not to. And there's a reason for that. There's a reason why the witnesses they've talked about aren't material witnesses. They don't go to the question of whether the president withheld the aid for this corrupt purpose. They don't go to any of that because they have no witnesses to absolve the president on the facts. You should want to see these documents. You should want to see them. You should want to know what these private emails and text messages have to say. If you're going to make a decision about the president's guilt or innocence, if you're going to make a decision about whether he should be removed from office, you should want to see what these documents say. Now, if you don't care, if you've made up your mind that he's the president of my party or for whatever reason, I'm not interested. And what's more, I don't really want the country to see this. Well, that's a wholly different matter. But that's not what your oath requires. It's not what your oath requires. The oath requires you to do impartial justice, which means to see the evidence. To see the evidence. That's all we're asking. Just don't blind yourself to the evidence. It's just, I yield back.
Thank you. The majority leader is recognized.
I send a motion to the desk to table the amendment and ask for the ayes and nays.
The question is on the motion to table. Is there sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. Mr. Burr. Aye. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Mr. Inzy, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Jones, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mrs. Loeffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young,
Are there any senators in the chamber wishing to vote or change his or her vote? If not, the yeas are 53, the nays are 47. The amendment is tabled. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain documents and records from the State Department, and I ask that it be read.
The clerk will read the amendment.
The senator from New York, Mr. Schumer, proposes an amendment, number 1285. At the appropriate place in the resolving clause, insert the following section. Notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedures and Practice in the Senate when sitting in impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the Secretary of Senate commanding him to produce, for the time period from January 1, 2019 to the present, all documents, communications, and other records within the possession, custody, or control of the Department of State, referring or relating to A, all meetings and calls between President Trump and the President of Ukraine, including documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21 and July 25, 2019 telephone calls, as well as the President's September 25, 2019 meeting with the President of Ukraine in New York. B, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF, including but not limited to all communications with the White House, Department of Defense, and the Office of Management and Budget, as well as the Ukrainian government's knowledge prior to August 28, 2019, of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance to Ukraine, including all meetings, calls, or other engagements with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine. C, all documents, communications, notes, and other records created or received by Secretary Michael R. Pompeo, Counselor T. Ulrich Breckbull, former Special Representative for Ukraine Negotiations Ambassador Kurt Volker, Deputy Assistant Secretary George Kent, then United States Embassy in Ukraine Chargé d'Affaires William B. Taylor, and Ambassador to the European Union Gordon Sondland, and other State Department officials relating to efforts to 1, solicit, request, demand, induce, persuade, or coerce Ukraine to conduct or announce investigations, 2, schedule, cancel, or withhold a White House meeting for Ukraine's president, or 3, hold and then release military and other security assistance to Ukraine. D, any meetings or proposed meetings at or involving the White House that relate to Ukraine, including but not limited to 1, President Zelensky's inauguration on May 20, 2019 in Kiev, Ukraine, including but not limited to President Trump's decision not to attend, to ask Vice President Pence to lead the delegation, directing Vice President Pence not to attend, and the subsequent decision about the composition of the delegation of the United States. 2, a meeting at the White House on or around May 23, 2019, involving, among others, President Trump, then Special Representative for Ukraine Negotiations Ambassador Kurt Volker, then Energy Secretary Rick Perry, and United States Ambassador to the European Union Gordon Sondland, as well as any private meetings or conversations with those individuals before or after the larger meeting. 3, meetings at the White House on or about July 10, 2019, involving Ukrainian officials Andriy Yermak and Alexander Danieluk, and United States government officials, including but not limited to then National Security Advisor John Bolton, Secretary Perry, Ambassador Volker, and Ambassador Sondland, to include at least a meeting in Ambassador Bolton's office and a subsequent meeting in the ward room. 4, a meeting at the White House on or around August 30, 2019, involving President Trump, Secretary of State Mike Pompeo, and Secretary of Defense Mark Esper. 5, a planned meeting, later canceled in Warsaw, Poland, on or around September 1, 2019, between President Trump and President Zelensky, and subsequently attended by Vice President Pence. And 6, a meeting at the White House on or around September 11, 2019, involving President Trump, Vice President Pence, and Mr. Mulvaney, concerning the lifting of the hold on security assistance for Ukraine. E, all communications, including but not limited to WhatsApp or text messages on private devices between current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, Ambassador Sondland, Ambassador Taylor, and Deputy Assistant Secretary Kent, and the following: President Zelensky, Andriy Yermak, or individuals or entities associated with or acting in any capacity as a representative, agent, or proxy for President Zelensky before and after his election. F, all records specifically identified by witnesses in the House of Representatives impeachment inquiry that memorialize key events or concerns, and any records reflecting an official response thereto, including but not limited to: 1, on August 29, 2019, cable sent by Ambassador Taylor to Secretary Pompeo; 2, an August 16, 2019, memorandum to file written by Deputy Assistant Secretary Kent; and 3, a September 15, 2019, memorandum to file written by Deputy Assistant Secretary Kent. G, all meetings or calls, including but not limited to all requests for or records of meetings or telephone calls, scheduling items, calendar entries, State Department visitor records, and email or text messages using personal or work-related devices between or among: 1, current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, and Ambassador Sondland; and 2, Rudolph W. Giuliani, Victoria Tensing, or Joseph DeGeneva; and H, the curtailment or recall of former United States Ambassador to Ukraine, Marie Masha Yovanovitch, from the United States Embassy in Kiev, including credible threat reports against her and any protective security measures taken in response. And 2, the Sergeant at Arms is authorized to utilize the services of the Deputy Sergeant at Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice.
The Majority Leader is recognized.
I now ask for a brief 10-minute recess before the parties are recognized to debate the Schumer amendment. At the end of the debate time, I'll again move to table the amendment as the timing of these votes are specified in the underlying resolution. So I ask consent that the Senate stand in recess subject to the call of the chair.
Without objection, the Senate is in recess. Senate will come to order. The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent?
Proponent, Mr. Chief Justice.
Thank you. And Mr. Cipollone?
Opponent.
Okay. And Mr. Schiff, you have an hour and will be able to reserve time for rebuttal.
Chief Justice Roberts, Senators, Counsel for the White House. I am Val Demings from the state of Florida. The House managers strongly support the amendment to issue subpoena for documents to the State Department. As we explain, the first article of impeachment charges the president with using the power of his office to solicit and pressure Ukraine to announce investigations that everyone in this chamber knows to be bogus. The president didn't even care if an investigation was actually conducted, just that it was announced. Why? Because this was for his own personal and political benefit. The first article further charges that the president did so with corrupt motives, and that his use of power for personal gain harmed the national security of the United States. As the second article of impeachment charges, the president sought to conceal evidence of this conduct. He did so by ordering his entire administration, every office, every agency, every official to defy every subpoena served in the House impeachment inquiry. No president in history has ever done anything like this. Many presidents have expressly acknowledged that they couldn't do anything like this. President Trump did not take these extreme steps to hide evidence of his innocence or to protect the institution of the presidency. As a career law enforcement officer, I have never seen anyone take such extreme steps to hide evidence allegedly proving his innocence. And I do not find that here today. The president is engaged in this cover-up because he is guilty, and he knows it. And he knows that the evidence he is concealing will only further demonstrate his culpability. Notwithstanding this effort to stonewall our inquiry, the House amassed powerful evidence of the president's high crimes and misdemeanors. 17 witnesses, 130 hours of testimony combined with the president's own admissions on phone calls and in public comments, confirmed and corroborated by hundreds of texts, emails, and documents. Much of that evidence came from patriotic, nonpartisan, decorated officials in the State Department. They are brave men and women who honored their obligations under the law and gave testimony required by congressional subpoena in the face of the president's taunts and insults. These officials described the president's campaign to induce and pressure Ukraine to announce political investigations, his use of $391 million of vital military aid, taxpayer money appropriated on a bipartisan basis by Congress as leverage to force Ukraine to comply, and his withholding of a meeting desperately sought by the newly elected president of Ukraine. This testimony was particularly compelling because the State Department is at the very center of President Trump's wrongdoing. We heard firsthand from diplomatic officials who saw up close and personal what was happening and who immediately sounded the alarms. Ambassador William Taylor, who returned to Ukraine in June of last year as acting ambassador, texted other State Department officials. I think it's crazy to withhold security assistance for help with a political campaign. Ambassador to the European Union, Gordon Sondland, who was delegated authority over Ukraine matters by none other than President Trump, testified, "We knew these investigations were important to the president, and we followed the president's orders." And David Holmes, a senior official at the U.S. Embassy in Kyiv, said it was made clear that some action on a Burisma Biden investigation was a condition for an Oval Office meeting. During their testimony, many of these State Department officials described specific documents, including text messages, emails, former diplomatic cables, and notes that would corroborate their testimony and shed additional light on President Trump's corrupt scheme. For instance, Ambassador Taylor, who raised concerns that military aid had been conditioned on the president's demand for political investigations, described a little notebook in which he would take notes on conversations he had with key officials. Ambassador Sondland referred by date and recipient to emails regarding the president's demand that Ukraine announce political investigations. As we'll see through emails that were sent to some of President Trump's top advisors, including acting White House Chief of Staff Mick Mulvaney, Secretary of State Michael Pompeo, and Secretary of Energy Rick Perry. Deputy Assistant Secretary of State George Kent, who oversaw Ukraine policy matters in Washington for the State Department, wrote at least 4 memos to file to document concerning conduct he witnessed or heard. And Ambassador Kurt Volker, the special representative for Ukraine negotiations, provided evidence that he and other American officials communicated with high-level Ukrainian officials, including President Zelensky himself, via text message and WhatsApp, about the president's improper demands and how Ukrainian officials would respond to them. Based on the testimony we received and on evidence that has since emerged, all of these documents and others that we will describe bear directly on the allegations set forth in the first article of impeachment. They would help complete our understanding of how the president's scheme unfolded in real time. They would support the conclusion that senior Ukrainian officials understood the corrupt nature of President Trump's demand, and they would further expose the extent to which Secretary Pompeo, Acting Chief of Staff Mick Mulvaney, and other senior Trump administration officials were aware of the president's plot and helped carry it out. We're not talking about a burdensome number of documents. We're talking about a specific, discrete set of materials held by the State Department. Documents the State Department has already collected in response to our subpoena, but has never produced. We know these materials exist. We know they are relevant, and we know the president is desperately trying to conceal them. As I will describe, the Senate should subpoena the following. Number one, WhatsApp and other text message communications. 2, emails. 3, diplomatic cables. And 4, notes. Given the significance and relevance of these documents, the House requested that they be provided. When these requests were denied, when our requests were denied, the House issued subpoenas commanding that the documents be turned over. But at the president's direction, the Department of State unlawfully defied that subpoena. And I stand here now, as I stand here now, the State Department has all these documents in its possession, but refuses, based on the president's order, to let them see the light of day. This is an affront to the House, which has full power to see these documents. It is an affront to the Senate, which has been denied a full record on which to judge the president's guilt or innocence, and it is an affront to the Constitution, which makes clearly that nobody, not even the president, is above the law. And it is an affront to the American people, who have a right to know what the president and his allies are hiding from them and why it is being hidden. In prior impeachment trials, this body has issued subpoenas requiring the recipient to hand over relevant documents. It must do so again here. And it must do so now at the beginning of the trial, not the end. Of course, the need for a Senate subpoena arises because, as I've noted, the president ordered the State Department to defy a subpoena from the House. At this point, I'd like to briefly describe our own efforts to get those materials. I'll then address in a more detailed fashion exactly what documents the State Department has hidden from the American people and why the Senate should require it to turn them over. On September 9th, exercising their Article I oversight authority, the House Investigating Committee sent a document request to the State Department. The committee sought materials related to the president's effort to pressure Ukraine to announce investigations into his political rival, as well as his dangerous, unexplained withholding of millions of dollars in vital military aid. After the State Department failed to produce any documents, the House Committee on Foreign Affairs issued a subpoena to the State Department on September 27th. In a letter on October 1st, Secretary Pompeo acknowledged receipt of the subpoena. At that time, he stated that he would respond to the committee's subpoena for documents by the return date, October 4th. But his response never came. Instead, on October 8th, President Trump's lawyer, writing on the president's behalf, issued a direction confirming that the administration would stonewall the impeachment inquiry. To date, the State Department has not produced a single document, not a single document in response to the congressional subpoena. But witnesses who testified indicated that the State Department had gathered all of the records and was prepared to provide them before the White House directed it to defy the subpoena. Notwithstanding this unlawful obstruction through the testimony of brave State Department employees, the House was able to identify with remarkable precision several categories of documents relevant to the first article of impeachment that are sitting right now. Right now, those documents are sitting right now at the State Department. I'd like to walk you through 4 key categories of documents that should be subpoenaed and which illustrate the highly relevant documents the State Department could produce immediately They could produce them immediately for this trial. The first category consists of WhatsApps and other text messages from State Department officials caught up in these events, including Ambassadors Sondland and Taylor, and also Deputy Assistant Secretary George Kent, all three of whom confirm in their testimony that they regularly use WhatsApp to communicate with each other and foreign government officials. As Deputy Assistant Secretary Kent explained, WhatsApp is a dominant form of electronic communication in certain parts of the world. We know that the State Department possesses the records of WhatsApp and text messages from critical eyewitnesses to these proceedings, including from Ambassador Sondland and Taylor and Deputy Assistant Secretary Kent. We know that the department is deliberately concealing these records at the direction of the president, and we know that they could contain highly relevant testimony about the president's plan to condition official presidential acts on the announcements of investigations for his own personal and political gain. We know this not only from testimony, but also because Ambassador Volker was able to provide us with a small but telling selection of his WhatsApp messages. Those records confirmed with a full review of these texts and WhatsApp messages from relevant officials would help to paint a vivid, firsthand picture of statements, decisions, concerns, and beliefs held by important players of events unfolding in real time. For example, thanks to Ambassador Volker's messages, we know that Ambassador Sondland, a key player in the president's pressure campaign, who testified in the House about a quid pro quo arrangement, texted directly with the Ukrainian president, President Zelensky. This image, produced by Ambassador Volker, appears to be a screenshot of a text message that Ambassador Sondland exchanged with President Zelensky about plans for the White House visit, the very same visit that President Zelensky badly needed, and that President Trump later withheld as part of the quid pro quo described by Ambassador Sondland in his testimony. This body and the American people have a right to know what else Ambassador Sondland and President Zelensky said in this and other relevant exchanges about the White House meeting or about the military aid and the president's demand. But we don't know exactly what was conveyed and when. We don't know if President Trump directed the State Department to conceal these vital records. These are records that the State Department would have otherwise turned over if not for the president's direction and desire to cover up his wrongdoing. To get a sense of why texts and WhatsApp messages are so vital, just consider whether another piece of evidence we've gleaned from Ambassador Volker's partial production. On July 10th, at the White House meetings, at which Ambassador Sondland pressured Ukrainian officials to announce investigations of President Trump's political opponents, a Ukrainian governmental official texted Ambassador Volker, "I feel that the key for many things is Rudy, and I am ready to talk with him at any time." This is evidence that immediately following Ambassador Sondland's ultimatum, Ukrainian officials recognized that they needed to appease Rudy Giuliani by carrying out the investigations. Of course, Mr. Giuliani had publicly confirmed that he was not engaged in foreign policy, but it was instead advancing his clients, the president's own personal interest. Further, in another text message exchange provided by Ambassador Volker, we see evidence that Ukraine understood President Trump's demands loud and clear. On the morning of July 25th, half an hour before the infamous call between President Trump and President Zelensky, Ambassador Volker wrote to a senior Ukrainian official heard from White House. Assuming President Z convinces Trump he will investigate, get to the bottom of what happened in 2016, we will nail down date for visit to Washington. Good luck. See you tomorrow. Kurt. Ambassador Sondland confirmed that this text accurately summarized the president's directive to him earlier that morning. After the phone call between President Trump and President Zelensky, the Ukrainian official responded pointedly. Phone call went well. He then discussed potential dates for a White House meeting. Then the very next day, Ambassador Volker wrote to Rudy Giuliani exactly the right messages as we discussed. These messages confirm Mr. Giuliani's central role, the premeditated nature of President Trump's solicitation of political investigation and the pressure campaign on Ukraine waged by Mr. Giuliani and senior officials at President Trump's direction. Again, this is just some of what we learned from Ambassador Volker's records. As you will see during this trial presentation, there were numerous WhatsApp messages in August while Ambassadors Volker and Sondland and Mr. Giuliani were pressuring President Zelensky's top aide to issue a statement announcing the investigations that President Trump wanted. And Ambassador Taylor's text that you saw earlier about withholding the aid further reveals how much more material there likely is that relates to the articles of impeachment. There can be no doubt that a full production of relevant texts and WhatsApp messages from other officials involved in Ukraine and in touch with Ukrainian officials, including Ambassador Sondland, Ambassador Taylor, and Deputy Assistant Secretary Kent, would further illuminate the malfeasance addressed in our first article. This leads to the second category of documents that the State Department is unlawfully withholding: emails involving key State Department officials concerning interactions with senior Ukrainian officials and relating to military aid, a White House meeting, and the president's demand for investigations into his rivals. For example, on July 19th, Ambassador Gordon Sondland spoke directly with President Zelensky about the upcoming July 25th call between President Trump and President Zelensky. Ambassador Sondland then sent an email updating key officials about Secretary Pompeo, including Secretary Pompeo, Acting White House Chief of Staff Mulvaney, and his senior advisor, Robert Blair. In this email, he noted that he prepared President Zelensky, who was willing to make the announcements of political investigations that President Trump desired. Secretary Perry and Mick Mulvaney then responded to Sondland, acknowledging they received the email and recommending to move forward with the phone call. That became the July 25 call between the presidents of the United States and Ukraine. We know all of this not because the State Department provided us with critical document, but instead because Ambassador Sondland provided us a reproduction of the email. In his public testimony, Ambassador Sondland quite correctly explained that this email demonstrated, quote, everyone was in the loop.
Everyone was in the loop. It was no secret. Everyone was informed via email on July 19th, days before the presidential call. As I communicated to the team, I told President Zelensky in advance that assurances to run a fully transparent investigation and turn over every stone were necessary in his call with President Trump.
Even viewed alone, this reproduced email is damning. It was sent shortly after Ambassador Sondland personally conveyed the president's demand for investigations to Ukrainians at the White House, leading several officials to sound alarms. It was sent just a few days before the July 25 call, where President Trump asked for a favor. And by itself, this email shows who was embroiled in President Trump's plan to pressure the Ukrainian president for his own political gain. But it's obvious that the full email chain and other related emails to this key time period would also be highly relevant. We don't have those emails because the State Department is hiding them at the direction of the president. The Senate should issue the proposed subpoena to ensure a complete record of these and other relevant emails. Any doubt that the State Department is concealing critical evidence from this body was resolved when the State Department was recently ordered to release documents, including emails pursuant to a lawsuit under the Freedom of Information Act. These documents are heavily redacted and are limited to a very narrow time period. But nevertheless, despite the heavy redactions, these highly limited glimpse into the State Department's secret record demonstrates that those records are full of information relevant to this trial. For example, several of these newly elected or released emails show multiple contacts between the State Department, including Secretary Pompeo and Mr. Giuliani throughout 2019. This is an important fact. Mr. Giuliani served as the president's point person in executing his corrupt scheme. Mr. Giuliani repeatedly emphasized that his role was to advance the president's personal agenda. The president's political interests, not to promote the national security interest of the United States. The fact that the president's private attorney was in contact at key junctures with the Secretary of State, whose senior officials were directed by the president to support Mr. Giuliani's efforts in Ukraine, is relevant, disturbing, and telling. For example, we know that on March 26th, as Mr. Giuliani was pursuing the president's private agenda in Ukraine, and just 1 week after The Hill published an article featuring Mr. Giuliani's Ukraine conspiracy theories, Secretary Pompeo and Mr. Giuliani spoke directly on the phone. That same week, President Trump's former personal secretary was asked by Mr. Giuliani's assistant for a direct connection to Secretary Pompeo. Based on these records, it is also clear that Secretary Pompeo was already actively engaged with Mr. Giuliani in early spring of 2019. And it also appears that these efforts were backed by the White House, given the involvement of President Trump's personal secretary. This body and the American people need to see these emails and other files at the State Department, fleshing out these exchanges and the details surrounding Mr. Giuliani's communications with Secretary Pompeo. Moreover, based on call records lawfully obtained by the House from this period, we know that from March 24th to March 30th, Mr. Giuliani called the White House several times and also connected with an unidentified number numerous times. These records show that on March 27th, Mr. Giuliani placed a series of calls to the State Department switchboard, Secretary Pompeo's assistant, and the White House switchboard in quick succession, all within less than 30 minutes. Obtaining emails and other documents regarding the State Department's leadership's interaction with President Trump's private lawyer in this period, when Mr. Giuliani was actively orchestrating the pressure campaign in Ukraine related to the sham investigation into Vice President Biden and the 2016 election, would further clarify the president's involvement and direction at this key juncture in the formation of a plot to solicit foreign interference into our election. We also know, based on recently obtained documents, excuse me, that Les Parmas, an associate of Rudy Giuliani, has assisted him in his representation of President Trump, that Giuliani likely spoke with Secretary Pompeo about Ukraine matters even earlier than previously understood. According to documents obtained from Mr. Parmas, Mr. Giuliani wrote in early February of 2019 that he apparently spoke with Secretary Pompeo about the removal of the U.S. ambassador in Ukraine, Marie Yovanovitch. Mr. Giuliani viewed her as an impediment to implementing the president's corrupt scheme and orchestrated a long-running smear campaign against her. Here's what Mr. Parmas said about this just last week.
Do you believe that part of the motivation to get rid of Ambassador Yovanovitch, to get her out of post, was because she was in the way of this effort to get the government of Ukraine to announce investigations of Joe Biden?
That was the only motivation.
That was the only motivation.
There was no other motivation.
These are just some of the email communications that we know. These are just some of the email communications that we know to exist, but there are undoubtedly more, including, for example, Ambassador Yovanovitch's requests for the State Department to issue a statement of support of her around the time that Mr. Giuliani was speaking directly with Secretary Pompeo. But that statement never came. The State Department has gathered these records and they are ready to be turned over pursuant to a subpoena from the Senate. It would not be a time-consuming or lengthy process to obtain them, and there are clearly important and relevant documents to the president's scheme. If we want the full and complete truth, then we need to see those emails. The Senate should also seek a third item that the State Department has refused to provide, and that's Ambassador Taylor's extraordinary first-person diplomatic cable to Secretary Pompeo dated August 29 and sent at the recommendation of the National Security Advisor, John Bolton, in which Ambassador Taylor strenuously objected to the withholding of military aid from Ukraine, as Ambassador Taylor recounted in his deposition.
Near the end of Ambassador Bolton's visit, I asked to meet him privately, during which I expressed to him my serious concern about the withholding of military assistance to Ukraine while the Ukrainians were defending their country from Russian aggression. Ambassador Bolton recommended that I send a first-person cable to Secretary Pompeo directly, relaying my concerns. I wrote and transmitted such a cable on August 29th, describing the folly I saw in withholding military aid to Ukraine at a time when hostilities were still active in the East and when Russia was watching closely to gauge the level of American support for the Ukrainian government. The Russians, as I said at my deposition, would love to see the humiliation of President Zelensky at the hands of the Americans. I told the Secretary that I could not and would not defend such a policy. Although I received no specific response, I heard that soon thereafter, the Secretary carried the cable with him to a meeting at the White House focused on security assistance for Ukraine.
While we know from Ambassador Taylor and Deputy Assistant Secretary Kent that the cable was received, we do not know whether or how the State Department responded, nor do we know if the State Department possesses any other internal records relating to this cable. This cable is vital for 3 reasons. First, it demonstrates the harm that President Trump did to our national security when he used foreign policy as an instrument of his own personal political gain. Second, on the same day the cable was sent, President Zelensky's senior aide told Ambassador Taylor that he was very concerned about the hold on military assistance. He added that the Ukrainians were just desperate at it to be released. In other words, President Trump's effort to use military aid to apply additional pressure on Ukraine was working. And finally, based on reporting by the New York Times, we now know that within days of Ambassador Taylor sending this cable, President Trump discussed Ukrainian security assistance with Secretary Pompeo, Defense Secretary Esper, and National Security Advisor Bolton. The investigation uncovered testimony that Secretary Pompeo brought Ambassador Taylor's cable to the White House. Perhaps it was during this meeting. There, perhaps prodded by Ambassador Taylor's cable, all 3 of them pleaded with the president to resume the crucial military aid. Yet the president refused. This body has a right to see Ambassador Taylor's cable as well as the other State Department records addressing the official response to it. Although it may have been classified at the time, the State Department could no longer claim that the topic of security assistance remains classified today in light of the president's decision to declassify his 2 telephone calls with President Zelensky and Mr. Mulvaney's public statements about security assistance. The 4th category of documents that the Senate should subpoena are contemporaneous first-person accounts from State Department officials who were caught up in President Trump's corrupt scheme. These documents, which were described in detail by Deputy Assistant Secretary Kent, Ambassador Taylor, and political officer David Holmes, would help complete the record and clarify how the president's scheme unfolded in real time and how the Ukrainians reacted. Mr. Kent wrote notes or memos to file at least 4 times, according to his testimony. Ambassador Taylor took extensive notes of nearly every conversation he had, some in a little notebook. And David Holmes, the embassy official in Ukraine, was a consistent note-taker of important meetings with Ukrainian officials.
Did you take notes of this conversation on September 1st with Ambassador Sondland?
I did.
And did you take notes related to most of the conversations, if not all of them, that you recited in your opening statement?
All of them, Mr. Goldman.
And you are aware, I presume, that the State Department has not provided those notes to the committee, is that right?
I am aware.
So we don't have the benefit of reviewing them to ask you these questions?
Correct. I understand that they may be coming sooner or later.
Well, we would welcome that.
The State Department never produced those notes. As another example, Deputy Assistant Secretary Kent testified about a key document that he drafted on August 16th, describing his concerns that the Trump administration was attempting to pressure Ukraine into opening politically motivated investigations.
I'd like to start with you, Mr. Kent. In your testimony, you said that you had, in mid-August, it became clear to me that Giuliani's efforts to gin up politically motivated investigations were now infecting U.S. engagement with Ukraine, leveraging President Zelensky's desire for a White House meeting. Mr. Kent, did you actually write a memo documenting your concerns that there was an effort underway to pressure Ukraine to open an investigation to benefit President Trump?
Yes, ma'am. I wrote a memo to the file on August 16th.
But we don't have access to that memo, do we?
I submitted it to the State Department subject to the September 27th subpoena.
And we have not received one piece of paper from the State Department relative to this investigation.
Deputy Assistant Secretary Kent also memorialized a September 15 conversation at which Ambassador Taylor described a Ukrainian official accusing America of hypocrisy for advising President Zelensky against investigating a prior Ukrainian president. Mr. Kent described that conversation during his testimony. He said, but the more awkward part of the conversation came after Special Representative Volker made the point that the Ukrainians, who had opened their authorities under President Zelensky, had opened investigations of former President Poroshenko. He didn't think that was appropriate. And then Andrei Yermak said, what? You mean the type of investigations you're pushing for us to do on Biden and Clinton? The conversation makes clear the Ukrainian officials understood the corrupt nature of President Trump's requests and therefore doubted American credibility on anti-corruption measures. Records of these conversations and other notes and memoranda by senior American officials in Ukraine would flesh out and help complete the record for the first article of impeachment. They would tell the whole truth and to the American people and to this body. You should require the State Department to provide them. To summarize, the Senate should issue the subpoena proposed in the amendment requiring the State Department to turn over relevant texts and WhatsApp messages, emails, diplomatic cables, and notes. These documents bear directly on the trial of this body, the trial that this body is required by the Constitution to hold. They are immediately relevant to the first article of impeachment. Their existence has been attested to by credible witnesses in the House. And the only reason we don't already have them is that the President has ordered his administration, including Secretary Pompeo, to hide them. The President's lawyers may suggest that the House should have sought these materials in court or awaited further lawsuits under the Freedom of Information Act, aka FOIA lawsuits. Any such suggestion is meritless. To start, the Constitution has never been understood to require such lawsuits, which has never occurred. It's never occurred in any previous impeachment. Moreover, the President has repeatedly and strenuously argued that the House is not even allowed to file a suit to enforce its subpoenas. And in the Freedom of Information Act cases, the administration has only grudgingly and slowly produced an extremely small set of materials, but has insisted on applying heavy and dubious redactions. FOIA lawsuits filed by third parties cannot serve as a credible alternative to congressional oversight. In fact, it is still alarming that the administration has produced more documents pursuant to the Federal Office of Information Act lawsuits by private citizens and entities than congressional subpoenas. Finally, as we all know, litigation would take an extremely long time, likely years, not weeks or months, while the misconduct of this president requires immediate attention. The misconduct of this president requires immediate attention if this body is truly committed to a fair trial. It cannot let the president play a game of keep away and dictate what evidence the senators can and cannot see bearing on his guilt or innocence. This body cannot permit him to hide all the evidence while disingenuously insisting on lawsuits that he doesn't actually think we can file, ones that he knows won't be resolved until after the election he is trying to cheat to win. Instead, to honor your oaths to do impartial justice, we urge each senator to support a subpoena to the State Department. And that subpoena should be issued now, at the beginning of the trial, rather than at the end, so these documents can be reviewed and their importance weighed by the parties, the Senate, and by the American people. That is how things work in every courtroom in the nation. And it is how they should work here, especially because the stakes, as you all know, are so high. The truth is there. Facts are stubborn things. The president is trying to hide it. This body should not surrender to his obstruction by refusing to demand a full record. That is why the House managers support this amendment. And Mr. Chief Justice, the House managers reserve the balance of our time.
Mr. Cipollone.
Thank you, Mr. Chief Justice. In the interest of time, I won't repeat all of the arguments that we've made already with respect to these motions. I would say one thing before I turn it over to my co-counsel. Mr. Schiff came here and said he's not asking you to do something he wouldn't do for himself. And the House manager said, we're not asking you to do our jobs for us. And Mr. Schiff came up here and he said, I call Ambassador Bolton. Remember Paul Harvey? It's time for the rest of the story. He didn't call him in the House. He didn't subpoena Ambassador Bolton in the House. I have a letter here from Ambassador Bolton's lawyer. He's the same lawyer that Charlie Kupperman hired. It's dated November 8th. He said, I write as counsel to Dr. Charles Kupperman and to Ambassador John Bolton in response to one, to the letter of November 5th from Chairman Schiff, Chairman Engel, and Acting Chair Maloney, the House chairs, withdrawing the subpoena to Dr. Kupperman. I mentioned that earlier. And to recent published reports announcing that the House chairs do not intend to issue a subpoena to Ambassador Bolton. He goes on and says, we are dismayed that the committees have chosen not to join us in seeking resolution from the judicial branch of this momentous constitutional question. And he ends the letter by saying, if the House chooses not to pursue through subpoena the testimony of Dr. Kupperman and Ambassador Bolton, let the record be clear. That is the House's decision, and they made that decision. They never subpoenaed Ambassador Bolton. They didn't try to call him in the House, and they withdrew the subpoena for Charles Kupperman before the judge could rule, and they asked that the case be mooted. And now they come here and they ask you to issue a subpoena for John Bolton. It's not right. I yield the remainder of my time to Mr. Sekulow.
Mr. Chief Justice, members of the Senate, the manager just said facts are a stubborn thing. Let me give you some facts. It's from the transcripts. Ambassador Sondland actually testified unequivocally that the president did not tie aid to investigations. Instead, that he acknowledged any leak he had suggested was based entirely on his own speculation, unconnected to any conversation with the president. Here's the question. What about the aid? Ambassador Volker says that they were tied, that the aid was not tied. Answer, I didn't say that they were conclusively tied either. I said I was presuming it. Question, okay, and so the president never told you they were tied. Answer, that is correct. Question, so your testimony and Ambassador Volker's testimony is consistent, and the president did not tie investigations, aid to investigations. Answer, that is correct. Ambassador Sondland also testified that he asked President Trump directly about these issues, and the president explicitly told him that he did not want anything from Ukraine. I want nothing. I want nothing. I want no quid pro quo. Tell Zelensky to do the right thing. Similar comments were made to Senator Johnson. Those are the facts. Stubborn, but that's the facts. No one is above the law. Here's the law. As every member of Congress knows, undoubtedly aware, separate from even state secret privileges is the presidential communication executive privilege to communications and performance of a president's responsibilities. The presidential communication privilege has constitutional origins. Courts have recognized a great public interest in preserving the confidentiality of conversations that take place in the president's performance of his official duties, because such confidentiality is needed to protect the effectiveness of the executive decision-making process. In Ray Seal cases, that was decided in the District of Columbia Court of Appeals. The Supreme Court found such a privilege necessary to guarantee the candor of presidential advisors and to provide a president and those who assist him with freedom to explore alternatives in the process of ultimately shaping policies and making decisions, and to do so in a way many would be unwilling to express except in private. For these reasons, presidential conversations are presumptively privileged. There's something else about this privilege. Communications made by presidential advisors, again, quoting courts, and by the way, lawyer lawsuits, we're talking about the impeachment of a president of the United States, duly elected. And the managers are complaining about lawyer lawsuits? The Constitution allows lawyer lawsuits. It's disrespecting the Constitution of the United States to even say that in this chamber. Lawyer lawsuits. Here's the law. Communications made by presidential advisors in the course of preparing advice for the president come under the presidential communications privilege, even when these communications are not made directly to the president. Even when they're not made directly to the president, advisor to advisor. Given the need to provide sufficient elbow room for advisors to obtain information from all knowledgeable sources, the privilege must apply both to communications which these advisors solicit and receive from others, as well as those they authorize themselves. The privilege must also extend to communications authored or received in response to solicitations by members of a presidential advisor's staff, since in many instances, advisors must rely on their staffs to investigate an issue and formulate advice given to the president. Lawsuits. The Constitution. A dangerous moment for America when an impeachment of a president of the United States is being rushed through because of lawyer lawsuits. The Constitution allows it if necessary. The Constitution demands it. if necessary. Thank you, Mr. Chief Justice.
Mrs. Demings, you have 13 minutes for rebuttal. Mr. Schiff.
Thank you, Mr. Chief Justice. Let me just respond to some of my colleagues' points, if I can. First, counsel said, well, the House would like to call John Bolton, but the House did not seek his testimony during its investigation. Well, first of all, we did. We invited John Bolton to testify, and you know what he told us? I'm not coming, and if you subpoena me, I will sue you. That was his answer, I will sue you. Mr. Bolton is represented by the same lawyer who represents Dr. Kupperman, who actually did sue us when he was subpoenaed. So we knew that John Bolton would make good on that threat. Now, Mr. Sekulow says something about lawyer lawsuits. Now, I have to confess I wasn't completely following the argument, but something about lawyer lawsuits, that we're against lawyer lawsuits. Well, I don't know what that means, but I can tell you this. The Trump Justice Department is in court in that case and in other cases arguing Congress cannot go to court to enforce its subpoenas. So when they say something about lawyer lawsuits and they say there's nothing wrong with the House suing to get these witnesses to show up, and they should have sued to get them to show up, their own other lawyers are in court saying the House has no such right. They're in court saying you can't have lawyer lawsuits. So that argument cannot be made in both directions. What's more, in the Kupperman litigation, in the McGahn litigation, which tested the same bogus theory of absolute immunity, in that lawsuit, once again involving the president's lawyer, Don McGahn, the one who was told to fire the special counsel and then to lie about it, that lawsuit, to get his testimony. Judge Jackson ruled on that very recently when they made the same bogus claim, he's absolutely immune from showing up. And the judge says that's nonsense. There's no support for that, none in the Constitution, none in the case law, that is made out of whole cloth. But you know, the judge said something more that was very interesting. Because what we urged John Bolton's lawyer is, you don't need to file a lawsuit. Dr. Kupperman, you don't need to file a lawsuit. There's one already filed involving Don McGahn that's about to be decided. So unless your real purpose here is delay, unless your real purpose here is to avoid testimony and you just wish to give the impression of a willingness to come forward, you just want to have the court's blessing, if that's really true, agree to be bound by the McGahn decision. Well, of course they were not willing, because they didn't want to testify. Now, for whatever reason, John Bolton is now willing to testify. I don't know why that is. Maybe it's because he has a book coming out. Maybe it's because it will be very hard to explain why he was unwilling to share important information with the Senate, that he couldn't show up for a House deposition or interview because he would need court permission to do it, but he can put it in a book. I don't know. I can't speak to his motivation. But I can tell you he's willing to come now, if you're willing to hear him. But of course, they weren't willing to be bound by that court decision in McGahn, but the court said something very interesting, because one of the arguments they had been making, one of the arguments that John Bolton's lawyer had been making as to why they needed their own separate litigation was, well, John Bolton and Dr. Kupperman, they're national security people, and Don McGahn is just the White House counsel. No offense to the White House counsel, but apparently you have nothing to do with national security. And so they couldn't be bound by what the court in the McGahn case said. Well, the judge in the McGahn case said, this applies to national security stuff too. So we do have a court decision, and what's more, we have the court decision in the Harriet Miers case in the George W. Bush administration, where likewise the court made short shrift of this claim of absolute, complete, and total immunity. Now, there were also comments made about Ambassador Volker's testimony by Mr. Sekulow. And it was along these lines. Ambassador Volker said the president never told him that the aid was being conditioned or the meeting was being conditioned on Ukraine doing these sham investigations. So, well, I guess that's case closed. Unless the president told everyone, called them into their office and said, hey, I'm going to tell you now, and then I'm going to tell you now. If he didn't tell everyone, I guess it's case closed. Well, you know who the president did tell, among others? He told Mick Mulvaney. Mick Mulvaney went out on national television and said, yes, they discussed it. This investigation, this Russian narrative that it wasn't Ukraine that intervened in 2016, it was Russia. I'm sorry, it wasn't Russia, it was Ukraine. Yes, that bogus 2016 theory, yes, they discussed it. Yes, that was part of the reason why they withheld the money. And when reporters said, well, you're kind of describing a quid pro quo, his answer was, yeah, get used to it or get over it. We do it all the time. Now, they haven't said they want to hear from Mick Mulvaney. I wonder why. The president did talk to Mick Mulvaney about it. Wouldn't you like to hear what Mick Mulvaney has to say? I mean, if you really want to get to the bottom of this, if they're really challenging the fact that the president conditioned $400 million of military aid to an ally at war, if Mick Mulvaney has already said publicly that he talked to the president about it, and this is part of the reason why, don't you think you should hear from him? Don't you think impartial justice requires you to hear from him? Now, counsel also referred to Ambassador Sondland, and Sondland saying, well, the president told me there was no quid pro quo. Now, of course, at the time the president said to Sondland, no quid pro quo, he became aware of the whistleblower complaint, presumably by Mr. Cipollone. And so the president knew that this was going to come to light. On the advice, apparently, of Mr. Cipollone, or maybe others, the Director of National Intelligence, for the first time in history, withheld a whistleblower complaint from Congress, its intended recipient. But nonetheless, the White House was aware of that complaint. We launched our own investigations. Yes, they got caught, and in the midst of being caught, what does he say? It's called a false exculpatory. For those people at home, that's a fancy word of saying it's a false, phony alibi. No quid pro quo. He wasn't even asked the question, was there a quid pro quo? He just blurted it out. That's the defense, that the president denies it. And what's more interestingly, he didn't tell you about the other half of that conversation where the president says no quid pro quo. He says no quid pro quo, but Zelensky needs to go to the mic, and he should want to do it, which is the equivalent of saying no quid pro quo except the quid pro quo. And here's what the quid pro quo is. He needs to go to the mic, and he should want to do it. That's their alibi? They didn't also mention, of course, and you'll hear about this during the trial if we have a real trial. Ambassador Sondland also said that we're often asked, was there a quid pro quo? The answer is yes, there was a quid pro quo. There was an absolute quid pro quo. And what's more, when it came to the military aid, it was as simple as 2 + 2. Well, I'll tell you something. We're not the only people who can add up 2 + 2. There are millions of people watching this can add up 2 + 2 also. When the president tells his chief of staff we're holding up the aid because of this, as the chief of staff admitted, when the president gives no plausible or other explanation for holding up aid that you all and we all supported and voted on a very bipartisan way, has no explanation for it, when in that call he never brings up corruption except the corruption he wants to bring about, it doesn't take a genius, it doesn't take Albert Einstein to add 2 + 2. It equals 4. In this case, it equals guilt. Now, you're going to have 16 hours to ask questions. You're going to have 16 hours. That's a long time to ask questions. Wouldn't you like to be able to ask about the documents in that 16 hours? Would you like to be able to say, counsel for the president, what did Mick Mulvaney mean when he emailed so-and-so and said such and such? What's your explanation for that? Because that seems to be pretty damning evidence of exactly what the House is saying here. What's your explanation of that, Mr. Sekulow? What's your explanation? Wouldn't you like to be able to ask about the documents? Or ask the House, Mr. Schiff, What about this text message? Doesn't that suggest such as what the president is arguing? Wouldn't you like to be able to ask me that question or my colleagues? I think you would. I think you should. But the backwards way this resolution is drafted, you get 16 hours to ask questions about documents you've never seen. And then you know what's more? If you do decide at that point, after the trial is essentially over, that you do want to see the documents after all, and the documents are produced, you don't get another 16 hours. You don't get 16 minutes. You don't get 16 seconds to ask about those documents. Does that make any sense to you? Does that make any sense at all? I'll tell you something I'd like to know that may be in the documents. You probably heard more about the three amigos. My colleagues mentioned two of the three amigos, Amigo Volker and Amigo Sondland. These are two of the three people that the president put in charge of Ukraine policy. The third amigo is Secretary Rick Perry, the former Secretary of Energy. Well, we know from Amigo Sondland's testimony that he was certainly in the loop and knew exactly all about this scheme. And we know from Ambassador Volker's testimony and his text messages and his WhatsApps that amigo was in the loop. What about the third amigo? Wouldn't you like to know if the third amigo was in the loop? Now, as my colleagues will explain, when we get to the Department of Energy records, that, well, surprisingly, we didn't get those either. But any communication between the Department of Energy and the Department of State is covered by this amendment. Wouldn't you like to know? Don't you think the American people have a right to know what the third amigo knew about this scheme? I'd like to know. I think you should be able to ask questions about it in your 16 hours. At the end of the day, I guess I'll finish with something Mr. Sekulow said. He said, this was a dangerous moment because we're trying to rush through this somehow. It is a dangerous moment, but we're not trying to rush through this trial. We're actually trying to have a real trial here. It's the president that's trying to rush through this. And I have to tell you that whatever you decide here, maybe this is wasted breath and maybe it's already decided, but whatever you decide here, I don't know who the next president's going to be. Maybe it'll be someone in this chamber. But I guarantee you this, whoever that next president is, whether they did something right or they did something wrong, there's going to come a time where you in this body are going to want to subpoena that president and that administration. You're going to want to get to the bottom of serious allegations. Are you prepared to say that that president can simply say, I'm going to fight all subpoenas? Are you prepared to say and accept that president saying, I have absolute immunity. You want me to come testify? Senator, you want me to come and testify? No, no, I have absolute immunity. You can subpoena me all you like. I'll see you in court. And when you get to court, I'm going to tell you, you can't see me in court. Are you prepared for that? That's what the future looks like. Don't think this is the last president if you allow this to happen. That's going to allow this to take place.
Your time
Mr.
is
Justice,
expired.
I yield back. I thank you.
The majority leader is recognized.
To table the amendment.
The question is on the motion to table.
And ask for the ayes and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Mr. Enzi, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Jones, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mrs. Loeffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
there anyone wishing to vote or change their vote? If not, the yeas are 53, the nays 47. The motion to table is agreed to. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain office and management and budget documents, and I ask that it be read.
The clerk will read the amendment.
The senator from New York, Mr. Schumer, proposes an amendment number 1286. At the appropriate place in the resolving clause, insert the following. Section, notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the acting director of the Office of Management and Budget, commanding him to produce for the time period from January 1st, 2019 to the present all documents, communications, and other records within the possession, custody, or control of the Office of Management and Budget, referring or relating to A, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, referred to in this section as USAI, and foreign military financing, referred to in this section as FMF, including but not limited to 1, communications among, between, or referring to Director Michael John Mick Mulvaney, Assistant to the President Robert Blair, Acting Director Russell Vaught, Associate Director Michael Duffy, or any other Office of Management and Budget employee. 2, communications related to requests by President Trump for information about Ukraine's security or military assistance and responses to those requests. 3, communications related to concerns raised by any Office of Management and Budget employee related to the legality of any hold on foreign assistance, military assistance, or security assistance to Ukraine. 4, communications sent to the Department of State regarding a hold or block on congressional notifications regarding the release of FMF funds to Ukraine. 5, communications between 1, officials at the Department of Defense, including but not limited to Undersecretary of Defense Elaine McCusker, and 2, Associate Director Michael Duffy, Deputy Associate Director Mark Sandy, or any other Office of Management and Budget employee. 6, all draft and final versions of the August 7th, 2019 memorandum prepared by the National Security Division, International Affairs Division, and Office of General Counsel of the Office of Management and Budget about the release of foreign assistance, security assistance, or security assistance to Ukraine. 7, the Ukrainian government's knowledge prior to August 28, 2019, of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance to Ukraine, including all meetings, calls, or other engagement with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine. B, communications, opinions, advice, counsel, approvals, or concurrences provided by any employee in the Office of Management and Budget regarding the actual or potential suspension, withholding, delaying, freezing, or releasing of security assistance to Ukraine, including legality under the Impoundment Control Act. C, Associate Director Michael Duffy taking over duties related to apportionments of USAI FMF from Deputy Associate Director Mark Sandy or any other Office of Management and Budget employee. D, all meetings related to the security assistance to Ukraine, including but not limited to interagency meetings on July 18th, 2019, July 23rd, 2019, July 26th, 2019, and July 31st, 2019, including any directions provided to staff participating in those meetings and any readouts from those meetings. E, the decision announced on or about September 11, 2019, to release appropriated foreign assistance, military assistance, or security assistance to Ukraine, including but not limited to any notes, memoranda, documentation, or correspondence related to the decision. F, all draft and final versions of talking points related to the withholding or release of foreign assistance, military assistance, or security assistance to Ukraine, including communications with the Department of Defense related to concerns about the accuracy of the talking points, and G, all meetings and calls between President Trump and the President of Ukraine, including documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21st and July 25th, 2019 telephone calls, as well as the President's September 25th, 2019 meeting with the President of Ukraine in New York, and 2, the Sergeant at Arms is authorized to utilize the services of the Deputy Sergeant at Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice.
The Majority Leader is recognized.
First, a scheduling note. As the parties are ready to debate this amendment, I suggest we go ahead, get through the debate, and vote before we take a 30-minute recess for dinner. And I would remind everyone that I'll be moving to table the amendment, and it's also important to remember that both evidence and witnesses are addressed in the underlying resolution.
Thank you. The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent of the motion? Proponent. Mr. Cipollone, are you a proponent or opponent? Then, Mr. Schiff, your side will proceed first, and you will be able to reserve time for rebuttal. Thank you.
Before I begin, Mr. Chief Justice, the House managers will reserve the balance of our time to respond to the counsel for the President. Mr. Chief Justice, Senators, counsel for the President, and the American people, I am Jason Crow from the great state of Colorado. The House managers strongly support this amendment to subpoena key documents from the Office of Management and Budget, or OMB. These documents go directly to one of President Trump's abuses of power, his decision to withhold vital military aid from a strategic partner that's at war to benefit his own personal re-election campaign. But why should that matter? Why should anybody care? Why should I care? Before I was a member of Congress, I was an American soldier, serving in Iraq and Afghanistan. And although some years have passed since that time, there are still some memories that are seared in my brain. One of those memories was scavenging scrap metal on the streets of Baghdad in the summer of 2003 that we had to bolt onto the side of our trucks because we had no armor to protect against roadside bombs. So when we talk about troops not getting the equipment that they need when they need it, it's personal to me. To be clear, here we are talking of $391 million of taxpayer money intended to protect our national security by helping our strategic partner, Ukraine, fight against Vladimir Putin's Russia, an adversary of the United States. But the president could not carry out this scheme alone. He needed a lot of people to help him. And that's why we know as much about it as we do today. But there is much more to know. And that's what trials are for, to get the full picture. We know there's more because President Trump needed the Office of Management and Budget to figure out how to stop what should have been a routine release of funds mandated by Congress. A release of funds that was already underway. But the people in this chamber don't need me to tell you that, because 87 of you in this room voted for those vital funds to support our partner, Ukraine. Witnesses before the House testified extensively about OMB's involvement in carrying out the hold. It was OMB that relayed the president's instructions and implemented the hold. And it was OMB that scrambled to justify the freeze. OMB has key documents that President Trump has refused to turn over to Congress. It is time to subpoena those documents. These documents would provide insight into critical aspects of the military aid hold. They would show the decision-making process and motivations behind President Trump's freeze. They would reveal the concerns expressed by career OMB officials, including lawyers, that the hold was violating the law. They would expose the lengths to which OMB went to justify the president's hold. They would reveal concerns about the impact of the freeze on Ukraine and U.S. national security. And they would show that senior officials repeatedly attempted to convince President Trump to release the hold. In short, they would show exactly how the president carried out the scheme to use our national defense funds to benefit his personal political campaign. We are not speculating about the existence of these documents. We are not guessing what the documents might show. During the course of the investigation in the House, witnesses who testified before the committees identified multiple documents directly relevant to the impeachment inquiry that OMB continues to hold to this day. We know these documents exist, and we know that the only reason we do not have them is because the president directed OMB not to produce them, because he knows what they would show. To demonstrate the significance of the OMB documents and the value they would provide in this trial, I would like to walk you through some of what we know exists, but which the Trump administration has refused to turn over. As we have discussed, the Trump administration has refused to turn over any documents to the House in response to multiple subpoenas and requests. Based on what is known from the testimony and the few documents that have been obtained through public reporting and lawsuits, it's clear that the president is trying to hide this evidence because he is afraid of what it would show. Documents offer stark examples of the chaos and confusion that the president's scheme set off across our government, and they make clear the importance of the documents that are still being concealed by the president. We know that OMB has documents that reveal that as early as June, the president was considering holding military aid for Ukraine. The president began questioning military aid to Ukraine after Congress appropriated and authorized the money. $250 million in DoD funds and $141 million in State Department funds. This funding had wide bipartisan support because, as many witnesses testified, providing military aid to Ukraine to defend itself against Russian aggression also benefits our own national security. Importantly, the president's questions came weeks after the Department of Defense already certified that Ukraine had undertaken the anti-corruption reforms and other measures mandated by Congress as a condition for receiving that aid. So there is a process for making sure that the funds make it to the right place and to the right people, a process that has been followed every year that we have been providing that security assistance to Ukraine, including the first 2 years under the Trump administration. Nonetheless, the President's questions came days after DOD issued a press release on June 18th announcing it would provide its $250 million portion of the taxpayer-funded military aid to Ukraine. According to public reporting, the day after DOD's press release, a White House official named Robert Blair called OMB's acting director, Russell Vought, to talk about the military aid to Ukraine. According to public reports, Mr. Blair told Vought, quote, "We need to hold it up." OMB has refused to produce any documents related to this conversation. The Senate can get them by passing the amendment and issuing a subpoena. But there's more. The same day Blair told Vought to hold up the aid, Michael Duffy, a political appointee at OMB who reports to Vought, emailed Deputy Undersecretary of Defense Elaine McCusker and told her that the President had questions about the aid. Duffy copied Mark Sandy, a career official at OMB, who told us about the email in his testimony before the House. Like all others, that email was not produced by the Trump administration in the House impeachment investigation. We know this email exists, however, because in response to a Freedom of Information Act lawsuit, the Trump administration was forced to release a redacted email consistent with Sandy's description. But OMB provided none of those documents to the House. With this proposed amendment, the Senate has an opportunity to obtain and review the full record that could further demonstrate how and why the President was holding the aid. These documents would also shed light on the President's order to implement the hold. On July 3rd, the State Department told various officials that OMB blocked it from dispensing $141 million in aid. OMB had directed the State Department not to send a notification to Congress about spending the money. And without that notification, the aid was effectively blocked. Why did OMB block the congressional notification? Who told them to do it? What was the reason? The Senate would get those answers if it issued this subpoena. But there's more. On July 12th, Blair, the White House official who had called Vought on June 19th and said, quote, "We need to hold it up," then sent an email to Duffy at OMB. Blair said, quote, "The President is directing a hold on military support funding for Ukraine." We haven't seen this email. The only reason we know about it is from the testimony of Mark Sandy, the career OMB official who followed the law and complied with his subpoena. As you can see from the transcript excerpt in front of you, Sandy testified that the July 12th email did not mention concerns about any other country or any other aid packages, just Ukraine. So of the dozens of countries where we provide aid and support, the President was only concerned about one of them, Ukraine. Why? Well, we know why. But OMB has still refused to provide a copy of this July 12 email and has refused to provide any documents surrounding it, all because the President told OMB to continue to hide the truth from Congress and the American people. What was he afraid of? A subpoena issued by the Senate would show us. OMB also has documents about a key series of meetings triggered by the President's order to hold the military aid. In the second half of July, the National Security Council convened a series of interagency meetings about the President's hold on military aid. OMB documents would show what happened during those meetings. For example, on July 18th, the National Security Council staff convened a routine interagency meeting to discuss Ukraine policy. During the meeting, it was the OMB representative who announced that President Trump placed a hold on all military aid to Ukraine. Ambassador Bill Taylor, our most senior diplomat to Ukraine, participated in that meeting. And he described his reaction at his open hearing.
In a regular NSC secure video conference call on July 18th, I heard a staff person from the Office of Management and Budget say that there was a hold on security assistance to Ukraine, but could not say why. Toward the end of an otherwise normal meeting, a voice on the call, the person was off screen, said that she was from OMB, and her boss had instructed her not to approve any additional spending on security assistance for Ukraine until further notice. I and others sat in astonishment. The Ukrainians were fighting Russians and counted on not only the training and weapons, but also the assurance of U.S. support. All that the OMB staff person said was that the directive had come from the President to the Chief of Staff to OMB. In an instant, I realized that one of the key pillars of our strong support for Ukraine was threatened.
It's hard to believe that OMB would not have any documents following this bombshell announcement. It surely does. It was the agency that delivered the shocking news to the rest of the U.S. government that the President was withholding the vital military aid from our partner. And we would see these documents if the Senate issued a subpoena. The July 18th meeting was just the first in a series of meetings where OMB held the line and enforced the President's hold on the aid. But there was a second meeting on July 23rd, where we understood agencies raised concerns about the legality of OMB's hold on the aid. And then a third meeting at a more senior level on July 26th. Witnesses testified that at that meeting, OMB struggled to offer an explanation for the President's hold on the aid. And then a fourth meeting on July 31st, where the legal concerns about the hold were raised. At each of these meetings, there was confusion about the scope and the reasons for the hold. Nobody seemed to know what was going on. But that was exactly the point. All of the agencies, except OMB, which was simply conveying the President's order, supported the military aid and argued for lifting the hold. OMB did not produce a single document providing information about its participation, preparation, or follow-up from any of these meetings. Did these OMB officials come prepared with talking points for these meetings? Did OMB officials take notes during any of these meetings? Did they exchange emails about what was going on? Did OMB discuss what reasons they could give everyone else for the hold? By issuing this subpoena, the Senate can find out the answers to all of those questions and others like them. The American people deserve answers. OMB documents would also reveal key facts about what happened on July 25th. On July 25th, President Trump conducted his phone call with President Zelensky, during which he demanded a favor. This favor was for Ukraine to conduct an investigation to benefit the President's re-election campaign. That call was at 9 a.m. Just 90 minutes after President Trump hung up the phone, Duffy, the political appointee at OMB, who is in charge of national security programs, emailed DOD to, quote, formalize, end quote, the hold on the military aid. Just 90 minutes after President Trump's call, a call in which the President had asked for a favor. That email is on the screen in front of you. We have a redacted copy of this email because it was recently released through the Freedom of Information Act. It was not released by the Trump administration in response to the House's subpoena. In this email, Duffy told the DOD officials that based on the guidance he had received, they should, quote, hold off on any additional DOD obligations of these funds. He added that the request was, quote, sensitive, and that they should keep this information closely held, meaning don't tell anybody about it. Why did Duffy consider the information sensitive? Why didn't he want anyone to learn about it? Answers to those questions may be found in OMB emails, emails that we could all see if you issue a subpoena. But there's more. Remember, the administration needed to create a way to stop funding that was already underway. The train had already left the station. And something like this had never been done before. Later in the evening of July 25th, OMB found a way, even though DOD had already notified Congress that the funds would be released. Here is how the scheme worked. OMB sent DOD a funding document that included a carefully worded footnote directing DOD to hold off on spending the funds. Quote, to allow for an interagency process to determine the best use, end quote. Remember that language. To allow for an interagency process to determine the best use. Let me explain that. The footnote stated that this, quote, brief pause would not prevent DOD from spending the money by the end of the fiscal year, which was coming up on September 30th. OMB had to do this because it knew that not spending the money was illegal. And they knew that DOD would be worried about that. And they were right. DOD was worried about it. Mr. Sandy testified that in his 12 years of experience at OMB, he could not recall anything like this ever happening before. The drafting of this unusual funding document and the issuance of the document must have generated a significant amount of email traffic, memos, and other documentation at OMB. Memos, email traffic, and documentation that we would all see if the Senate issued a subpoena. So what was the result from the series of events on July 25th? Where was Mr. Duffy's guidance to implement the hold coming from? Why was the request sensitive? What was the connection between OMB's direction to DOD and the call President Trump had with President Zelensky just 90 minutes before? Did agency officials communicate about the questions coming from Ukrainian officials? The American people deserve answers. A subpoena would provide those answers. OMB documents also would reveal information about the decision to have a political appointee take over Ukraine funding responsibility. The tensions and chaos surrounding the freeze escalated at the end of July when Duffy, a political appointee at OMB, with no relevant experience in funding approvals, took authority for releasing military aid to Ukraine away from Sandy, a career OMB official. Sandy could think of no other example of a political appointee taking on this responsibility. Sandy was given no reason other than that Mr. Duffy wanted to be, quote, more involved in daily operations, end quote. During his deposition, Sandy confirmed that he was removed from the funding approval process after he had raised concerns to Duffy about whether the hold was legal under the Impoundment Control Act. Needless to say, OMB has refused to turn over any documents or communications involving that decision to replace Mr. Sandy. Why did Duffy, a political appointee with no relevant experience in this area, take over responsibility for Ukraine funding approval? Was the White House involved in that decision? Was Sandy removed because he had expressed concerns about the legality of the hold? By August 7th, people in our government were worried. And when people in the government get worried, sometimes what they do is they draft memos. Because when they're concerned about getting caught up in something that doesn't seem right, they don't want to be a part of it. So on that day, Mark Sandy and other colleagues at OMB drafted and sent a memo about Ukraine military aid to Acting Director Vaught. According to Sandy, the memo advocated for the release of the funds. It said that the military aid was consistent with American national security interests. It would help to oppose Russian aggression, and it was backed by strong bipartisan support. But President Trump did not lift the hold. Over the next several weeks, OMB continued to issue funding documents that kept kicking the can down the road, supposedly to allow for more of this, quote, interagency process, while inserting those footnotes throughout the apportionment documents stating that the delay wouldn't affect the funding. But here's the really shocking part. There was no interagency process. They made it up. It had ended months before. They made it up because nobody could say the real reason for the hold. In total, OMB issued 9 of these documents between July 25th and September 10th. Did the White House respond to OMB's concerns and recommendation to release the aid? Did the White House instruct OMB to continue creating a paper trail in an effort to justify the hold? Who knew what and when? OMB documents would shed light on OMB's actions as the president's scheme unraveled. Did the White House direct OMB to continue issuing the hold? What was OMB told about the president's reasons for releasing the hold? What communications did OMB officials have with the White House around the time of the release? As the president's scheme unraveled, did anyone at OMB connect the dots about the real reason for the hold? The OMB documents would shed light on all of these questions, and the American people deserve answers. I remember what it feels like to not have the equipment you need when you need it. Real people's lives are at stake. That's why this matters. We need this information so we can ensure that this never happens again. Eventually, this will all come out. We will have answers to these questions. The question now is whether we'll have them in time and who here will be on the right side of history.
Mr. Sekulow?
Mr. Chief Justice, the House managers reserve the balance of our time for an opportunity to respond to the President's argument.
Thank you. Mr. Sekulow?
Thank you, Mr. Chief Justice, members of the Senate. Manager Crow, you should be happy to know that the aid that was provided to Ukraine over the course of the President's administration included lethal weapons. Those were not provided by the previous administration. The suggestion that the Ukraine failed to get any equipment is false. The security assistance was not for funding Ukraine over the summer of 2019. There was no lack of equipment due to the temporary pause. It was future funding. The Ukraine Deputy Minister of Defense, who oversaw U.S. aid shipments, said the hold came and went so quickly they did not notice any change. Undersecretary of State David Hale explained the paused aid was future assistance, not to keep the Army going now. So the made-up narrative that security assistance was conditioned on Ukraine taking some action on investigations is further disproved by the straightforward fact that the aid was delivered on September 11, 2019, without Ukraine taking any action on any investigation. It's interesting to note that the Obama administration withheld $585 million of promised aid to Egypt in 2013. But the administration's public message was that the money was not officially on hold, as technically it was not due until September 30th, the end of the fiscal year. so they didn't have to disclose the halt to anyone. Sounds like this may be a practice of a number of administrations. In fact, to the president, this president has been concerned about how aid is being put forward. So there have been pauses on foreign aid in a variety of contexts. In September of 2019, the administration announced that it was withholding over $100 million in aid to Afghanistan over concerns about government corruption. In August of 2019, President Trump announced that the administration and Seoul were in talks to substantially increase South Korea's share of the expense of U.S. military support for South Korea. In June, President Trump cut or paused over $550 million in foreign aid to El Salvador, Honduras, and Guatemala because those countries were not fairly sharing the burdens of preventing mass migration to the United States. This is not the only administration. As I said, President Obama withheld hundreds of millions of dollars of aid to Egypt. To be clear, and I want to be clear, Ambassador Yovanovitch herself testified that our policy actually got stronger under President Trump, largely because, unlike the Obama administration, quote, this administration made the decision to provide lethal weapons to Ukraine to help Ukraine fend off Russian aggression. She testified in a deposition before your various committees that, and actually I felt that in the 3 years that I was there, partly because of my efforts, but also the interagency team and President Trump's decision to provide lethal weapons to Ukraine, that our policy actually got stronger. Deputy Assistant Secretary Kent, his name's come up a couple of times, agreed that javelins are incredibly effective weapons at stopping armored advance, and the Russians are scared of them. Ambassador Volker explained that President Trump approved each of the decisions made along the way, and as a result, America's policy towards Ukraine strengthened. So when we want to talk about facts, go to your own discovery and your own witnesses that you called. This all supposedly started because of a whistleblower. Where is that whistleblower?
The House managers have 35 minutes remaining.
Mr. Chief Justice, at war, time matters. Minutes and hours can seem like years. So the idea that, well, it made it there eventually just doesn't work. And yes, the aid was provided. It was provided by Congress, this Senate, in the House of Representatives with the President's signature. The Congress is the one that sends the aid. And millions of dollars of this aid would have been lost because of the delay had Congress not actually passed another law that extended that deadline to allow the funds to be spent. Let me repeat that. The delay had jeopardized the expenditure of the money to such an extent that Congress had to pass another law to extend the deadline so that the money and the equipment got to the people on the front lines. Need I also reiterate the supposed interagency process, the concerns that the President and his counsel continue to raise about corruption and making sure that the process went right. There was no interagency process. The whole thing was made up. It was a phantom. There was a delay, and delays matter. Mr. Chief Justice, I reserve the balance of my time for Mr. Schiff.
Mr. Schiff?
Thank you, Mr. Chief Justice. Just a few additional points I'd like to make on this amendment and on my colleagues' arguments. First of all, Mr. Sekulow makes the point that the aid ultimately got released. They ultimately got the money, right? Yes, they got the money after the president got caught, after the president was forced to relieve the hold on the aid, after he got caught, yes. But even then they had held on to the aid so long that it took a subsequent act of Congress to make sure it could all go out the door. So what, is the president supposed to get credit for that, that we had to intervene because he withheld the aid so long? And that's the only reason Ukraine got all of the aid that we'd approved in the first place? My colleagues have glossed over the fact that what they did was illegal, that the GAO, an independent watchdog agency, found that that hold was illegal. So it not only violated the law, it not only took an act of Congress to make sure they ultimately got the aid. This is supposed to be the defense to why you shouldn't see the documents? Is that what we're to believe? Now, counsel also says, well, you know, he's not the first president to withhold aid, and that's true. After all, counsel says, well, President Obama withheld aid to Egypt. Yes, at the urging of members of Congress. Senators McCain and Graham urged that that aid be withheld, and why? Because there was a revolution in Egypt after it was appropriated. That wasn't something that was hidden from Congress. That was a pretty darn good reason to think, do we still want to give aid to this government after this revolution? We're not saying that aid has never been withheld. That's absurd. But I would hope and expect this is the first time aid has been withheld by a president of the United States to coerce an ally at war to help him cheat in the next election. I think that's a first. But what we do here may determine whether it's the last. And one other thing about this pause in aid, right? The argument, well, no harm, no foul. Okay, you got caught, they got the aid. What's the big deal? Well, as we heard during the trial, it's not just the aid. I mean, the aid is obviously the most important thing. As Mr. Crow mentioned, you know, without it you can't defend yourself, and we'll have testimony about just what kind of military aid the president was withholding. But we also had testimony that it was the fact of the aid itself that was so important to Ukraine, the fact that the United States had Ukraine's back. And why? Because this new president of Ukraine, this new untested former comedian, president of Ukraine, at war with Russia, was going to be going into a negotiation with Vladimir Putin with an eye to ending that conflict. And whether he went into that negotiation from a position of strength or a position of weakness would depend on whether we had his back. And so when the Ukrainians learned and the Russians learned that the President of the United States did not have his back, was withholding this aid, what message do you think that sent to Vladimir Putin? What message do you think it sent to Vladimir Putin when Donald Trump wouldn't let Vladimir Zelensky, our ally, in the door at the White House, but would let the Russian foreign minister? What message does that send? So it's not just the aid, it's not just when the aid is delivered, it's not just if all of the aid is delivered, it's also what message does the freeze send to our friend, and even more importantly, to our foe. And the message it sent was a disaster. Was a disaster. Now, you might ask yourself, because counsel has said, hey, President Trump has given lethal weapons to Ukraine. You might ask yourself, if the president was so concerned about corruption, why did he do that in 2017? And why did he do that in 2018? Why was it only 2019 that there was a problem? Was there no corruption in Ukraine in 2017? Was there no corruption in Ukraine in 2018? No. Ukraine has always battled corruption. It wasn't the presence or lack of corruption in one year to another. It was the presence of Joe Biden as a potential candidate for president. That was the key change in 2019. That made all the difference. Which gets back to one of the key moments in this saga. You know, a lot of you are attorneys. You're probably much better attorneys than I am, and I'm sure you had the experience in cases you tried where there was some vignette, some conversation, some document. It may not have been the most important on its face, but it told you something about the case that was much larger than that conversation. For me, one of those conversations was not on July 25th between President Trump and President Zelensky, but on July 26th, the very next day. Now, you may have watched some of the House proceedings, or you may haven't, and people watching may have seen it, maybe they didn't. But there's this scene in a Ukrainian restaurant, a restaurant in Kyiv, with Gordon Sondland. Now, bear in mind, Gordon Sondland, who said there was absolutely a quid pro quo and 2 + 2 = 4, this is not some never-Trumper. This is a $1 million donor to the Trump inauguration, okay? If there's a bias there, it's clearly a $1 million bias in favor of this president, not against him. So there's a scene in Kyiv, in this restaurant, and Sondland has a cell phone, and he's sitting with David Holmes, who is a career diplomat, U.S. diplomat in the Ukraine embassy. And Gordon Sondland takes out his phone and he calls the White House. Gordon Sondland holding for the White House, Gordon Sondland holding for the president. And it takes a while to be connected, but he's connected to the president. That's pretty impressive, right? This isn't some guy with no relationship to the president. The president may say, Gordon Sondland, I barely know him, or something to that effect, but this is a guy who can pick up his cell phone. He can call the president of the United States from a restaurant in Kyiv, and he does. And the president's voice is so loud that David Holmes, this diplomat, can hear it. And what does the president say? Does he say, how's that reform coming in the Rada? How's the attack on corruption going? No. He just says, is he going to do the investigation? Is Zelensky going to do the investigation? And Sondland says, yes. He'll do anything you want. He loves your ass. This is the extent of the president's interest in Ukraine, and they go on to talk about other things, and then they hang up. And David Holmes turns to the ambassador and says, in language which I will have to modify, to remove an expletive, says something along the lines of, does the president give a blank about Ukraine? And Sondland says, no, he doesn't give a blank about Ukraine. He only cares about the big stuff, like the investigation of the Bidens that Giuliani wants. This is a $1 million donor to the Trump inaugural, admitting the president doesn't care about Ukraine. He doesn't care whether they get military dollars to defend themselves. He doesn't care about what position Zelensky goes into in these negotiations with Putin. He doesn't care about that. Isn't that clear? It's why he didn't care about corruption in 2017 or 2018, and he certainly didn't care about it in 2019. All he cared about was the big stuff that affected him personally, like this investigation that he wanted of the Bidens. So when you ask, do you want to see these documents? Do you want to know if these documents corroborate Ambassador Sondland? Will the documents show, as we fully expect they will, that the only thing he cared about was the big stuff that affected him? David Holmes' response was, well, you know, there's some big stuff going on here, like a war with Russia. This isn't withholding aid because of a revolution in Egypt. This is withholding aid from a country in which 15,000 people have died fighting the Russians. And as Ambassador Taylor said, and others, Russia's fighting to remake the map of Europe by dint of military force. If we think that's just about Ukraine's security, we are very deceived. It's about our security. It's about the tens of thousands of troops that we have in Europe. And if we undercut our own ally, if we give Russia reason to believe we will not have their back, that we'll use Ukraine as a plaything, or worse, to get them to help us cheat in an election, that will only embolden Putin to do more. You've said it as often as I have, the only thing he respects is strength. Do you think that looks like strength to Vladimir Putin? I think that looks like something that Vladimir Putin is only too accustomed to. And that is the kind of corruption that he finds and he perpetuates in his own regime and he pushes all around the world. My colleague Val Demings made reference to a conversation which I think is one of the other key vignettes in this whole sad saga. And that's that conversation that Ambassador Volker has with Andrei Yermak, one of the top aides to President Zelensky. And this is a conversation in which Ambassador Volker is doing exactly what he's supposed to be doing, which is he's telling Yermak, you guys shouldn't really do this investigation of your former President Poroshenko because it would be for a political reason. You really shouldn't engage in political investigations. And as Representative Deming said, what's the response from the Ukrainians? Oh, you mean like the one you want us to do of the Bidens and the Clintons? Threw it right back in his face. Ukraine's not oblivious to that hypocrisy. Mr. Sekulow says, what are we here for? Part of our strength is not only our support for our allies, it's not only our military might, it's what we stand for. We used to stand for the rule of law. We used to champion the rule of law around the world. Part of the rule of law is, of course, that no one is above the law. But to be out in Ukraine or anywhere else in the world championing the rule of law and saying, don't engage in political prosecutions, and having them throw it right back in our face, oh, you mean like the one you want us to do? That's why we're here. That's why we're here. That's why we're here. I yield back.
Mr. Chief Justice.
The Majority Leader is recognized.
I send a motion to the desk to table the amendment and ask for the yeas and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Jones, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mrs. Loeffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
The yeas are 53, the nays are 47. The motion is tabled. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to issue a subpoena to John Michael Mick Mulvaney, and I ask that it be read.
Clerk will report.
The senator from New York, Mr. Schumer, proposes an amendment number 1287. At the appropriate place in the resolving clause, insert the following. Section, notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena for the taking of testimony of John Michael Mick Mulvaney, and the Sergeant at Arms is authorized to utilize the services of the Deputy Sergeant at Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice.
The majority leader is recognized.
I now ask for a 30-minute recess before the parties are recognized to debate the Schumer amendment. Following the debate time, I will once again move to table the amendment because votes on witnesses and evidence, as I've repeatedly said, are addressed in the underlying resolution. So I ask that the Senate stand in recess until 8 p.m.
Without objection, so ordered. To bang the gavel, right? Mr. Schiff, are you in favor of the motion or opposed, the amendment? Thank you. Mr. Cipollone? Okay, Mr. Schiff, the managers will go first and able to reserve time for rebuttal.
Mr. Chief Justice, distinguished members of the Senate, Counsel for the President. My name is Hakeem Jeffries, and I have the honor of representing the 8th Congressional District of New York in Brooklyn and Queens. It is one of the most diverse districts in the nation. In fact, I've been told that I have the 9th most African-American district in the country and the 16th most Jewish. And here on the Hill, some folks have said, Hakeem, is that complicated? But as my friend Leon Goldenberg says back at home, Hakeem, you've got the best of both worlds. You see, in America, our diversity is a strength. It is not a weakness. And one of the things that binds us together, all of us as Americans, regardless of race, regardless of religion, regardless of region, regardless of sexual orientation, regardless of gender, is that we believe in the rule of law and the importance of a fair trial. The House managers strongly support this amendment to subpoena witness testimony, including with respect to Mick Mulvaney. Who has ever heard of a trial with no witnesses? But that is exactly what some are contemplating here today. This amendment would address that fundamental flaw. It would ensure that the trial includes testimony from a key witness, the President's acting Chief of Staff and head of the Office of Management and Budget, Mick Mulvaney. And it would ensure that the Senate can consider his testimony immediately. Let's discuss why the need to hear from Mick Mulvaney is so critical. First, Leader McConnell's resolution undercuts more than 200 years of Senate impeachment trial practice. It departs from every impeachment trial conducted to date and goes against the Senate's own long-standing impeachment rules, which contemplates the possibility of new witness testimony. In fact, it departs from any criminal or civil trial procedure in America. Why should this president be held to a different standard? Second, the proposed amendment for witness testimony is necessary in light of the president's determined effort to bury the evidence and cover up his corrupt abuse of power. The House tried to get Mr. Mulvaney's testimony. We subpoenaed him. Mr. Mulvaney, together with other key witnesses, National Security Advisor John Bolton, Senior White House aide Robert Blair, Office of Management and Budget official Michael Duffy, and National Security Council lawyer John Eisenberg were called to testify before the House as part of this impeachment inquiry. But President Trump was determined to hide from the American people what they had to say. The president directed the entire executive branch and all of his top aides and advisors to defy all requests for their testimony. That cannot be allowed to stand. Third, Mr. Mulvaney is a highly relevant witness to the events at issue in this trial. Mr. Mulvaney was at the center of every stage of the president's substantial pressure campaign against Ukraine. Based on the extensive evidence the House did obtain, it is clear that Mulvaney was crucial in planning the scheme, executing its implementation, and carrying out the cover-up. Emails and witness testimony show that Mr. Mulvaney was in the loop on the president's decision to explicitly condition a White House meeting on Ukraine's announcement of investigations beneficial to the president's re-election prospects. He was closely involved in implementing the president's hold on the security assistance and subsequently admitted that the funds were being withheld to put pressure on Ukraine to conduct one of the phony political investigations that the president wanted. Phony political investigations. A trial would not be complete without the testimony of Mick Mulvaney. Make no mistake, the evidentiary record that we have built is powerful and can clearly establish the president's guilt on both of the articles of impeachment, but it is hardly complete. The record comes to you without the testimony of Mr. Mulvaney and other important witnesses. And that brings me to one final preliminary observation. The American people agree that there cannot be a fair trial without hearing from witnesses who have relevant information to provide. The Constitution, our democracy, the Senate, the President, and most importantly, the American people deserve a fair trial. A fair trial requires witnesses in order to provide the truth, the whole truth, and nothing but the truth. That is why this amendment should be adopted. Before we discuss Mr. Mulvaney's knowledge of the president's geopolitical shakedown, it is important to note that an impeachment trial without witnesses would be a stunning departure from this institution's past practice. This distinguished body has conducted 15 impeachment trials. All have included witnesses. Sometimes those trials included just a handful of witnesses, as indicated on the screen. At other times, they included dozens. In one case, there were over 100 different witnesses. As the slide shows, the average number of witnesses to appear at a Senate impeachment trial is 33. And in at least 3 of those instances, including the impeachment of Bill Clinton, witnesses appeared before the Senate who had not previously appeared before the House. That's because the Senate, this great institution, has always taken its responsibility to administer a fair trial seriously. The Senate has always taken its duty to obtain evidence, including witness testimony, seriously. The Senate has always taken its obligation to evaluate the president's conduct based on a full body of available information seriously. This is the only way to ensure fundamental fairness for everyone involved. Respectfully, it is important to honor that unbroken precedent today, so that Mr. Mulvaney's testimony, without fear or favor as to what he might say, can inform this distinguished body of Americans. This amendment is also important to counter the president's determination to bury the evidence of his high crimes and misdemeanors. As we've explained in detail today, despite considerable efforts by the House to obtain relevant documents and testimony, President Trump has directed the entire executive branch to execute a cover-up. He has ordered the entire administration to ignore the powers of Congress, a separate and co-equal branch of government, to investigate his offenses in a manner that is unprecedented in American history. There were 71 requests by the House for relevant evidence. In response, the White House produced 0 documents in this impeachment inquiry. 71 requests, 0 documents. President Trump is personally responsible for depriving the Senate of information important to consider in this trial. This point cannot be overstated. When faced with a congressional impeachment inquiry, a process expressly set forth by the framers of the Constitution in Article 1, the president refused to comply in any respect. And he ordered his senior aides to fall in line. As shown on the slide, as a result of President Trump's obstruction, 12 key witnesses, including Mr. Mulvaney, refused to appear for testimony in the House's impeachment inquiry. No one has heard what they have to say. These witnesses include central figures in the abuse of power charged in Article 1. What is the president hiding? Equally troublesome, President Trump and his administration did not make any legitimate attempts to reach a reasonable accommodation with the House or compromise regarding any document requests or witness subpoenas. Why? Because President Donald John Trump wasn't interested in cooperating. He was plotting a cover-up. It is important to take a step back and think about what President Trump is doing. Complete and total presidential obstruction is unprecedented in American history. Even President Nixon, whose articles of impeachment included obstruction of Congress, did not block key White House aides from testifying in front of Congress during the Senate Watergate hearings. In fact, he publicly urged White House aides to testify. Remember all of those witnesses who came in front of this body? Take a look at the screen. John Dean, the former White House counsel, testified for multiple days pursuant to a subpoena. H.R. Haldeman, President Nixon's former chief of staff, was subpoenaed and testified. Alexander Butterfield, the White House official who revealed the existence of the tapes, testified publicly before the Senate, and so did several others. President Trump's complete and total obstruction makes Richard Nixon look like a choir boy. 2 other presidents have been tried before the Senate. How did they conduct themselves? William Jefferson Clinton and Andrew Johnson did not block any witnesses from participating in the Senate trial. President Trump, by contrast, refuses to permit relevant witnesses from testifying to this very day. Many of President Clinton's White House aides testified in front of Congress, even before the commencement of formal impeachment proceedings. During various investigations in the mid-1990s, the House and Senate heard from more than 24 White House aides, including the White House counsel, the former chief of staff, and multiple senior advisors to President Clinton. President Clinton himself gave testimony on camera and under oath. He also allowed his most senior advisors, including multiple chiefs of staff and White House counsels, to testify in the investigation that led to his impeachment. And as you can see in the chart, their testimony was packaged and delivered to the Senate. There were no missing witnesses who had defied subpoenas. No aides who had personal knowledge of his misconduct were directed to stay silent by President Clinton. We have an entirely different situation in this case. Here we are seeking witnesses the president has blocked from testifying before the House. Apparently, President Trump thinks that he can do what no other president before him has attempted to do in such a brazen fashion: float above the law and hide the truth from the American people. That cannot be allowed to stand. Let me now address some bedrock principles about Congress's authority to conduct investigations. Our broad powers of inquiry are at their strongest during an impeachment proceeding, when the House and Senate exercise responsibilities expressly set forth in Article 1 of the Constitution. Nearly 140 years ago, the Supreme Court recognized that when the House or Senate is determining a question of impeachment, there is no reason to doubt the right to compel the attendance of witnesses and their answer to proper questions in the same manner and by the use of the same means that courts of justice can in like cases. Our nation's founders and greatest legal minds recognized these principles early on. Supreme Court Justice Joseph Story explained that the president should not have the power of preventing a thorough investigation of his conduct or of securing himself against the disgrace of a public conviction by impeachment if he should deserve it. President Trump cannot function as judge, jury, and executioner of our democracy. And it wasn't just the courts who confirmed this for us. Some of our nation's leading public servants. Representative John Quincy Adams, speaking on the floor of the House after he had served as president, once exclaimed, "What mockery would it be for the Constitution of the United States to say that the House should have the power of impeachment, extending even to the President of the United States himself, and yet to say that the House had not the power to obtain the evidence and proofs on which their impeachment was based." As Hamilton, Story, Adams, and others have recognized, the president cannot insulate himself from Congress's investigations of his wrongdoing. The president could decide what evidence gets to be presented in his own trial that would fundamentally nullify the constitutional power of impeachment. This amendment is important because President Trump simply cannot be allowed to hide the truth. No other president has done it. The Supreme Court does not allow it, and the president is not above the law. Witnesses matter. Documents matter. Evidence matters. The truth matters. Let me now turn to a third justification for this amendment. Mr. Mulvaney's testimony is critical to considering the case for removal. It is imperative that we hear from the president's closest aide, a man intimately involved at key stages of this extraordinary abuse of power. President Trump knows this. Why else would he be trying so hard to prevent Mick Mulvaney from testifying before you? There are at least 4 reasons why Mr. Mulvaney's testimony is critical. To begin with, as acting White House Chief of Staff and head of the Office of Management and Budget, Mick Mulvaney has firsthand knowledge about President Trump's efforts to shake down Ukraine and pressure its new president into announcing phony investigations. Mr. Mulvaney was in the loop at each critical stage of President Trump's scheme. He was in the loop in the planning of the scheme. He was in the loop in its implementation. And he was in the loop when the scheme fell apart. He even admitted publicly that the aid was withheld in order to pressure Ukraine into announcing an investigation designed to elevate the president's political standing. Mr. Mulvaney, perhaps more than any other administration witness excepting the president has firsthand insight into the decision to withhold $391 million in military and security aid to a vulnerable Ukraine without justification. Indeed, our investigation revealed that President Trump personally ordered Mr. Mulvaney to execute the freeze in July of 2019. Mr. Mulvaney holds the senior-most staff position at the White House. He is a member of President Trump's cabinet, and he is responsible for President Trump's team at 1600 Pennsylvania Avenue. He remains the director of the Office of Management and Budget, which implemented the hold on the security assistance in violation of the law, as the Government Accountability Office recently concluded. In short, respectfully, the Senate's responsibility to conduct a complete and fair trial demands that Mr. Mulvaney testify. Second, Mr. Mulvaney's testimony is critical because of his knowledge of the planning of President Trump's abuse of power. Ambassador Gordon Sondland, the U.S. ambassador to the European Union, testified that there was a quid pro quo. Ambassador Sondland is not a so-called never-Trumper. Mr. Sondland gave $1 million to President Trump's inauguration. He testified that everybody was in the loop and that it was no secret what was going on. In fact, as early as May of 2019, Ambassador Sondland made clear that he was coordinating on Ukraine matters with Mr. Mulvaney. Here is what David Holmes, an official at the U.S. Embassy in Ukraine, had to say on that matter.
Well, Ambassador Sondland's mandate as the accredited ambassador to the European Union did not cover individual member states, let alone non-member countries like Ukraine. He made clear that he had direct and frequent access to President Trump and Chief of Staff Mick Mulvaney, and portrayed himself as the conduit to the President and Mr. Mulvaney for this group.
After the U.S. delegation returned from the inauguration of the new Ukrainian president in April, they were able to secure an Oval Office meeting with President Trump to brief him on their trip, in part because of Ambassador Sondland's connections to Mick Mulvaney. Then, during a June 18, 2019 meeting, Ambassador Sondland informed National Security Council Senior Director Dr. Fiona Hill that he was in charge of Ukraine and that he had been briefing senior White House officials, including Mr. Mulvaney, about his efforts to undertake, as Dr. Hill put it, a domestic political errand in Ukraine. Here is Dr. Hill explaining this herself.
So I was upset with him that he wasn't fully telling us about all of the meetings that he was having. And he said to me, but I'm briefing the president. I'm briefing Chief of Staff Mulvaney. I'm briefing Secretary Pompeo, and I've talked to Ambassador Bolton. Who else do I have to deal with? And the point is we have a robust interagency process that deals with Ukraine. It includes Mr. Holmes, it includes Ambassador Taylor as the chargé in Ukraine. It includes a whole load of other people. But it struck me yesterday when you put up on the screen Ambassador Sondland's emails and who was on these emails, and he said, these are the people who need to know, that he was absolutely right, because he was being involved in a domestic political errand. And we were being involved in national security foreign policy, and those two things had just diverged.
And there's more. Much more. A month later, President Trump's national security advisor at the time, John Bolton, told Dr. Fiona Hill to tell the National Security Council's lawyers that he was not part of whatever drug deal Sondland and Mulvaney were cooking up. He made that statement after Ambassador Sondland specifically said that he had a deal with Mr. Mulvaney to schedule a White House visit for President Zelensky if Ukraine announced 2 phony investigations involving the Bidens and 2016 election interference investigations that were sought by President Donald John Trump. Here is Dr. Hill's testimony about Sondland describing this drug deal he had with Mulvaney.
And so when I came in, Gordon Sondland was basically saying, well, look, we have a deal here that there will be a meeting. I have a deal here with Chief of Staff Mulvaney. There will be a meeting if the Ukrainians open up or announce these investigations and, into 2016 in Burisma. And I cut it off immediately there. Because by this point, having heard Mr. Giuliani over and over again on the television and all of the issues that he was asserting, by this point it was clear that Burisma was code for the Bidens, because Giuliani was laying it out there. I could see why Colonel Vindman was alarmed, and he said, this is inappropriate, we're the National Security Council, we can't be involved in this.
The referenced agreement between Ambassador Sondland and Mick Mulvaney was so upsetting that Dr. Hill reported it to National Security Council legal advisors. Here is the testimony of Dr. Hill explaining these particular concerns.
What did he say?
Yes, but he was making a very strong point that he wanted to know exactly what was being said. And when I came back and related it to him, he had some very specific instruction for me. And I'm presuming that that's
what was that specific instruction?
The specific instruction was that I had to go to the lawyers, to John Eisenberg, our senior counsel for the National Security Council, to basically say, you tell Eisenberg, Ambassador Bolton told me, that I am not part of this whatever drug deal that Mulvaney and Sondland are cooking up.
What did you understand him to mean by the drug deal that Mulvaney and Sondland were cooking up?
I took it to mean investigations for a meeting.
Did you go speak to the lawyers?
I certainly did.
Sondland's testimony not only corroborates Dr. Hill's account, he actually says that Mick Mulvaney, the subject of this amendment, who should appear before the Senate if we're going to have a free and fair trial. Sondland says Mick Mulvaney knew all about it.
What I want to ask you about is, he makes reference in that drug deal to a drug deal cooked up by you and Mulvaney. It's the reference to Mulvaney that I want to ask you about. You've testified that Mulvaney was aware of this quid pro quo, of this condition that the Ukrainians had to meet, that is, announcing these public investigations to get the White House meeting. Is that right?
Yeah, a lot of people were aware of it, and
including Mr. Mulvaney.
Correct.
The documents also highlight the extensive involvement of Mick Mulvaney in this geopolitical shakedown scheme. Email messages summarized by Ambassador Sondland during his sworn testimony showed that he informed Mr. Mulvaney, as well as Secretary Pompeo and Secretary Perry, of his efforts to persuade President Zelensky to announce the investigations desired by President Trump. For example, as shown on the screen, on July 19th, Ambassador Sondland emailed several top administration officials, including Mr. Mulvaney, stating that he had talked to President Zelensky to help prepare him for a phone call with President Trump. And he reported that President Zelensky planned to assure President Trump that he intends to run a fully transparent investigation and will turn over every stone. Ambassador Sondland made clear in his testimony that he was referring to the Burisma Biden and 2016 election interference investigations that were explicitly mentioned by President Trump on the July 25th phone call. Mr. Mulvaney wrote in response, I asked NSC to set it up. What exactly did Mr. Mulvaney know about the Ukrainian commitment to turn over every stone? And when did he know it? These and many other questions require answers under oath from Mr. Mulvaney. Mr. Mulvaney is also a central figure with respect to how President Trump implemented this pressure campaign. According to public reports and witness testimony, Mr. Mulvaney was deeply involved with implementing the scheme, including the unlawful White House freeze on $391 million in aid to Ukraine. But this isn't just other people fingering Mr. Mulvaney. Mr. Mulvaney has himself admitted that he was involved.
Again, I was involved with the process by which the money was held up temporarily. Okay.
The public reports confirm Mr. Mulvaney's own account that he has information that goes to the heart of this inquiry, specifically related to why the president ordered the hold on aid to Ukraine and kept it in place, despite deep-seated concerns among Trump administration officials. This New York Times article on the screen summarizes an email conversation between Mr. Mulvaney and Robert Blair, a senior administration advisor, on June 27th, when Mr. Mulvaney asked, did we ever find out about the money for Ukraine and whether we can hold it back? What prompted that email? According to public reports, Mr. Mulvaney was on Air Force One. Air Force One with President Trump when he sent it. What other conversations did Mr. Mulvaney have with the president and White House officials about this unlawful freeze? The American people deserve to know. There is other significant evidence concerning Mr. Mulvaney's role in implementing the scheme. According to multiple witnesses, the direction to freeze the security assistance to Ukraine was delivered by Mick Mulvaney himself. Office of Management and Budget official Mark Sandy testified about a July 12th email from Mr. Blair stating that President Trump is directing a hold on military support funding for Ukraine. Was Mr. Blair acting at Mr. Mulvaney's express direction? The members of this distinguished body deserve to know. On July 18th, the hold was announced to the agencies in the administration overseeing Ukraine policy matters. Those present were blindsided by the announcement that the security aid appropriated by this Congress on a bipartisan basis to Ukraine, which is still at war with Russian-backed separatists in the East. They were alarmed that that aid had inexplicably been put on hold. Meanwhile, officials at the Defense Department and within the Office of Management and Budget became increasingly concerned that the hold also violated the law. Their concerns turned out to be accurate. Public reports have indicated that the White House is in possession of early August emails, exchanges between Acting Chief of Staff Mick Mulvaney and White House budget officials seeking to provide an explanation for the funds. An explanation, I should note, that they were trying to provide after the president had already ordered the hold. Mr. Mulvaney presumably has answers to these questions. We don't know what those answers are, but he should provide them to this Senate and to the American people. Finally, on October 17, 2019, at a press briefing at the White House, Mr. Mulvaney left no doubt that President Trump withheld the essential military aid as leverage to try to extract phony political investigations as part of his effort to solicit foreign interference in the 2020 election. This was an extraordinary press conference. Mr. Mulvaney made clear that the president was, in fact, pressuring Ukraine to investigate the conspiracy theory that Ukraine, rather than Russia, had interfered in the 2016 election. A conspiracy theory promoted by none other than the great purveyor of democracy, Vladimir Putin himself. When White House reporters attempted to clarify this acknowledgement of a quid pro quo related to security assistance, Mr. Mulvaney replied, "We do that all the time with foreign policy. I have news for you. Get over it." Let's listen to a portion of that stunning exchange.
Did he also mention to me in the past the corruption related to the DNC server? Absolutely, no question about that. But that's it, and that's why we held up the money. Now, there was a report.
So the demand for an investigation into the Democrats was part of the reason that he ordered to withhold funding to Ukraine.
The look back to what happened in 2016 certainly was part of the thing that he was worried about in corruption with that nation. And that is absolutely appropriate.
But to be clear, what you just described is a quid pro quo. It is funding will not flow unless the investigation into the Democratic server happened as well.
We do that all the time with foreign policy. We were holding up money at the same time for what was it? The Northern Triangle countries. We were holding up aid at the Northern Triangle countries so that they would change their policies on immigration. By the way, and this speaks to an important. I'm sorry. This speaks to an important point, because I heard this yesterday, and I can never remember the gentleman who testified. Was it McKinney, the guy? Is that his name? I don't know him. He testified yesterday. And if you go, and if you believe the news reports, okay, because we've not seen any transcripts of this. The only transcript I've seen was Sondland's testimony this morning. If you read the news reports and you believe them, what did McKinney say yesterday? Well, McKinney said yesterday that he was really upset with the political influence in foreign policy. That was one of the reasons he was so upset about this. And I have news for everybody. Get over it. There's going to be political influence in foreign policy.
In this extraordinary press conference, Mr. Mulvaney spoke with authority and conviction about why President Trump withheld the aid. He did not mince his words, but then following the press conference, he tried to walk back his statements as if he had not said them or had not meant them. We need to hear from Mick Mulvaney directly so he can clarify his true intentions. Now, having gone through the need for the evidence, let's briefly address the president's arguments that he can block this testimony. That argument is not only wrong, it fundamentally undermines our system of checks and balances. Step back for a moment and consider the extraordinary position that President Trump is trying to manufacture for himself. The Department of Justice has already said that the president cannot be indicted or prosecuted in office. As we sit here today, the president has actually filed a brief in the Supreme Court saying he cannot be criminally investigated as well while in the White House. So the Senate and the House are the only check that are left when the president abuses his power, tries to cheat in the next election, undermines our national security, breaks the law in doing so, and then tries to cover it up. This is America. No one is above the law. But if the president is allowed to determine whether he is even investigated by Congress, if he is allowed to decide whether he should comply with lawful subpoenas in connection with an impeachment inquiry or trial, then he is the ultimate arbiter of whether he did anything wrong. That cannot stand. If he can't be indicted, and he can't be impeached, and he can't be removed, then he can't be held accountable. That is inconsistent with the United States Constitution. Now, you will no doubt hear that the reason that the president blocked all of these witnesses, including Mr. Mulvaney, from testifying is because of some lofty concern for the office of the presidency and the preservation of executive privilege. Let's get real. How can blocking witnesses from telling the truth about the president's misconduct help preserve the office of the presidency? This type of blanket obstruction undermines the credibility of the office of the presidency and deals the Constitution a potentially mortal death blow. To be clear, executive privilege does not provide a legally justifiable basis for his complete and total blockage of evidence. In fact, as you heard earlier today, President Trump never even invoked executive privilege, not once. And without ever asserting this privilege, how can you consider his argument in a serious fashion? Instead, speaking through Mr. Cipollone, the distinguished White House counsel, in a letter dated October 8, 2019, President Trump simply decided that he did not want to participate in the investigation into his own wrongdoing. It was a categorical decision not to cooperate without consideration of specific facts or legal arguments. In fact, even the words that President Trump used through his White House counsel were made up. In the letter, Mr. Cipollone referred to so-called executive branch confidentiality interest. But that is not a recognized jurisprudential shield, not a proper assertion of executive privilege. To the extent that there are privilege issues to consider, those can be resolved during the testimony, as they have been for decades. And finally, the president claimed that Mr. Mulvaney could not be compelled to testify because of so-called absolute immunity. But every court to address this legal fiction has rejected it. As the Supreme Court emphatically stated in unanimous fashion in its decision on the Nixon tapes, confidentiality interests of the president must yield to an impeachment inquiry when there is a legitimate need for the information, as there is here today. There can be no doubt that Mr. Mulvaney, as the president's chief of staff and head of the Office of Management and Budget, is uniquely situated to provide this distinguished body with relevant and important information about the charges in the articles of impeachment. The president's obstruction has no basis in law and should yield to this body's co-equal authority to investigate impeachable and corrupt conduct. One final point bears mention. If the president wanted to make witnesses available, even while preserving the limited protections of executive privilege, he can do so. In fact, President Trump expressed his desire for witnesses to testify in the Senate just last month. Let's go to the videotape.
So when it's fair, it will be fair in the Senate. I would love to have Mike Pompeo. I'd love to have Mick. I'd love to have Rick Perry and many other people testify.
If President Trump has nothing to hide, as he and his advisors repeatedly claim, they should all simply testify in the Senate trial. What is President Donald John Trump hiding from the American people? The Constitution requires a fair trial. Our democracy needs a fair trial. The American people deserve a fair trial. A fair trial means witnesses. A fair trial means documents. A fair trial means a consideration of all of the available evidence. A fair trial means testimony from Mick Mulvaney. Mr. Chief Justice, the House managers reserve the balance of our time.
Mr. Cipollone. Thank you.
Mr. Chief Justice, members of the Senate, good evening. My name is Michael Propura. I serve as Deputy Counsel to the President. We strongly oppose the amendment and support the resolution. There is simply no need to alter the process on witnesses and documents from that of the Clinton trial, which was supported by this body 100-0. At its core, this case is very simple, and the key facts are undisputed. First, you've seen the transcripts, which the President released transparently, unprecedentedly. There was no quid pro quo for anything. Security assistance funds aren't even mentioned on the call. Second, President Zelensky and the highest-ranking officials in the Ukrainian government repeatedly have said there was no quid pro quo and there was no pressure. Third, the Ukrainians were not even aware of the pause in the aid at the time of the call and weren't aware of it, did not become aware of it until more than a month later. Fourth, the only witnesses in the House record who actually spoke to the President about the aid, Ambassador Sondland and Senator Ron Johnson, say the President was unequivocal in saying there was no quid pro quo. Fifth, and this one's pretty obvious, the aid flowed, and President Trump and President Zelensky met without any investigations started or announced. Finally, and I ask that you not lose sight of the big picture here. By providing lethal aid to Ukraine, President Trump has proven himself to be a better friend and ally to Ukraine than his predecessor. The time for the House managers to bring their case is now. They had their chance to develop their evidence before they sent the articles of impeachment to this chamber. This chamber's role
is not to do the House's job for it. With that, I yield the balance of my time to Mr. Cipollone.
Thank you, Mr. Chief Justice. Just a couple of observations. First of all, as Mr. Purpura said, all we're talking about is when this question is addressed. Under the resolution, that'll be next week. This resolution was accepted 100-0. Some of you were here then, thought it was great. If we keep going like this, it'll be next week. For those of you keeping score at home, they haven't even started yet. We're here today. We came hoping to have a trial. They spent the entire day telling you and the American people that they can't prove their case. I could have told you that in 5 minutes and saved us all a lot of time. They came here talking about the GAO. It's an organization that works for Congress. Do you know who disagrees with the GAO? Don't take it from me. They do. They sent you articles of impeachment that makes no claim of any violation of any law. By the way, you know what also doesn't? You can search high and low on the articles of impeachment. You know what it doesn't say? Quid pro quo, because there wasn't any. Only in Washington would someone say that it's wrong when you don't spend taxpayer dollars fast enough, even if you spend them on time. Now let's talk about the Judiciary Committee for a second. 2 days in the Judiciary Committee, 2 days. The Judiciary Committee is supposed to be in charge of impeachments. The delivery time for the articles they produced was 33 days. I think this might be the first impeachment in history where the delivery time was longer than the investigation in the Judiciary Committee. They come here and falsely accuse people. By the way, they falsely accused you. You're on trial now. They falsely accuse people of phony political investigations. Really? Since the House Democrats took over, that's all we've had from them. They've used their office, all the money that the taxpayers send to Washington to pay them, to conduct phony political investigations against the president, against his family, against anyone who knew him. They started impeaching him the minute he was elected. They've weaponized the House of Representatives to investigate incessantly their political opponent. And they come here and make false allegations of phony political investigations. I think the doctors call that projection. It's time for it to end. It's time for someone, for the Senate, to hold them accountable. Think about what they're asking. I said it, they didn't deny it. They're trying to remove President Trump's name from the ballot, and they can't prove their case. They've told you that all day long. Think about what they're asking some of you senators to do. Some of you are running for president. They're asking you to use your office to remove your political opponent from the ballot. That's wrong. That's not in the interest of our country. And to be honest with you, it's not really a show of confidence. So we will, I suppose, have this debate again next week, if we ever get there. It's getting late. I would ask you respectfully, if we could simply start. Maybe tomorrow we can start, and they can make their argument, and they can, I guess, make a case that they once called overwhelming. We'll see. But this resolution is right, and it's fair, and it makes sense. You have a right to hear what they have to say before you have to decide these critical issues. That's all this is about. Is it now, or is it a week from now? Seriously, can we please start? Thank you.
The House, Mr. Cipollone, is your side complete?
Yes, we are, Mr. Chief Justice.
Thank you. The House managers have 14 minutes remaining.
Counsel for the President indicated that we have not charged President Trump with a crime. We have charged him with crimes against the United States Constitution, high crimes and misdemeanors. Abuse of power strikes at the very heart of what the framers of the Constitution were concerned about. Betrayal of one's oath of office for personal gain, and the corruption of our democracy. High crimes and misdemeanors, that's what this trial is all about. Now, counsel for the President, again, has declined to address the substantive merits of the amendment that has been offered. Tried to suggest that House Democrats have only been focused on trying to oust President Trump. Nothing can be further from the truth. In the last year, we passed 400 bills sent into this chamber. 275 of those bills are bipartisan in nature, addressing issues like lowering health care costs and prescription drug prices, trying to deal with the gun violence epidemic. We've worked with President Trump on criminal justice reform. I personally worked with him, along with all of you, on the First Step Act. We worked with him on the U.S.-Mexico-Canada trade agreement. We worked with him to fund the government. We don't hate this president, but we love the Constitution. We love America. We love our democracy. That's why we're here today. The question was asked by Mr. Sekulow as he opened before this distinguished body. Why are we here? Let me see if I can just posit an answer to that question. We are here, sir, because President Trump pressured a foreign government to target an American citizen for political and personal gain. We are here, sir, because President Trump solicited foreign interference in the 2020 election and corrupted our democracy. We are here, sir, because President Trump withheld $391 million in military aid from a vulnerable Ukraine without justification in a manner that has been deemed unlawful. We are here, sir, because President Donald Trump elevated his personal political interests and subordinated the national security interests of the United States of America. We are here, sir, because President Trump corruptly abused his power and then he tried to cover it up. And we are here, sir, to follow the facts, apply the law, be guided by the Constitution, and present the truth to the American people. That is why we are here, Mr. Sekulow. And if you don't know, now you know. I yield to my distinguished colleague, Chairman Schiff.
I thank the gentleman for yielding, and just want to provide a couple quick fact checks on my colleagues at the other table. First, Mr. Purpura said that security assistance funds were not mentioned at all in the July 25th call between President Trump and President Zelensky. Well, let's think back to what was discussed in that call. You might remember from that call that President Zelensky thanks President Trump for the Javelin anti-tank weapons and says they're ready to order some more. And what is President Trump's immediate response? I have a favor to ask, though. What was it about the president of Ukraine bringing up military assistance that triggered the president to go immediately to the favor that he wanted? I think that's telling that it takes place in that part of the conversation. So, yes, security assistance, military assistance did come up in that call. It came up immediately preceding the ask. What kind of message do you think that sends to Ukraine? They're not stupid. The people watching this aren't stupid. Now, Mr. Purpura says, well, they never found out about it, or they didn't find out about the freeze in the aid until a month later. Mr. Purpura needs to be a little more careful with his facts. Let me tell you about some of the testimony you're going to hear, and you'll only hear it because it took place in the House. If these were other witnesses, you wouldn't be able to hear it. But you had Catherine Croft, a witness from the State Department, a career official at the State Department, who talked about how quickly, actually, after the freeze went into place, the Ukrainians found out about it, and she started getting contacts from the Ukrainian embassy here in Washington. She said she was really impressed with their diplomatic tradecraft. Now, what does that mean? It means she was really impressed with how quickly the Ukrainians found out about something that the administration was trying to hide from the American people. Ukraine found out about it. In fact, Laura Cooper, a career official at the Defense Department, said that her office started getting inquiries from Ukraine about the issues with the aid on July 25th, the very day of the call. So much for Ukraine not finding out about this for a month later. But I thought this was very telling, too. The New York Times disclosed that by July 30th, so within a week of the call between President Trump and President Zelensky, Ukraine's foreign ministry received a diplomatic cable from its embassy indicating that Trump had frozen the military aid. Within a week, that cable is reported to have gone from the Ukrainian embassy to the Ukrainian foreign ministry. And the former Ukrainian deputy foreign minister, Olena Zerkal, said, quote, "We have this information. It was definitely mentioned that there were some issues." She went on to say that the cable was simultaneously provided to President Zelensky's office. But Andrei Yermak, who you'll learn more about later, a top aide to President Zelensky, reportedly directed her to keep silent and not discuss the hold with reporters or Congress. Now, we heard testimony about why the Ukrainians wanted to keep it secret, that they knew about the hold. You can imagine why. Zelensky didn't want his own people to know that the President of the United States was holding back aid from him. What does that look like for a new president of Ukraine who is trying to make the case that he's going to be able to defend his own country because he has such a great relationship with the great patron, the United States? He didn't want Ukrainians to know about it, but you know, even more than that, he didn't want the Russians to know about it for the reasons we talked about earlier. So yes, the Ukrainians kept it close to the vest. Now, Mr. Purpura also went on to say, well, the Ukrainians say they don't feel any pressure. That's what they say now. Of course, we know that's not true. We've had testimony that they didn't want to be used as a political pawn in U.S. domestic politics. They resisted it. You'll hear more testimony about that, about the efforts to push back on this public statement, how they tried to water it down, how they tried to leave out the specifics, and how Giuliani, at the president's behest, forced them to know, no, this isn't going to be credible if you don't add Burisma and you don't add 2016. You'll hear about the pressure. They felt it. So why isn't President Zelensky now saying he was pressured? Well, can you imagine the impact of that? Can you imagine the impact of President Zelensky if he were to acknowledge today Hell yes, we felt pressured. You would too. We're at war with Russia, for crying out loud. Yeah, we felt pressure. We needed those hundreds of millions of military aid, but you think I'm going to say that now? I still can't get in the White House door. They let Lavrov in, the Russian foreign minister, they let him in. I can't even get in the White House door. You think I'm going to go out now and admit to this scheme? I mean, anyone who's watched this president the last 3 years knows how vindictive he can be. Do you think it would be smart for the president of Ukraine to contradict the president of the United States so directly on an issue he's being impeached for? That would be the worst form of malpractice for the new president of Ukraine. We shouldn't be surprised he would deny it. We should be surprised if he were to admit it. Now, let me just end with a couple observations about Mr. Cipollone's comments. He says, this is no big deal. We're not talking about when we're going to have witnesses or if we're going to have witnesses. We're just talking about when. Just talking about when. As if, well, later they're going to say, oh, yes, well, we're happy to have the witnesses now. It's just a question of when. Okay. As my colleague said, let's be real. There will be no when. There will be no when. Do you think they're going to have an epiphany a few days from now and say, okay, we're ready for witnesses? No, no. Their goal is get you to say no now, get you to have the trial, and then argue, make it go away. Let's dismiss the whole thing. That's the plan. A vote to delay is a vote to deny. Let's make no mistake about that. They're not going to have an epiphany a few days from now and suddenly say, okay, the American people do deserve the answers. Their whole goal is that you'll never get to that point. You'll never get to that point. When they say when, they mean never. I yield back.
The majority leader is recognized.
I make a motion to table the amendment and ask for the ayes and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Heidsmith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Lankford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
Are there any senators in the chamber wishing to change his or her vote? If not, the yeas are 53 and the nays are 47. The amendment is tabled.
Mr. Chief Justice.
Mr. Majority Leader is recognized.
I would ask consent to ask the Democratic leader, since there's a certain similarity to all these amendments, whether he might be willing to enter into a consent agreement to stack these votes.
Without objection, the inquiry is permitted.
Thank you, Mr. Chief Justice. The bottom line is very simple. As has been clear to every senator and the country, we believe witnesses and documents are extremely important, and a compelling case has been made for them. We will have votes on all of those. We will also, the leader, without consulting us, made changes, a number of significant changes that significantly deviated from the 1999 Clinton resolution. We want to change those. So there will be a good number of votes. We are willing to do some of those votes tomorrow. There's no reason we have to do them all tonight and inconvenience the Senate and the Chief Justice. But we will not back off on getting votes on all of these amendments, which we regard as extremely significant and important to the country.
As I've said,
Consent was for a question.
As I've said repeatedly, all of these amendments under the resolution could be dealt with at the appropriate time. I suggest the absence of quorum.
The clerk will call the roll.
Mr. Alexander.